My lord. My lord. End of the list.
Lords, fresh matter
End
for
of the list, my lord.
2:30
My lord.
today, Lords.
End of the list.
I
your
had
lords.
moved it day before yesterday, Lords. Petitioner is a member of a syndicate. Today is the LIC committee constitution, Lords. My case is not being considered. Lords, the notification is already stayed in a connected matter. I have produced that copy also. They say, Lords, I should take a separate stay for consideration of myself.
My
It
lord.
is already.
My lord.
Your
End of
Honor,
the list. Your
I have-
lords. End of the list. One DRT matter, your lordship. ಮೊನ್ನೆ ಮೂವ್ ಮಾಡಿದ್ವಿ ಇವತ್ತು ಬಂದಿಲ್ಲ ಸರ್. ಹಾಗಾಗಿ ಒಂದು DRT matter, your lords. Position ತಗೊಂಡಿದ್ದಾರೆ. Winter season ಅಂತ ಹೇಳಿ. End of the list.
Your Honor, ನಾನು 8ನೇ ತಾರೀಕು ನಾನು ಮೂವ್ ಮಾಡಿದೆ. ನೋಟಿಸ್ ಎಲ್ಲ ಇಶ್ಯೂ ಮಾಡಿದ್ದೀನಿ. ಬಟ್ ಅದು 8ನೇ ತಾರೀಕು 9ನೇ ತಾರೀಕು ಬಂದು ತಮ್ಮನ್ನು ಕೇಳಿದಕ್ಕೆ ಇಲ್ಲ ತೆಗೆದುಕೊಡಿ ಕಳಿಸಿ ಅಂದ್ರು. ಅದು ಕೆಳಗಡೆ ಬರಲಿಲ್ಲ. ಮತ್ತೆ ನಾನು 10ನೇ ತಾರೀಕು ಒಂದು ಕೊಟ್ಟೆ. 10ನೇ ತಾರೀಕು 13ನೇ ತಾರೀಕು ಕೊಡಿ ಅಂದೆ. ಆಗ್ಲಿಲ್ಲ. 15ನೇ ತಾರೀಕು ಅಂತ ತಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ರ. ಇಲ್ಲ ಸ್ವಾಮೀಜಿ ಪೆಂಡಿಂಗು. ವೆರಿ ಅರ್ಜೆಂಟ್ ಕೇಸು ಎಲೆಕ್ಷನ್ದು ಇಂಪ್ಯೂಟ್ ಬಂದು ಹೋಗಿದೆ ಸರ್. ಅಲ್ಲಲ್ಲ ಈಗ ಈ ಆರ್ಗ್ಯುಮೆಂಟ್ ಬೇಕು ನನಗೆ. ಈಗ ಎಲೆಕ್ಷನ್ ಆಗತ್ತೆ ಹೇಳಿದೀನಿ ಸರ್. ಕೊಡಿ ತಗೊಳ್ಳಿ.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ. ಅಲ್ಲ ಡೇಟ್ ಮೇ ಬಿ ಸಬ್ಮಿಷನ್ ಮೇಲೆ ಅರ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಮಾರ್ಚ್ ಎಲ್ಲ ಹಾಕಿದ್ದೀನಿ. ಮಾರ್ಚ್ ಡೇಟ್ ಕೊಡಿ ಸ್ವಾಮಿ. ಅರ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿನಿ.
List number 1, fresh matter, serial number 1.
ಇವ್ರ ಅನಾರ್ 15ನೇ ತಾರೀಕು ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ರ ಸ್ವಾಮೀಜಿ. ಅವ್ರು ಹಾಕಿಲ್ಲ.
Your Lordship, for extending.
ಇವ್ರ
Your Lordship, for extension of interim order, Your Lordship. Extension of interim order. Tomorrow is the last day.
My lord, DRT matter, my lord. It's for settlement, my lord. Kindly post it for 2:30, my lord. For 2:30, my lord. Today.
My lord, matter for 2:30.
My lord, one submission, my lord. Its matter has been settled, my lord.
Number 1.
my lord. Covered matter, my lord. BWSS,
My
my lord.
Serial number 1.
Annexure G 47, my lord. Covered matter.
Yes.
BWSSP covered matter, my lord.
Huh?
Annexure G 47, page
Covered
number.
matter.
BWSSP, my lord.
Learned AGA takes notice for response number 1. Learned counsel Sri BL Sanjeev is requested to take notice for response number 2 and 3. Learned counsel for petitioners is directed to serve copies of the petition along with annexures on the learned counsels for the respondents. Release this matter
My lord, interim.
on 21st of January.
My lord, interim. Interim, my lord.
Here interim relay matter has to be disposed of.
Yeah.
Next week it will be disposed of. Yes.
Serial number 2.
Same, my lord.
Same.
Serial number 3. Mendes. AS Mendes.
Your Lordship, I'm appearing for the petitioner.
Yes.
I filed an IA for dispensation with the original bar certified copy. The
You can't seek dispensation of production of certified copy of the
position
order
notice,
which you are seeking, you are challenging.
it's a position notice.
You cannot seek.
The original was not at all handed over to us. The respondent bank came to affix the same on the wall of the petitioner here.
Ah.
So the photo of it was taken and printed and produced before this honorable court.
Yes.
Your Lordship,
make
the original is not available with the.
All right, you can make submissions on the interim prayer.
Yes, Your Lordship.
Yes.
So your Lordship, the petitioner had obtained a loan for rupees 15 lakhs. And on 14/11/2017, as per Annexure C, there was an insurance on the loan account.
5 lakhs 80,231.
No, Your Lordship, actually, this is the false amount claimed by them. If your Lordship looks at,
This court cannot go into all those aspects, madam. Go to the DRT.
Your Lordship, actually, they have used forged documents
Go to
to,
the DRT.
they've used forged documents, Your Lordship, and there is 75%.
Questions cannot be gone into before this court under 226.
Yes, Your Lordship.
The remedy available for you is before the DRT. Go there.
Your Lordship, the petitioner number 1 is 75% disabled. His disability certificate is produced at Annexure D.
Ah.
And illegally, they are already party to the consumer court case, which we have filed.
Ah.
And already the consumer court judgment has been passed, dated 16 it is an Annexure H, Your Lordship.
Ah.
So there already the insurance company was told to pay rupees 10 lakhs with interest
Ah.
at sorry, at annexure G or at annexure H itself, the insurance company was told to pay a sum of rupees 10 lakhs with interest of 9%. This would have covered the entire loan amount, but they have gone on appeal to the State Consumer Forum. So if they would have dispersed the amount, then we would have been able to pay to the respondent. And in the appeal, the respondent is also a party to the appeal. Yet they are proceeding to issue this notice based on forged documents, which the petitioner has not even signed and executed.
United India Insurance Company.
Yes, Your Lordship, they had insured the loan already. And
So your grievance was against the insurance company.
yes, and the decree is already done. They were supposed to pay 10 lakhs with 9% interest, which if they would have dispersed, the loan amount would have been cleared. And the respondent also is a party to this. Initially, as per Annexure G, Your Lordship, stay was already granted by the Consumer Court, asking the respondent not to proceed against this petitioners. And now it's gone on appeal, Your Lordship. Even the respondent is a party to this.
Yes.
The respondent themselves arranged for this insurance. They didn't proceed to go against the insurance company to recover the loan. They directly proceeded against us. There is a subsisting judgment, Your Lordship, of the Consumer Court, which already is supposed to make the insurance company pay the 10 lakhs amount to the petitioners, which the petitioners would have given to the respondent. But yet this respondent has issued this possession notice and they've come to directly affix it on the wall of the property of the petitioners. And in that notice, Your Lordship, which...
What is the grievance against the insurance company?
The insurance company has insured the loan, Your Lordship. So because of the 75% disability of the petitioner, the insurance company is supposed to give the amount of the loan. So 10 lakhs was already ordered.
They are supposed to give the loan.
Because the loan account was insured. The respondent itself arranged for this insurance. The premium was already debited. So the fall happened of the petitioner number 1, because of which he got 75% disability. So when the insurance company claim was made, they rejected. So we filed before the Consumer Court. Even the respondent is a party. Even the insurance company is a party.
Coverage of this policy.
The coverage of the policy, P1 was insured for 10 lakhs, P2 was insured for 5 lakhs. So entire 15 lakhs was insured.
Madam, these insurances are done in respect of the house, in respect of the property, not in respect of the persons.
There is a clause in that, Your Lordship, regarding death or disablement.
That has got nothing to do with the
But
loan
there
you
is
have taken.
there is a Consumer Court judgment, Your Lordship, where they have already, where the court has already granted 10 lakhs, but they have come on appeal now before the State Consumer
You are
Forum.
willing to pay 25% of the amount,
Yes, Your Lordship.
pass any interim order, otherwise I'll
Yes, Your
simply issue
Lordship.
notice, that's all.
The petitioners
Nothing more.
will comply with any conditions.
4 weeks time, we'll have to deposit 25%.
Yes, they will comply with the conditions, Your Lordship.
Issue notice to the respondent. Next para, learned counsel for the petitioners submits that the petitioners were aggrieved of the action of the United India Insurance Company Limited, which had insured the loan obtained by the petitioners from the respondent bank. Full stop. Consequently, the petitioners approached the District Consumer Disputes Redressal Forum in complaint number 239 of 2019. Full stop. The District Forum passed an order on 16th of September 2022, directing the insurance company to pay a sum of rupees 10 lakhs along with interest at 9% per annum from the date of the complaint till the date of the payment. Full stop. Nevertheless, the insurance company has gone up on appeal. Full stop. In the meanwhile, the respondents have proceeded to initiate action for non-payment of the EMIs. Full stop. Learned counsel submits that the petitioners are ready and willing to pay the outstanding amount, and they also anticipate that the award passed by the Consumer Forum will be executed and the petitioners will be able to repay at least rupees 15 lakhs to 20 lakhs from out of the said award amount. Full stop. In order to show the bona fides of the petitioners will deposit a reasonable amount with the respondent bank. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned possession notice dated 20/12/2024 at annexure A till the next date of hearing. Possession notice dated so and so and all further proceedings thereto till the next date of hearing, comma, subject to the petitioners depositing 25% of rupees 25 lakhs 80,231, comma, with the respondent bank, comma, within a period of 4 weeks from today. Full stop. Release this matter. On 18th of February.
Much obliged, your lordship.
Yes.
Still number 4.
Appearing-
Govind Kamath.
Appearing for the petitioners, my lords. Lord Senior has been briefed. Request for a short passover minutes.
Pass over.
Much obliged.
Still number 5.
So petitioner,
Mukesh.
Lord, the respondent number 1 has cancelled the tender allotted to the petitioner, my lord, for supply of VC units in the central jails.
Supply of
VC unit, video conferencing units in the central jail. My lord, the
cancelled.
But
Tender is cancelled.
cancelled
It was
and
allotted to you.
allotted to
It
me.
was cancelled.
It was cancelled and also, my lord, the forfeiture of bank guarantee is ordered. My lords, by order dated, your lordship may kindly see page annexure Q, page 37. My lords, I have given explanations and also indication that, my lords, the electrical wiring had to be done by the jail authorities, which I have specifically told them that it is not available. My lords, in spite of my explanations, my lords, without recording any reasons, my lords, tender is cancelled, number 1. Now, secondly, my lords,
In the agreement entered into later,
yes,
is there no arbitration clause?
there is an arbitration clause, but I am not heard in the matter.
So you'll have to
My lords,
invoke
I am not heard in the matter. Secondly, your lordship may kindly take page 41, annexure T. They pass a second order by the respondent number 2, who is not the competent, my lords. She has no jurisdiction at all. Page 41.
If there is an arbitration clause, any dispute arising out of the contract has to be settled only through arbitration.
My lords, I am on the question whether, my lords, I should have been heard in the matter. My lords, it is a state government, my lords, which has issued the tender contract.
Learned AG takes notice for both the respondents. Learned counsel for petitioner is directed to serve copies of the writ petition along with annexures on the learned AG. Full stop. Although, next para. Learned counsel for the petitioner seeks to submit that the petitioners are aggrieved of the cancellation
Annexure Q.
of the tender awarded to the petitioner and the blacklisting of the
There
petitioner
is no
company.
blacklist. There is no blacklisting. There is no blacklisting.
Then what is annexure T?
Well, annexure T is a second order passed on 6/1/25, giving detailed reasons as to why they have cancelled it. And the person who passed an order is subordinate to respondent number 1. She is not competent to pass any orders. Completely without jurisdiction.
But the first order is passed by the competent authority.
Yes. And second order, my lord, they supplement the reasons in the second order.
ಏನ್ ಹೇಳಿದೆ?
First order do not indicate any reasons at all.
And blacklisting ತೆಗೆದಾಕ್ಬಿಡಿ. And the fact that the second order at annexure T is issued by an incompetent authority. Nevertheless, learned AGA submits that the agreement entered into between the parties contains an arbitration clause, and any dispute that arises between the parties are to be resolved only through arbitration process. Clause 20. Full stop. Next para. Release this matter on 22nd, 21st of January. Full stop. Learned AGA is directed to secure instructions and make submissions.
Let's make one
Also,
request.
please come prepared
Yes.
to
please.
say whatever you want to say about this
Arbitration.
aspect of the matter, where there is
Make-
an arbitration clause.
I follow.
Yes.
My lords, may I make one request? My lords, of course, stay is not possible now. Let them not invoke bank guarantee, my lord. 3 crores money is
I've given a date for next week.
Lord,
Will you please
revoke-
come, we'll see.
revoke ಮಾಡಿದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
Huh?
Revoke ಮಾಡಿದ್ರೆ 3 ಕೋಟಿ ರೂಪಾಯಿ ಹೋಗ್ಬಿಡುತ್ತೆ. The units are already delivered to the jail authorities. Around 1 crore unit is lying with them, plus 3 crores
If
invocation.
you don't invoke the proper provision of the contract and seek remedy accordingly,
My lords, I'll argue
what
on
to
this.
do?
My lords, I'll argue. Let them not invoke till then, my lords.
Let us see.
Till number
Yes.
6, Rohit or Nayak. Kamath.
Milords, appearing for the petitioners, Milords, this is a matter that pertains to a tender that is called under the IBC. Milords, here, the aspect that has happened is there is a email that is sent on 30th December. Despite me being the successful bidder and having time till 90 days for making payment, on 30th December, there is an email that is sent by the official liquidator stating that my sale is, cancelled. Milords, there is also a subsequent document which I would like to place on record.
What, you are aggrieved of what?
Milords, there is an auction that is called under the IBC proceedings. Milords, when the IBC proceedings, there is a sale auction that is called for. The successful bidder has 90 days for making the payment of the entire amount. But however, before the expiry of within 75 days, he is actually, the sale is being cancelled. Milords, I would like to place on record certain additional documents for the benefit of the honorable court, please, Milords.
How is this petition maintainable?
Milords, the reason is because,
Respondent is not
In-
a financial institution.
Milords, indeed, Milords. Milords, here, the official liquidator,
Private entities.
Milords, they are exercising the powers under the statute, Milords.
Huh?
They're exercising a power under the statute, Milords. The
Ah.
jurisdiction is before the National Company Law Tribunal. But however, the NCLT is not in sitting, Milords.
Issue notice to the respondent.
Milords, and I would like to place on record an email that is,
Returnable by 29th of January.
Milords, kind indulgence here, Milords. The next auction that is called for is on 20th January, Milords.
Let us see.
Number
Yes,
7.
Milords, kind indulgence here,
Hold on.
Milords.
yes.
Appear for the petition.
Respondent. Undertake to file wakala may permit.
There is,
Respondent Piramal.
the due amount was around 95 lakhs.
Learned Counsel Shri
Yes, Lakshmi Narayan.
S. Lakshmi Narayan undertakes to appear for the respondent. Learned Counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the Learned Counsel for the respondent.
I'll deposit.
On
some-
date, my lord, it is 1 crore, 1,44,000 outstanding as on date.
But there is a medical tragedy in the family, my lords. The son of the petitioner, he is having sudden seizures and he is also suffering from calcific pancreatitis. And also he has developed acute viral
ಏನ್
hepatitis.
ಮಾಡಕ್ಕಾಗತ್ತಪ್ಪ? See,
Sir,
what can be
correct,
done?
my lords. And till date, they have paid almost around 1 crore 55 lakhs.
ಅದಲ್ಲ ಲೆಕ್ಕ.
ಅದಕ್ಕೆ
What is outstanding is more
outstanding
important.
as on date is 1
ನೀವ್ ಎಷ್ಟು
crore.
ಕಟ್ಟಿದೀರಾ ಅಂತಲ್ಲ.
1 crore ಇದೆ.
It's more than 1 crore. What can be done?
And
You will
around-
not be able to deposit also if we order. I don't think it's up to you.
We'll deposit around 20 lakhs, my lords, for around
No, sir.
1 crore ಇದೆ. 20 lakhs will
You
deposit.
go before the DRT, what will happen?
I understand, lords. Around 20 lakhs will deposit in
Minimum 20% you will have to deposit.
20 lakhs ಕಟ್ತಾರೆ.
And I'm sure you are not going to deposit,
Yeah.
even if you give 4 weeks time, you will not deposit.
ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಇದೆ ಮಾರ್ಬಿಟ್ಟು ಸೆಲ್ ಮಾಡಿ. Your lordship make
4 ವಾರದಲ್ಲಿ ಏನ್ರಿ ಆಗುತ್ತೆ? ಆಗೋದಿಲ್ಲ. I don't think.
your lordship will grant.
Please go to the DRT.
ಅಲ್ಲ 4 weeks time ಕೊಟ್ಬಿಟ್ಟು ನನಗೆ
Please go
ಡೆಪಾಸಿಟ್
to the DRT.
ಅಲ್ಲ your lordship may grant me 4 weeks time.
No, no.
Ask me to deposit.
No.
Impose terms and condition I will do it. If I don't comply, my lords, I will go before you. I will
Okay.
comply, my lords.
Next para. Learned Counsel for the petitioner submits that the petitioner will make arrangement for payment of a reasonable percentage of the amount outstanding. Although the petitioner is in great difficulty having regard to the medical condition of her son. Full stop. What is the immovable property mortgaged?
It is a house property. my lord.
House property
Dwelling
where they are
house.
residing.
Yes,
The petitioner is also residing in the residential premises which has been offered as collateral security to the respondent bank. Full stop. Next para. Consequently, the respondent bank is hereby directed not to precipitate the matter any further till the next date of hearing, comma, subject to the petitioner depositing 20% of ಎಲ್ಲಿ ಅದು amount?
ಅವ್ರದ್ದು section 13 proceedings ಅಲ್ಲಿ 95 lakhs ಇತ್ತು. 95 lakhs 62,375.
95 lakh 62,375 with the respondent bank, comma, within a period of 4 weeks from today. Full stop. If the directions issued by this court are not complied, the benefit of the interim order passed by this court shall not be continued in favor of the petitioner, and the petitioner will also run the risk of having the writ petition dismissed.
Grateful.
Release this matter on 18th of February.
Grateful.
8, Rajshekar S.
Yes.
Lords, annexure B may kindly be seen, my lords. Page 21, my lords. I am a gas distributor, my lords, HP gas distributor. Now, my lords, at the instance of the person who is, my lords, claiming to be another dealer, they have asked me to transfer, my lords, 16 Anganwadi centers, my lords, gas connections to the third party pursuant to annexure B.
Mukambika HP gas
ಹೌದು, I am
agency
the gas distributor.
Amulya gas agency
Agency transfer ಮಾಡಿ ಅಂತ. No reasons, nothing. That is contrary to the order passed by this honorable court in the connected earlier writ petition. Wherein, my lords, unless and until, my lords, consumers are, my lords, given an option before whom or with whom they want to, my lords, purchase the gas cylinders. My lords, that is pending adjudication for consideration before this honorable court as well. May I request my lords to kindly turn to page 29. My lords, I'm sorry, I have not produced the initial order, my lords. Kindly see page 29, the earlier order, my lords. Wherein, my lords, the
Karnataka State LPG
LPG
Association.
associations, they have approached this honorable court as against the directions issued so as to transfer the bulk transfer of, my lords, consumers to various other distributors. That has been stayed by this honorable court, and this writ petition is pending for consideration. And the matter is seized off by the honorable apex court as well, insofar as, my lords, bulk transfer of consumers are concerned. The three companies, the learned single judge of this honorable court has extracted the number of earlier, the SLP as well. Page 29. Lords, what the oil companies proposed to transfer, make bulk transfers of consumers to various other, my lords, distributors. Then, my lords, they have brought in some amendment that was under challenge, and Kerala High Court granted interim order. This honorable court has also granted interim order. As against that, my lords, some of them filed writ appeal. Writ appeal came to be dismissed, and as against that, my lords, SLP is filed. SLP is pending for adjudication. I have produced the copy of the order passed by the high courts, and also, my lords, the SLP also.
What? What right do you have to say, no, don't?
Consumers will have to give an option, my lords.
Anganwadi, you can't say is a consumer.
My lords,
It is
Anganwadi,
a government agency.
I can understand, my lords, if there is any allegation against me, and if
Sir, after all, they are consumers.
they are
They can
consumers.
do whatever they want.
No,
How can you say, no, don't do it?
they only give a letter saying that, my lords, your services are satisfactory. Avare letter ಕೊಡ್ತಾರೆ.
So what?
Now they say, my lords, you transfer it. May I request, my lords, to kindly turn to page 101, my
So
lords.
what right do you have, sir?
I don't have a,
Then-
my lords, except unless and until certain allegations are made.
Or when can a
Or-
mandamus be issued?
No, my lords, sir, now,
When can a mandamus be issued?
now I have
You
sought
will have
for,
to point out to a right
no, I have sought
going
for,
under
I have sought for setting
a
aside
provision
the,
of law
I have sought for setting aside the,
and a commensurate duty cast on the respondents.
my lords,
Only then a writ of mandamus can
yes,
be
my
issued.
lords, I have sought for the quashing of the communication as well.
Huh?
Annexure A and B.
Correct.
Okay.
What is your right?
Lords, sir, I am
There is no right with you
admittedly,
flowing from any provision of law,
my lord, sir.
unless you point out to such a right.
Yes, my lords.
Which will also automatically cast a duty on the respondents to follow the law. A writ of mandamus cannot be
My lords,
issued.
I can understand if may, that is why may I request my lords to kindly see who has made the representation. I can
Sir, you will have to
understand.
point out to a law, sir.
Yes, my lords.
You have to write,
Now-
show the right of yours.
My lords, now
No, no,
my,
no, they cannot do this. Madak barodil.
my lords, sir, that is what is the subject matter pending for consideration before the Honorable Apex Court now.
See, that is a matter between the oil
Company-
agency and the
company.
association. We
Lords.
are not concerned with that.
Kindly see, my lords, so who has addressed the letter, my lords? I can understand if third party, if the,
Sir, after all, they are consumers.
no, if I,
They
if-
have a right to do whatever they want.
my lords, if Anganwadi centers have requested for transfer, my lords, then right.
Sir, they are all government agencies.
My lord,
They are
that's what-
bound to follow the directions of the
Guidelines.
higher authorities. But you, for you to maintain this writ petition with this prayer, you will have to point out to a provision of law.
Now, my lords, my respectful submission is,
Barkule,
my lords, consumers can, my lords, approach the
DBA.
authorities, no doubt, my lords.
for all the respondents, for response number 1 to 3. For the time being, notice to respond number 4 is not issued. Since the learned counsel for the petitioner is required to point out to any provision of law which would entail the petitioner to make such a prayer before this court, seeking issuance of a writ of mandamus to the respondent authorities. Full stop. For that purpose, relist this matter on 21st of January. Please
May-
come, you
may-
point out, otherwise.
May I make
I'll
one,
dismiss
one
the writ
submission. I can understand, my lords, if consumers have approached the authority and made a request to
For
transfer,
issuance of a writ of mandamus, this is what is the requirement.
ma'am.
You please point,
please.
yes.
Serial number 9. Siri Rajshekar. Serial number 9.
Lords, 13-2 notice was issued at the first instance. If your lords were to take notes, page number 70. Notes,
13th of March 2024.
yes, this was challenged because it was a OD facility. We had serviced the interest. It was challenged at page number 72.
Hmm.
Notes, page number 74, they withdrew the notice. Paragraph number 3.
13-4 notice ಅಂತ ಬರೆದಿದ್ದಾರೆ ಇಲ್ಲಿ.
13, lords, it's a 13-3 notice. 13-2
13-2
notice,
na?
not section 13-2 notice, which
Ah.
was issued, was subject matter of challenge at page 72. It was permitted to withdraw.
Ah,
Let's kindly see the date of the order was on 17 December 24.
hmm.
Let's then at page 75, which is now impugned before your lordships,
Hmm.
they refer to a demand notice of 23/5/24, which is not issued at all. And they issue 13-4 proceedings. Lords, but all said and done, I am due to pay. Lords, this is a OD facility. I'll have to service the interest. Lords, 2.5 lakhs is the interest payable every month. I have defaulted for about 15 months as of today. Lords, I'll deposit 25% of 20% of the total entire amount due, which will be almost 3 times the interest which is required to be paid on this OD facility within a period of 4 weeks. I'm required to pay the money, but they have not followed the procedure.
According to you, what is the total EMI that is required?
Lords, this is a OD facility, my lords.
Ah,
OD facility, what
15
happens?
EMIs.
15 months interest. OD facility, the principal amount will
The
remain.
interest you have been paying.
Lords, OD facility, my lords, overdraft facility, how it works is that we will be given a period of 1 year. So I will have to pay the interest till a period of 1 year. Lords, if I satisfy the payment of interest for 1 year, which will be a little higher than the normal interest rates, they will again extend it for the next 1 year. Because ultimately what matters for the bank is the accrual of the interest for the amount which they would have lent. So because my property would have been there in the security, I would have serviced the interest. So OD facility will always be extended year on year based on my performance of payment of interest. Without default, if I don't, if I pay the interest periodically, then they will again extend it for a period of 1 year. Usually OD contracts will contain a clause that if no communication is there, it is deemed to have been extended on the same terms and conditions for the next year. That's how usually OD agreements will be drafted. But as things stands, my lords, I'm in a default for almost about 15 months of payment of interest. It was only on account of the earlier notice, not for any other reason. Within 4 weeks, I will pay 20% of the total amount due, which will be almost 3 times than the interest which will be overdue as of today.
Withdrawal of the previous writ petition
Yes, withdrawal of the notice in the previous writ
maybe
petition.
for some reason.
Lords, the reason why it was withdrawn was, number one, the amount was not properly mentioned. And number two, the interest was actually paid till that date. So they could not have treated the account as an NPA and issued the notice. These two things which we brought it to the notice of the court. Because to invoke the provisions of 13.2, there should have been a default for a period of 90 days, which was not there as on that date. So therefore, they have withdrawn the notice. But anyway, my lords, I am not standing on this. It's only to say that procedural aberrations in its place, I will deposit 20% of the total and amount due as of today within a period of 4 weeks. Let them not take precipitative action.
1,22,73,000.
Lordships. ಇವತ್ತೊಂದು 25 ಒಂದು 12 ಒಂದು 37 ಲಕ್ಷ ರೂಪಾಯಿ ಬರ್ಬೋದು. Total amount which I have to pay.
$37 lakhs.
37 lakhs.
You are ready to pay that.
I'll pay it within 4 weeks, my lords. One of the petitioners is serious and he is presently, my lords, in the hospital. So there is some difficulty for the next 2-3 weeks. Within 4 weeks, we'll make good the payment.
Issue notice to the respondent. Next, learned senior counsel, Shri D.R. Ravishankar, appearing for the petitioner, draws the attention of this court to a previous writ petition at annexure J in WP number 9720 of 2024, whereby on 17th of December 2024, the writ petition was permitted to be withdrawn
$30 lakhs. Yeah.
as having become infectious in view of the withdrawal of the notice issued under section 13(2) of the SARFAESI Act. Notice dated 13/3/2024, at the hands of the respondent bank. Full stop. However, in the impugned notice at annexure K dated 2/1/2025, reference is made to a demand notice issued under section 13(2) dated 23/5/2024. Which apparently did not find any mention in the previous writ petition. Full stop. This itself is sufficient ground for interference at this stage. Full stop. Nevertheless, learned senior counsel would further submit that the petitioners may be put on terms and the petitioners will comply with any such directions issued by this court. Full stop. Next para. Accordingly, there shall be an ad interim order of stay of the impugned notice dated 2/1/2025 at annexure K.
And also annexure L, my lords.
And all further proceedings thereto.
Please.
Till the next date of hearing, subject to the petitioners depositing
30 lakhs it comes, my lords. I calculated. It comes to 30 lakhs.
25%.
25%. 30 lakhs within a period of 4 weeks, I'll pay it.
25% of rupees 1,22,000 or 1,22,70,988 with the respondent bank within a period of 4 weeks from today is. Full stop. If the directions issued by this court are not complied, the petitioners the benefit of the interim order passed by this court shall not inure to the petitioner, and the petitioners will also run the risk of having the writ petition dismissed.
Please, my lords. Great.
So, release this matter on 18th of February.
Lots.
10. Samir Sharma.
For the petitioner, the medical
Friend has served
negligence
some
matter.
Huh?
15 other judgments, my lord. On 8-8-8-1, my lord, your lordship stated, go through 3 judgments, my lord, and make my submission. Thereafter, my lord, day before yesterday, my friend has again served 2 paper books.
Medical
Of-
negligence.
Please,
How
please,
the-
it came up last
He
week.
served 2 more paper books, my lord, of some other 15 judgments that he wants to rely on. Can I make my submissions, my lord, next week after looking through this?
Alappa, all that we wanted to know,
Please.
as to what are the procedures that are required to be followed in terms of the directions, in terms of the law laid down by the Honorable Supreme Court,
Yes,
where a written complaint is given to the police
yes, sir.
in the matter of medical negligence.
Yes, sir.
Because nothing much can be done by the police.
Yes, sir.
So therefore, what I had requested you to is to go through all those judgments and say
Yes, sir.
whether under these circumstances, they were directed to file a private complaint.
Please.
So that the court will take the process further and the police will act in terms of the directions of the magistrate. That is what I wanted to know.
Please. My lord,
Huh?
directions of this court, my lord, were to conduct a preliminary inquiry. We have written to the Victoria Hospital.
Today,
How?
what is the procedure in terms of the law laid down by the Honorable Supreme Court? That is what I wanted to know. If the intention is very clear that even though you file a complaint before the police will not be able to do much. So therefore you go file a private complaint before the magistrate and the police will act in terms of the directions of the magistrate.
Please.
And what are the directions that are required to be given by the magistrate is also indicated by the Supreme Court. Then they will have to go file a private complaint.
That is what they'll have to do. Initially, what we have done is,
I wanted to know, is this what is flowing from the orders of the Honorable Supreme Court?
my friend had served me few more judgments, my lord, yesterday. I thought I'll go through those also and then make my submissions. Lordship may have it on Monday, my lord, I'll make my.
At the request of the learned AGA, release this matter on 20th of January.
Great.
I'm grateful.
11. Chita DJ.
For the second respondent.
Petitioner is the company. We are in pursuance of the notification for a tender, we participated as per annexure A. The present petition, my lord, I question the correctness of the tender condition. May I request, my lord, page 22.
An autonomous
If I-
institute of Government of Karnataka.
Yes. So let me kindly, the condition number 9, I question the tender condition, that is at page 25. ma'am. That is a presentation, the marks that has been allocated. Presentation by the firm on the work, that is a manpower agency and also.
Page number?
Page number 25, ma'am, 25. So Lakshmi, may I request, that is a column 9. Yes, presentation, PPT, that is it. Presentation by the firm on the work to be done. Number clause A, work plan methodology with the value addition, chemicals, machinery, manpower with a cleaning plan of 15 marks. B, worker retention and incentive plan, 5 marks. That is C, contingency plan, 5 marks. Note, presentation should be limited to 30 minutes. This is a, so far the the evaluation is concerned, both technical as per the financial bid. Ultimately, may I request, my lord, for a minute, kindly for a 26, kindly, page 26 may be kindly be seen, ma'am. Financial bid evaluation, just I'll the below. The bidder's ranking shall be arranged depending on the work marks obtained by each of the bidder, both in technical evaluation and financial evaluation. the bidder meeting the minimum eligibility criteria and with the highest marks, that is on total technical evaluation mark and financial evaluation, shall be deemed as a successful bidder and shall be considered eligible L1 bidder for the process. Now, in this matter, they also filed the objection. This honorable court on 2210 passed the order subject to the decision of the court. Now, what the 2210, my lord. Subject to order of the 2210. This honorable court passed the order and the pleadings are completed.
Yeah, what is your grievance?
Now, my grievance is this, my lord. In fact, the second respondent is 25 marks.
Huh?
You have the power to allocate the entire mark by way of presentation PPT.
Yes.
Suppose virtually the object of the PP, that is the Karnataka Transparency Act, will be defeated. Just to favor, assuming for a moment, even all that your lordship may kindly appreciate, Annexure C may be kindly for a minute. My request or any other criteria, the same marks of 25 marks to be allocated. I am not the purpose is here, my lord. The object of the Karnataka Transparency Act, that is the whole ultimately, my lord, the second respondent has to favor some agency or to favor some A or B. If they give say more, assuming for a moment, I secures in all other headings, so I secure say marks. Still, the 25 marks which is been the proverse second respondent, ultimately their decision-making authority here, as per the tender conditions, decision-making authority to the presentation will be by director come in on the aspects of defined in the criteria. Ultimately, decision.
Sir, please point out if there can be any arbitrariness
Yes, exactly.
while considering this one.
The ultimate decision of the apex court is, so let me kindly appreciate what I try to put in the page 25, but the relevant paragraph, so let me kindly appreciate. Madam. Page number, internal page, paragraph 24, Mila. When tenders are invited, the terms and conditions must indicate with a legal certainty, so Lakshmi, and norms and the benchmarks.
Correct.
This legal certainty is an important aspect of the rule of law. If there is a vagueness or subjectivity in the said norms, it may result in the unequal and discriminatory treatment. It may violate the doctrine of level playing field.
Correct.
That the second part. In the case of
That is why I am asking you this question.
by fact,
Having regard to this condition number
yes,
9,
exactly.
is there any possibility
Yes, exactly.
of the authority
Yes, sir.
acting arbitrarily?
Yes.
Not possible.
No.
For each aspect, they have said, if you fulfill this much marks will be given. Everything is
No.
clear cut.
No, you are not
In the presentation, if you show the work plan methodology with the value addition, cleaning plan, 15 marks will be awarded. If you show how the worker retention incentive plan is provided for, 5 marks will be awarded. If there is a contingency plan clearly shown, 5 marks will be awarded. Where is the question of arbitrariness?
The entire allocation is concerned, PPT presentation is concerned. My apprehension, the reason is this, arbitrary. Suppose, assuming on other different headings, if I succeed, I am eligible. These 25 marks, ultimately the second respondent is the authority. They may have their choice.
No, there is no choice left to them. If you fulfill this requirement, this much marks will be awarded. Everything is clear. There is no scope for arbitrariness here. It is not possible.
Ultimately, my lord, the other
ಈಗ senior counsels interview ಹೋಗ್ತಿರಲ್ಲ ನೀವು
like
ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ, if you have publications, this much marks. If you have put this much of service as an advocate, this much marks. Anta ಏನು they have given the criteria, same principles are followed here. There is no scope for arbitrariness.
Your lordship is right, so far as specifications are concerned. May I request my lord, Annexure C may be kindly with you.
Sir,
What I contended with, my lord.
will permit them to proceed and
My lord,
declare the
Lord, may I
results.
make submission, my lord.
Yes.
My lord, this petition itself, my lord, is
You have
already
given a
covered.
presentation?
I give a reference.
All right. Let
Let
My lord,
them consider
already, my lord,
presentation.
in my statement
Let
of
us consider the
objections,
annexure C.
my lord, the
And-
same
and-
petitioner, my lord, same petitioner had already filed a writ petition the
No.
previous year and have filed the statement of objection R1 with this very same ground he had taken.
No, that is
And
not the
the
same.
honorable, this honorable court, my lord, coordinate bench, along with my statement of objection, page 19.
I will not suppress it. That is my stated in my petition parallel.
Really, the very same condition,
No,
There is
no,
that-
the condition
When
is
did you
statement
different.
of
file the-
objections.
But
Statement
you know,
of
statement of objection is the notary.
Para 11 may be kindly seen. In my petition itself, I
Federal illa.
stated, the conditions are different.
Idರಲ್ಲಿ ಇಲ್ಲ. When did you file?
My lord, it is filed on 6th December, my lord.
Huh?
6th December I had filed, my lord.
6th December.
Please, my lord. Page number 19 is the judgment. Para number 6. Page number 19, my lord, is the judgment.
Yes.
Otherly, para number 6, 7 and 10, my lord.
Yes.
The very same contentions, my lord. Between the same parties, the same petitioner.
Hmm.
Your Lordship kindly appreciate. So
This
far
judgment
the-
copy was not produced along with the writ petition by the petitioner, my lord.
You
The
have-
very same conditions in the previous writ petition also, same grounds
May
urged
I
once again.
request the para 11 of my writ petition, it is pertaining to state that in a similar circumstance, the petitioner herein had challenged the earlier tender notification issued by the same respondent, challenging the condition WP 7894 of 2012. However, the same came to be dismissed. However, it is not pertinent to state that in the present petition, the petitioner challenged the condition clause 9. The petitioner is herein seeking allotting the 25 marks to other criteria instead of PPT
The
presentation. And
notification
the same
itself,
is requested. That is
The
my, in the my
notification-
para 11 of my writ petition, I categorically that has been pleaded. And also what my annexure C is, you will ask my kind, that's why I request my lord to, for a annexure C may be kindly be seen. Here the same 25 marks or any other, assuming for an argument, as per tender conditions, that is the turnover of the company or a scale size of the operation, experience, number of years existence, and manpower on role, quality, focus and capability, value of machineries and other equipment in hand, or any other criteria. That is my, in fact, my representation specifically says in a pre-bid meeting, they are specifically pleaded. This should not ultimately, my lord, that is in the hands of the second respondent to decide. The object of the act will be defeated and then there is a transparency in the fact. If there is assuming for an argument, the entire 25 marks to favor a certain agency, if they allocate.
There is
Certain-
already a declaration made by this court
No,
that
no.
no arbitrariness can be
Why-
found in clause, condition number 9.
Yeah, 25 same marks may be allocated to any other headings, my lord. What my present petition is, your last may
No, no,
kindly the same. my
You have suffered a similar order
Okay.
in respect of the same condition
Earlier writ petition,
and you are not challenged it.
in fact, my lord.
There is a finding.
that is
You
in
please
fact,
see.
The same in a similar.
Pause, please come to paragraph number 10.
Hello, I do agree with your lordship. There is no quarrel of, so far the.
So once there is a declaration made by this court in respect of the same conditions, that they are not arbitrary, how can you challenge it once again?
Same condition illa.
Nodi, David,
No, no,
Nodi.
I'll request
Please
this.
see.
Earlier, the condition was different.
Yes,
You-
same conditions.
The earlier condition was totally different.
Please come to,
Challenge, you are kindly appreciate, my lord.
type.
Presentation by the firm on the work to be done here.
Same
Yeah,
work plan,
is-
methodology, manpower, cleaning plan, same.
But ultimately, my lord, here, what we pleaded here is same 25 marks to be given to
ಹಂಗ್
any
ಮಾಡಕ್
other,
ಬರಲ್ಲ.
any other.
We
criteria.
can't issue such direct.
Any other criteria, that's all my submission. In fact, your lordship, kindly, one more point for your lordship consideration is, when the same medical college, the annexure B may be kindly be seen. What I tried to pursue, my lord, is here, annexure B may be kindly be seen, my lord. Page number, the same tender notification is by another medical college, there is no such condition, sir. Your lordship kindly appreciate, 108.
We can't direct them, you follow the same procedure. ಹಂಗ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
Ultimately, the department is one of the.
All that you are required to do
Paying
is
and
give a presentation.
ultimately, my lord.
And in the presentation, these are the criteria there which are required to be shown.
Participated. my lord.
If you show that, marks will be given to
He
you.
has already participated.
You are assuming for a moment of an argument say, if I am secure in all headings and all marks, 25 marks is not easy.
Why you will not secure if you have all the capacity with you, you will show it in your presentation. This is what we intend to do anbuttu. How you are going to keep the hospital premise clean?
The power and ultimately.
What is the manpower that you have?
My concern is what the power to allocate the mark. Ultimately, West with the second respondent.
Ali ivaga, see, once you have challenged the same condition and this court has already upheld that condition, you will not be able to will not be permitted to re-agitate the same. Barkal.
One may make some, I
Yes.
may not pursue it. I lost my party, maybe have it tomorrow, I withdraw it. If such is the case to pursue before they are starting. Anyway, there is a provision under section 16 to go in appeal. I will advise the party to go in appeal. If such.
Learned counsel for the second respondent points out in the statement of objections filed at the answer of the second respondent that earlier the petitioner had filed a similar writ petition in WP number 7894 of 2022, being aggrieved of conditions number 7 and 9 as found in the impugned tender notification. Full stop. This court has considered such contention and has held that conditions number 7 and 9 are not unreasonable nor arbitrary. Full stop. Next para. At this juncture, learned senior counsel appearing for the petitioners submits that the matter may be taken up tomorrow. He will secure instructions from the petitioners. Full stop. Release this matter tomorrow.
Right.
Lord, I appear for the petitioner's
Where
counsel.
came?
Before the learned senior could start, my lord, in this matter, the learned AAG is appearing in this matter. Lord. He's on leave today. He has requested if he can be accommodated tomorrow, day after, whichever is convenient to the senior counsel.
Your lordship's hands.
Huh?
I mean, your lordship's hands.
Anu Prakash is
AAG, learned AGA submits that the learned AAG is unable to appear before the court today for personal reasons and therefore requests for a short accommodation. Full stop. Release this matter. You want it on Friday?
Monday ಆಗ್ಬೋದಾ ಫ್ರೈಡೆಗೆ ಯಾಕಂದ್ರೆ ಪರ್ಮಿಟೇಷನ್
Monday.
ಕಾಂಬಿನೇಷನ್ ಎಲ್ಲ ಚೇಂಜ್ ಆಗ್ತಾ ಇರುತ್ತೆ
ಆಯ್ತು 20th of January, Monday.
Grateful.
ಇನ್ನೆರಡು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಮೇ ಬಿ ಅಲೌಡ್ ಅಂಡ್ ದೆನ್ they can file their objections.
Yes.
There are two other matters connected with them.
Sorry, 12.2
One and-
IA for amendment of it.
Amendment may be allowed, my lord, because subsequently, my lord, they issued an order. Initially, my lord, they had not issued an order for, my lord, rejecting our sanction, request for sanction. So we have, my lord, challenged that. Amendment may be allowed and then they can file their objection
Yes, sir.
to the main petition.
We'll file.
ಅದಕ್ಕೆ ಮುಂಚೆ order on IA number 1 of 2024 in 12.1, 12.2.
Please.
Learned senior counsel Shri Uday Hulla appearing for the petitioner submits that this application was required to be filed having regard to the subsequent developments where the respondents have passed one more order assigning reasons for
Saying reason, rejecting the prayer for, my lord, sanction.
and now containing reasons.
No reasons also. Adrallu reason illa.
Ilva?
Rejecting the prayer,
Rejecting the
prayer for sanction.
request made by the
Request.
petitioner.
Yes.
Full stop. Next para. Accepting the submission made by the learned senior counsel, the interlocutory application is allowed. Please. The petitioner is permitted to amend the writ petition accordingly.
Please.
And furnish amended writ petition by the next date of hearing.
Please.
Yes.
Thirteen. Prithviraj BN.
Petitioner is an agriculturist, having 3 acres of land in Kuntur Taluk, within the 10 kilometers radius of Withdrawal reserve forest. His crops are being destroyed from the monkeys staying from the nearby forest. He has approached DCF, RFO, they orally say that they will take action. But from past 4 to 5 years,
Auren madakagutte. What can they do?
wild animals staying from the forest and destroying crops.
Monkeys,
Yes, madam.
they are here even in the cities. What can they do?
Some direction. from
Adu
the-
forest, you are hardly few kilometers away from the forest.
10 within 10 kilometers.
ಅದೇ
radius of,
ಅವ್ರು ಏನೇ ಮಾಡಿದ್ರು ವಾಪಸ್ ಬಂದೇ ಬರ್ತಾವ.
Nobody is.
What is
taking-
it that they can do?
He's facing problem from 4 to 5 years. Tender coconuts are being destroyed.
ಗೊತ್ತಾಯ್ತು.
For yield of,
ಈಗ ಏನ್ ಮಾಡ ನಮ್ಮ ಫಾರೆಸ್ಟ್ ಅಫಿಷಿಯಲ್ಸ್ ಅವ್ರೇನಾದ್ರು ತೊಂದರೆ ಕೊಟ್ಟಿದ್ರೆ ವಿ ಕ್ಯಾನ್ ಸೇ ಸಮಥಿಂಗ್. If the monkeys are coming and giving you trouble, what is it that you expect from the department?
Is to take up my case, consider my representation.
And do what?
Annexure D and E.
And do what? ಏನ್ ಮಾಡ್ಬೇಕು?
Appropriate measures may be taken.
ಏನು
to
ದಯವಿಟ್ಟು ಹೇಳಿ.
to drive away the monkeys. to
ಅದೇ
force the monkeys and
they'll
leave
have to
the-
drive away into the forest.
Yes, ma'am.
Again they will come back.
ಅದು ಇವ್ರು
There cannot be any fencing.
ಫೆನ್ಸಿಂಗ್ ಫಾರ್ ಅನಿಮಲ್ಸ್ ಇದೆ ಏನು ಎಲಿಫೆಂಟ್ಸ್ ಗೆಲ್ಲ ಎರೆಕ್ಟೆಡ್
ಆಯ್ತು.
ಬಿಗ್
ಇವಾಗ ಏನು ಈಗ ಕೋತಿಗಳಿಗೆ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ನಾಟ್ ಇವನ್ ಒನ್ ಅಟೆಂಪ್ಟೆಡ್ ಟು
No, see, if it is a futile exercise, courts are not going to issue directions. You will have to tell the court what is it that can be done.
they can poach the monkeys and leave it.
They will come back.
They may not come back, my lord. It is
ಹಂಗೆಲ್ಲ ಮಾಡಕ್ ಬರಲ್ಲಪ್ಪ. ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದೀರ ಆಗ್ಲೇ?
ಇಲ್ಲ.
ನೋಟಿಸ್ ತಗೊಂಡು. Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve copies of the writ petition along with annexures on the learned AGA. Full stop. Next para. The grievance of the petitioner is that monkeys are causing harm to the crops grown by the petitioner, more particularly coconut, which are grown in 21 trees, arecanut in 18 trees. Full stop. Prima facie, it appears that the respondent officials will not be able to help the petitioner in any manner, having regard to the fact that the property belonging to the petitioner is in a close proximity to the forest area. Full stop. Next para. Nevertheless, learned AGA is directed to secure instructions and make submission. Release this matter on 21st of January.
14.
I appear for respondent number 2.
2023, my lord.
Because I have one submission to make. On 18/12/2024, I have filed my statement of objections. On the very same date, my lord, they have served me additional statement of facts. So I'll seek some time to file my reply to that additional statement of facts on 18/12.
Lords, I have no difficulty on that, Lords. I have only one submission to make. There is a, my lords, why I'm saying this is because I don't want him to take time again. And my lords, what happens is in 2023, I'm awarded a contract for supply of cow mats. That contract is starting at cow mats for the cows to stand on, my lords, by Hassan Milk Federation. That is, my lords, terminated, saying that the supply of mats is not correct, is not as per specification. Thereafter, my lords, I come before this honorable court challenging the termination. Interim order is initially passed, staying all further tender proceedings because I had called for fresh tender. Then, my lords, interim order is modified, directing me to participate in the tender, fresh tender called by them. They don't allow me to participate. Then, my lords, they file an IFR modification saying, no, we never made that concession before the court. That IFR modification is rejected. Thereafter, my lords, that tender which they called, that is cancelled. Second, this is the third tender which is. In the third tender, my lords, my grievance why I had come before my lords was that they had rejected me without giving any reasons. That was my entire grievance. Now, in 18/12, they filed a statement of objections. In the statement of objections, they have taken a contention that they referred the sample mat which I have given to a specialist agency. That agency has said that it is not correct, etc. But I have one instruction say that report, whatever has been given, subsequently been withdrawn. That is first submission. Second submission, my lords, why I'm saying is he can take instructions on that because next date then we can finish the matter. Second submission, my lords, is that under the tender conditions, there is no permission or there is no mention that they will refer it to a technical committee. So therefore, the reference to a technical consultant falls foul of the KTP Pact. There's a division bench judgment of this honorable court on that issue. My lords, I'm only saying it so that next date of hearing my learned friend can.
Well, because all these submissions, my lord, is based on the additional statement of facts that
It is not based on the additional statement of facts.
Because
additional statements of facts was filed even before I received a copy of a statement of objections.
No. My lord, I filed in court and thereafter, my lord, while coming out of the court, they served me the additional statement.
My lords,
it is much more than the writ petition itself.
My lords,
that is why I need time to file object.
It was filed on 7/10. Kindly see, it was filed on 7th of December. My additional statement of facts was.
Request of learned counsel for respondent number 2, release this matter on 21st of January.
Can it be on 23rd, my lords? 23rd.
All right.
23rd. Obliged.
Mohana Chandra P.
He undertakes to file power for this third respondent.
So this is that matter where explosive NOC was rejected by the district magistrate. So that is renewal, no, this is only with regard to. Feel like only.
Yes.
My lord, the distance between the place, your lordship kindly see the table. Explosive Act rules are table distance. Distance between magazine store distance. Last time your lord distance is required. The explosive rules.
You have not pointed out any provision of law.
Provision regard distance.
Yes.
Under explosive rules, table 1. Table 1 ಅಲ್ಲಿ explosive rules ಅಲ್ಲಿ.
Eಲ್ಲಿದೆ? Where are the rules?
Explosive rules ಇಲ್ಲಿ.
Page number.
Page number 233. Schedule 8, table of safety distances. Schedule 8. Table 1 ಅಲ್ಲಿ 20,000 ಅಂತ ಉಂಟು 20,000 ಕೆಳಗಡೆ
ಹ್ಮ್
20,000
ಹ್ಮ್
ಅದಕ್ಕೆ ಡಿಸ್ಟೆನ್ಸ್ 605
ಏನದು ವಾಟ್ ಇಸ್
ಡಿಸ್ಟೆನ್ಸ್ ರಿಕ್ವೈರ್ಡ್ ಮೇಲ್ಗಡೆ ಬರ್ದಿದ್ದಾರೆ
ಕ್ವಾಂಟಿಟಿ ಇನ್ ಕಿಲೋಗ್ರಾಮ್ಸ್
ಟೇಬಲ್ ಆಫ್ ಸೇಫ್ಟಿ ಡಿಸ್ಟೆನ್ಸ್ ಇನ್ ಮೀಟರ್ಸ್ ಫಾರ್ ಮ್ಯಾನುಫ್ಯಾಕ್ಚರಿಂಗ್ ಫ್ಯಾಕ್ಟರಿ ಮ್ಯಾಗಝೀನ್ ಆಫ್ ಸೇಫ್ಟಿ ZZ
ಮ್ಯಾನುಫ್ಯಾಕ್ಚರಿಂಗ್
ಮ್ಯಾನುಫ್ಯಾಕ್ಚರಿಂಗ್ ಇನ್ಕ್ಲೂಡಿಂಗ್ ಸ್ಟೋರೇಜ್ ಆಲ್ಸೋ
ಸ್ಟೋರೇಜ್ ಬರಲ್ಲ ಇದು
Storage ಇಲ್ಲ.
ಸ್ಟೋರೇಜ್ ಬರಲ್ಲ ಇದು ಯು
ಅಲ್ಲಿ-
ಕಾಂಟ್ ಮೇಕ್ ಇಟ್ ಅಪ್ಲಿಕಬಲ್ ಫಾರ್ ಸ್ಟೋರೇಜ್
ಫಾರ್ ಪೊಸಿಷನ್ ಆಲ್ಸೋ ಪೊಸಿಷನ್
ನೋ ನೋ
There's no word used. It very clearly says for manufacturing.
can't read in something which is not provided for. ನೀವು you have produced at ink page number 13
ಹ್ಮ್.
ನಿಮ್ಮ petition ಅಲ್ಲಿ
ಹ್ಮ್.
form DE1
ಹ್ಮ್.
ಅದರಲ್ಲಿ
ಹ್ಮ್.
outside safety distance from dwelling house 650 meters.
ಹ್ಮ್.
This is what you have produced.
ಎಸ್
Huh?
ಹ್ಮ್.
You are a dwelling house.
ಎಸ್
Huh?
ಬಿಕಾಸ್ ವಿದ್ ಅಷ್ಟು ಡಿಸ್ಟೆನ್ಸ್ ಬೇಕಾ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅದಕ್ಕೆ
50,
yes.
650 meters.
ಎಸ್
Huh?
Huh.
What is the distance?
ಡಿಸ್ಟೆನ್ಸ್ ನಾವು ಇಸ್ ಬಿಲೋ ಲೆಸ್ ದೆನ್ 500
Less than?
500
From where do you get that?
because Google map.
My lord, the district magistrate as per the act, my lord, is the authority only to issue NOC, not the license. The licensing authority is the Union of India, the controller of thing.
Huh?
We are just a no objection issuing authority, your lordship. The
No objection ಕೊಡುವಾಗ
district- we have to
you
be
will
heard.
have to find out all these
We
things.
have given an opportunity. He has appeared before us.
ಅದಲ್ಲ. If any dwelling house is there within 650 meters, and if it is found that any dwelling house is there, then that can be reason to say, no,
No, yes. sir.
NOC
Then
cannot
there is
be
a public objection because as for the act itself, it provides for a public objection. So
Sorry.
at best, what could be done, my lord? This
Ah.
matter could be relegated back to the district magistrate
Ah.
to give him an opportunity to be heard.
Hmm.
Let them consider the distance accordingly. Because before this court, by virtue of a Google map, my lord, in 226, an order
Sir,
cannot be passed.
Rule 113.
113 regarding format, annexure A.
That are the
For
documents that
submission
are issued.
application for NOC.
103 is relevant.
Rule 103 na.
103 ನಲ್ಲಿ 103A for verification of the public interest, the lordship has got it. The lordship has the same page 62. Procedure to be observed for issue of no objection certificate. Adರಲ್ಲಿ A, after 1, 2 and 3A, 3A ನಲ್ಲಿ
Hmm.
for verification of the public interest of the district magistrate shall forthwith cause a notice to be published calling upon the public to submit objections if any, with reasons there are within a period of 1 month from the date of publication of the notice, and specify the date, time, so and so, where the site of the proposed premise lies within 15 kilometers of the limits of the jurisdiction of any town planning municipal authority or a port, airport. This will not applicable for a dwelling house. This is for a port or a satellite station. Thereafter, your lordship, the district magistrate shall cause the notice to be served on such authority or establishment. The day of hearing for consideration of objection shall be fixed as early as possible for the expiration of a period of 1 month from the date of the publication of notice. The district magistrate shall call the person or persons raising objection, also the applicant giving not less than 7 clear days of notice on the fixed day of hearing. Then the adjourn from time to time, and the district magistrate shall hear any objection relating to the purpose of no objection certificate and shall make an inquiry as he may deem necessary to assess justification of such objection.
No such inquiry was conducted in this case.
No, but he has appeared before the magistrate. Magistrate has
Mere
passed.
appearance, there is no, the impugner, there is no regarding.
Page 22, my lordship, that's a proceedings that was held before the deputy commissioner, where he is a party. He himself has filed an application. He is an appellant there. He has not raised that issue of distance there.
Your lordship kindly see page number 21 of my objection. I have raised contention. Same was not taken by the district magistrate.
This is only storing, is it?
Please.
Storage.
Only storing.
Storing. It's not a manufacturing plant. Since there are a lot of quarrying activities near that place, my lord, under that circumstance, my lord, the DC has permitted me to.
This is a storage of explosives
Storage of
for
explosives,
blasting.
that's all.
Who are you?
I am.
What are you doing with this?
Lord, I'm storing the explosive substances.
For what?
For
Rock blasting.
rock blasting.
So which means, what is the activity that you're doing?
Lord, only storing the explosives, that's all.
ಅರೆ ಬರೀ ಸುಮ್ನೆ ಯಾಕೆ ಸ್ಟೋರ್ ಮಾಡ್ತೀರಾ?
Transportation and storage, my lord.
For what purpose?
For blasting of rocks.
Who is doing the blasting activity?
Lord, near the vicinity, my lord, there are a lot of quarrying activities.
ಹಾ,
But there are granites and crushers near
ಆಯ್ತು.
the vicinity, my lord.
ಸರಿ.
Under that circumstance,
ಹಾ.
my lord, I was constrained to
No, they
seek
buy-
NOC from the deputy commissioner.
ನೀವ್ ಯಾಕೆ ಸ್ಟೋರ್ ಮಾಡ್ತಾ ಇದೀರಾ ಅಂತ?
In order to sell it to the
To sell it to the
Ah,
quarry
so
owners.
you are selling it to the
Quarry owners.
persons who are carrying out this activity.
Quarry
Please.
owners. He, if your lordship, he stores detonators and
Ah.
magazines.
So you are not doing anything except storing
Yes.
and selling.
Please.
See, you are still not able to point out to a provision, sir.
ಅಲ್ಲ, 605.
All this is pertaining only to manufacturers. Please see,
Exactly.
please see rule 113.
130.
Ella in respect of manufacturing only.
130 regarding submission application format. It is a only format.
License to possess and sale from a shop at any one time not exceeding 25 kilograms. So if you have that rule with you, ide book,
See,
Law and Justice, same book? You have the same book? Or nimd bere professional? See, idu table, ಅಲ್ಲ rule 113 ತೆಗಿರಿ. Rule 113 ಅಲ್ಲಿ column number 14. If you have the same book, then it is page number 85.
column number.
Column number 14.
Page number 75.
ಸಿಕ್ತಾ?
ಸಿಕ್ಕಿತು.
Please ನೋಡಿ ಅಲ್ಲಿ. License to possess and sale
Of-
from a shop
Hmm.
at any one time not exceeding 25 kilograms of small arms nitro compound.
ಇದು ಜಾಸ್ತಿ ಉಂಟು ಅದಕ್ಕಿಂತ 20,000 ನೈಟ್ರೇಟ್ ಅಂತೇಳಿ.
There is
Your lordship
storage.
kindly see the page number annexure A ಕೆಳಗಡೆ ನೈಟ್ರೇಟ್ ಮಿಕ್ಸ್ಚರ್ ಇದು ಅಂದ್ರೆ ಬೇರೆ ಬೇರೆ ಇದು ಉಂಟು, ಅದು ಇದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಉಂಟು ಕೀ.
So ಇನ್ನು ಜಾಸ್ತಿ ಇದ್ರೆ ಇನ್ನು ಕೆಳಗಡೆ ಇದೆ.
ಇದಕ್ಕೆ ಪೊಸಿಷನ್ ಬೇರೆ ಯಾವ್ದು ಇಲ್ಲ ಅದರಲ್ಲಿ, ಅದಕ್ಕಾಗಿ ಈ ಫಾರ್ಮೆಟ್
ನೋಡ್ರಿ ಪ್ಲೀಸ್ ನೋಡ್ರಿ ದಯವಿಟ್ಟು 15 ಅಲ್ಲಿ 100 kilograms ಇದೆ, ಆಮೇಲೆ 16 ಅಲ್ಲಿ 2000 ನಾಟ್ ಎಕ್ಸೀಡಿಂಗ್ 2000 ನಂಬರ್ಸ್ ಅದ್ ಬರೋದಿಲ್ಲ ಹಂಗಾದ್ರೆ 15 ಬರುತ್ತೆ ಹಂಗಾದ್ರೆ ಇಲ್ಲಿ ಡಿಪೆಂಡಿಂಗ್ ಆನ್ ದಿ kilograms of
The
what you're
explosive.
going to store.
Malad,
It's either 14 or 15.
14 is for a shop. Your
ಹೌದು
lordship. Shop.
ಇವ್ರು ಶಾಪೇ ಇವರು.
ಇಲ್ಲ shop ಇಲ್ಲ. That's a storage.
Godown, storage godown.
He will not sell. It's a godown.
ಹೋದ್ರಿ
How's
please read that.
A license for manufacturing fireworks,
ಅಲ್ಲ 14 ಹೋದ್ರಿ
75. License to possess and sale from a shop at one time, not exceeding 100 kilograms of manufactured fireworks of class 7, division 2, subclass 2, and 500 kilograms of torsa, crackers or sparklers. So this is only for fire crackers,
ಹಾ
firecrackers.
ಯಾವ್ದು ಓದ್ತಾ ಇದೀರಾ ನೀವು?
14. License to possess and sale from shop at any one time, it's not exceeding
ಇಲ್ಲ
25
in
small
my
arms.
book it says license to possess and
Yes,
sale
yes, ma'am. Yes, ma'am.
from a
Fine.
shop at any one time, not exceeding 25 kilograms of small arms nitro compound. ಇಷ್ಟೇ ಇರೋದು.
ಹೌದು. So this is the unit where they sell.
So therefore, there should be some clause which would pertain to what he is doing. Accordingly, you should see and consider the objections.
Yes, my lord. This
ಏನ್ ಮಾಡಿದೀರಾ?
this is a storage unit.
Storage ಗೆನೆ all this, it's either for manufacture or storage.
But a public hearing was called by the deputy commissioner. But after
ಅಂದ್ರೆ
hearing,
ಸುಮ್ನೆ ಕರೆದ್ಬಿಟ್ಟು without even looking into the provisions, if the deputy commissioner has proceeded, then it is wrong.
but after hearing the petitioners, my lord, a reasoned order came to be passed.
ಅವ್ರುನು ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿಲ್ಲ. When he came before this court last week, I said, which is the provision? He was not able to point out. After sending him only, now today he is bringing all this. Which means even before the deputy commissioner, they have not pointed out to this provision. And in fact, it's the duty of the deputy commissioner.
My lord, we have
He
stated
should
that-
know what are the provisions that are required to be complied. Please. ಸುಮ್ನೆ ಅಬ್ಜೆಕ್ಷನ್ ಕರೆದ್ಬಿಟ್ಟು ಗ್ರಾಂಟ್ ಮಾಡ್ಬಿಟ್ರೆ?
ಇಲ್ಲ, reasons have been assigned. ಪ್ರಸ್ತುತ ಕಡತದಲ್ಲಿನ ದಾಖಲಾತಿ.
He is saying they have dwelling houses within a distance of 500 meters. So which is the provision, first of all, which are required to be followed and
113 113 is for shops and storage. ಅದರಲ್ಲಿ
ಅದರಲ್ಲೇ ಬರುತ್ತೆ.
ಅದರಲ್ಲೇ ಬರುತ್ತೆ.
ಅದರಲ್ಲೇ ಬರುತ್ತೆ.
ಅದರಲ್ಲೇ ಬರುತ್ತೆ.
All provisions are made both for manufacturers
As well as
and for
storage
storage.
and selling, the
ಹೌದು.
three different categories.
Yes.
If that
ಅಲ್ಲ,
is so,
storage ಅಂದ್ರೆ ಏನ್ರಿ? They will, it is for the purpose of sale only.
ಹೌದು, but they cannot sell at that place. Well, they cannot sell in that place. Go down.
ಹಂಗ್ ಬರೋದೇ ಇಲ್ಲ ಹಂಗಾದ್ರೆ.
No, my lord, now.
You
for
you
example,
cannot
if-
simply store it there.
No, no, my lord, if I have to say this, I have a shop, my showroom unit is there. Then I have a godown. Now my GST is registered. In the GST I show as my sale showroom. Then as a godown. My lord, what I do
These
is,
provisions will apply to both the places.
yes, my lord, but
Both
then,
for storage
yes.
as well as in the
sale
shop.
unit. Yes, my lord. Previously
Apply to
also,
both
my lord,
places.
previously such matters came up during the Diwali season and we were arguing the same matter, my lord.
ಇದು ಯಾವ್ದು crackers ಅಲ್ಲ ಇದು.
The crackers alla. Similar, because explosives act only, explosive act applies.
Yes.
So what happens is, we were defending, the government was defending licenses for those shops in high density populations which they were existing in areas like Avenue Road and all. What their argument was, they say we store only 100 kgs of cracker at one point of time. We have a storage license.
Correct.
Outside Bangalore city, we have 2000.
Correct. So
tons of
even
so-
for the shops which
There's a
are,
separate license.
no, even for the shops which they are saying we store less than 100 kgs.
Yes, ma'am.
Provision is
Yes,
made.
yes, yes, ma'am.
You will have to comply with all the requirement.
Separate
Or
license, separate
different
NOC.
requirements are
Correct.
prescribed.
Yes.
For a shop, for a manufacturer, for a godown.
Go down, yes.
ಎಲ್ಲದಕ್ಕೂ ಇದೆ.
ಅದಕ್ಕೂ.
So whatever is applicable to the shop and to the godown, both they have to
That he
fulfill.
has to answer. If whether he is.
ಇದು ನಿಮ್ದು ಇವಾಗ ಬರೀ ಗೋಡೌನಾ?
It's only godown, my lord.
Only godown.
Godown.
You are not selling it there.
I am selling there only, my lord. It's a godown
ಹಂಗಾದ್ರೆ
come
ಎರಡು
shop.
ಬರುತ್ತೆ.
Godown
ಎರಡು
cum
ಅಪ್ಲೈ
shop.
ಆಗುತ್ತೆ. You will have to point out to the relevant provision.
Let my learned friend serve me a copy of the writ petition and annexes there.
No, we will dispose of the writ petition.
I'll
We will
file,
set aside the NOC.
I'll file my statement of objections.
No, no, no. The deputy commissioner is required to comply with all these provisions. But we will remit the matter back to the deputy commissioner.
To reconsider.
Let him consider all the provisions and then consider the objections and
Let-
then dispose it.
Let an opportunity be given to me, my lord, in order to file
Definitely.
statement of objections.
Definitely.
Let me serve me a copy of the writ petition.
Not
But-
here, sir. You go and file your objections there. ಬರ್ಕೊಳ್ಳಿ. There is no reference to any provisions.
A time bound frame may be fixed, my lord, in order to consider.
Learned counsel, Shri,
Manjunath B.R., my lord.
learned AGA takes notice
For 1 and 2.
for response number 1 and 2. Learned counsel, Shri,
Manjunath B.R.
PR, who is present in the court, appears for response
Respondent
number 3. Next para. The grievance of the petitioners is that a no objection certificate is issued by the second respondent, Deputy Commissioner, Chikballapur District, to the third respondent for grant of license for possession and use of explosives from a magazine of class 2 up to 20,000 kgs, semicolon, class 6, division 1, 40,000 meters, and class 6, division 3, 44,000 numbers, comma, without considering the objections filed by the petitioners. Full stop. It is the contention of the petitioners that their residential houses are at a distance of less than 500 meters from the shop bar godown of the third respondent, where they seek to store the explosives. Full stop. It is the contention of the learned counsel for petitioner that such no objection certificate could not have been issued by the Deputy Commissioner without considering the objections filed by the petitioners and without considering the relevant provisions of law. Full stop. Attention of this court is drawn to Rule 113 of the Explosives Rules, 2008, which prescribes the documents required to be submitted for approval and grant of license. Full stop. Clause nine in the table at annex at Rule 113. Prescribes the material required to be placed by the third respondent before the Deputy Commissioner for possession and use for agricultural purposes or in small quarry explosives not exceeding 50 kilograms of class 1, 2 or 3, semicolon, 1,500 numbers detonators, semicolon, 1,500 meters of detonating fuse or safety fuse at any one time in a magazine. Full stop. Similarly, clause 10, 11, 12 and 12 prescribe various other requirements, depending upon the volume of the explosives to be stored. Full stop. Learned counsel for the petitioner submits that the Deputy Commissioner has not looked into any of these provisions before granting NOC to the third respondent. Full stop. It is contended that the minimum distance maintainable has been prescribed in terms of Rule 113 in Form DE-1. Wherein a minimum distance of 650 meters is prescribed from such shops or godowns with reference to dwelling houses, public buildings, temples, mosques, church, and other places of worships, etc. Full stop. Next para. Adene, quarry gane. They are using it for quarry only. And you see the NOC given for 20,000 kgs. 20,000 kgs. Mate?
Not for sale, but for transfer to its own license. License to possess explosives of class 1, 2, 3, 4, and 5, 6 in the banquet and detonators. That is 9, 10, and 11 al bata.
Correct. That is what I said. But this Annexure A has been issued in the year 2022.
Annexure A is a application form.
Application form.
Submitted by the.
When is it granted?
Response number 3.
When is it granted?
Granted recently.
Annexure G, na?
Yeah, yes.
15/7/2024.
Yes.
25/7/2024.
Huh?
25/7/2000.
Annexure H.
No, Annexure G, 15/7/2024, my lord. Impugned order.
15/7/2024.
Yes.
Order was issued on 25.
25/7. Next para. However, this court finds that on an application filed by the third respondent on 28/7/2022, NOC has been given on 25/7/2024. Full stop. The petitioner has been carrying on the business.
No, but still I am making preparations in order to install the. Not started.
Learned counsel for the third respondent submits that the third respondent is making all preparations, please, for the storage of the explosives in terms of the NOC. License kotilva?
License ಕೊಟ್ಟಿಲ್ಲ.
Licensing authority is the control of the Division of India.
So it is yet to come, please. All right. All. ಏನ್ ಹೇಳಿದೆ? In terms of the NOC. But the license is still not granted to the third respondent by the competent authority. Who is the competent authority? Full stop. Next para. Having regard to the facts stated herein above, this court is of the considered opinion that the second respondent, Deputy Commissioner, was required to consider the objections filed by the petitioners. Full stop. It is not a mere formality that objections are considered, comma, having regard to the serious consequences that may follow if there is any untoward incident. Full stop.
Procedure is prescribed under 103. Clear procedure. 103. Procedure is for a grant of 103. Just follow what is envisaged in 103 and then have heard the other part.
Allah, site plan showing the location of the premises proposed to be licensed for issue of a certificate to the effect that there is no objection to the applicant receiving license for the site proposed. But they have filed objections. If objections are received, ellide?
3A ನಾನು ಹೇಳ್ತೀನಿ. With reasons thereof, within a period of 1 month, there is a consideration of objections by him. For a proposed premise like
Specifying the date, time and place for consideration of the objections by him. Where the site of proposed premises lies within 1 point adbadiya. If objections are received?
Yes.
What is it that it says?
Inquiry was conducted.
What is the prescription of law in rule 103?
On receipt of objection,
shall call the person or person raising objection or the applicant giving not less than 7 days of clear notice and the day fixed for hearing. On that day fixed for hearing, any hearing may be extended from time. We shall make inquiry as he may give to other specific. So he has to hold a proceeding. Here the proceedings also was held.
And even in terms of the application itself, at page number 13, the application itself prescribes the minimum distance that has to be maintained. And their contention is that it is less than 500 meters. Where is the consideration?
Based on a Google map of
Correct. Yes.
Based on that, let him pass it.
Because nothing has been said in the order. If they had considered the objections and they have said, we conducted an inquiry, it is found that it is beyond the distance of 650 meters and not within 500 meters as contended, then it is acceptable.
ಮನೆ ಬಗ್ಗೆ ಅವ್ರು ಹೇಳೇ ಇಲ್ಲ. ಕೇಸ್ 25 ನಲ್ಲಿ ಅವ್ರು ಫೈಲ್ ತಹಸೀಲ್ದಾರ್ ಗುಡಿಬಂಡೆ ತಾಲೂಕು ಅವರ ವರದಿಯಂತೆ ಸ್ತ್ರೀ ಜಮೀನು ಸುತ್ತಮುತ್ತಲು ಕೃಷಿ ಜಮೀನುಗಳಿದ್ದು 500 ಮೀಟರ್ ಒಳಗೆ ಕಾರ್ಮಿಕ ಸ್ಥಳ ಶಾಲಾ ಕಾಲೇಜು ಇಲ್ಲಿಲ್ಲ ಎಂದು
But their contention is that the dwelling house is there. ಏನಿದೆ? Full stop. Moreover, in terms of the prescribed application form itself, at minimum distance of 650 meters as safety distance is required to be ensured. Full stop. The impugned order at annexure G dated 15/7/2024 passed by the second respondent deputy commissioner simply places reliance on a report submitted by the Tahsildar stating that there are only agricultural lands around the vicinity and there is no objectionable places such as schools, colleges, places of worship, etc., within a distance of 500 meters. Full stop. It does not, the order does not specify as to the contention raised by the petitioners that they have their dwelling houses within a distance of 500 meters from the place in question. Full stop. The matter therefore requires reconsideration. Full stop. Next para. Accordingly, the petition stands disposed of while remanding the matter back to the second respondent deputy commissioner for reconsideration of the objections filed by the petitioners who state that their dwelling houses are within a distance of 500 meters from the place in question belonging to the third respondent. Full stop. The deputy commissioner shall cause an inquiry in this regard in the presence of the petitioners and the third respondent. Come out to find out whether the dwelling houses of the petitioners is within the prohibited distance in terms of the provisions of the Act and the rules. Full stop. Next para. Since the third respondent is making all arrangements for the storage of the explosives in terms of the NOC, but are awaiting grant of license from the competent authority, the second respondent deputy commissioner shall conduct the inquiry and pass orders afresh as expeditiously as possible and at any rate within a period of 4 weeks. Howdo? It is no only now the consideration of the objections of the petitioner.
The report from Tahsildar, 7 days notice has to be issued to the.
Bada, we will fix the date. We will fix the date. We will ask them to appear before the deputy commissioner. Within a period of 4 weeks from January 2025. Full stop. On 23rd of January, the parties herein are directed to appear before the deputy commissioner without waiting for further notice. Full stop. Ordered accordingly. Please.
Serial number 16.
Whether petitioner has availed OD facility to the tune of 25 lakhs, my lord, and he was unable to pay 7 installments of interest, therefore became NPA and now auction notice is issued as per annexure A, calling upon me to pay 22 lakhs 71,104. I'll pay the 25% within 4 weeks, my lord. And I am also intending to complete the entire dues within 6 months, my lord. I'm carrying any business, my lord. For the purpose of business, I availed the OD facility. And for 7 installments, I was unable to pay the interest. And I am due to a tune of 22,71,104, my lord. And 25% within 4 weeks I will deposit.
Issue notice to the respondents. Next para. Learned counsel for the petitioner submits that the petitioners have availed an overdraft facility from the respondent bank, and the impugned sale notice at annexure A has been issued on 20/12/2024, stating that the petitioner is overdue in a sum of rupees 22,71,104. Full stop. Learned counsel submits that the petitioners will make necessary arrangements to repay the outstanding loan amount if a reasonable time is granted to them. Full stop. In order to show the bona fides of the petitioners, it is submitted that the petitioners will deposit 25% of the outstanding amount within a reasonable time. Full stop. Next para. Accordingly, ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಅಲ್ಲಿ DR ರವಿಶಂಕರ್ ಅವರು ಅಪಿಯರ್ ಆದ್ರು. ಅದರಲ್ಲಿ ಲಾಸ್ಟ್ ಪೋರ್ಷನ್ ಏನಿದೆ ಸೇಮ್ ಅದನ್ನೇ ಮಾಡಿ. ಎಸ್, we have refixed the matter on 18th of February. Within 4 weeks, you'll have to deposit 25%.
17, Karthikeyan.
I appear to the petitioners in this matter. On 23/12/2024, the complainant, the petitioner's husband, files a complaint before Chikbalapur Rural Police Station alleging a theft of rupees 4 lakhs and original property documents and other crucial business documents of the petitioner's company. Petitioner and the complainant are partnership. It is a partnership firm.
FIR register madilva.
FIR register madilla. The offense is cognizable in nature. Theft of rupees more than 5,000 rupees is cognizable in nature. Subsequently, if my lords come to page number page number 33, my lords, annexure B is the copy of the complaint, my lords, scanned copy of the complaint. The type copy is in page number 36, my lords. 38, my lords, in
photographs.
That is the.
These are, my lord, employees of the complainant itself that have gone into the office premises. He
And
alleges, my lord, that some equipment and some information and money is taken out of
Taken
the,
out of. My lords, these are the
out of
support
the
employees.
office. They're
My
employees.
lords, they-
They're
they-
employees. They are called to the station. Petitioner is also called to the station. He says we'll sort it out of court. Sorry, out of
lord,
the station
this-
itself. Page 38
My lords, I may be
is his
permitted to
undertaking.
submit.
Annexure B starts at page 36 is the type copy.
My lords,
38 he concludes saying that we will settle it outside.
my lords,
And I retract my
my lords,
complaint.
my lords, if I may be permitted to submit, my lords, may I kindly come to page number 33. My lords, the handwriting difference, and my lords, there's no signature of the complainant. The handwriting difference, my lords, is clearly noticeable, my lords. My lords, on page number 33, the first page of the complaint, my lords, the complaint is written by the complainant in his own handwriting. But the handwriting of, in the side, my lords, in the left side of the first page of the complaint, my lords, it's written that dinanka 26/12/2024 randu, the type copy is, my lords, in page number 38. ರಂದು ಠಾಣೆಗೆ ಹಾಜರಾಗಿ ನಾನು ಫಿರ್ಯಾದಿಯನ್ನು ನಾನು ವಾಪಸ್ ಪಡೆದುಕೊಳ್ಳುತ್ತೇನೆ. ನಾವುಗಳು ಈ ಸಮಸ್ಯೆಯನ್ನು ಇತ್ಯರ್ಥ ಮಾಡಿಕೊಳ್ತೇವೆ. My lords, there is no signature of the complainant. My lords, if my lords comes to page number page number 39, my lords, it is a screenshot of the call records of the complainant's mobile. My lords, things standing that the complainant started getting threats and harassment from respondent number 5 and 6, my lords, who is the circle inspector and the sub inspector of Chikbalapur Gramantara police station. My lords, including the number. My lords, now, my lords, on 10/1/2025, the petitioner is a resident of Andhra Pradesh, my lords. My lords, the petitioner's husband, who is the complainant, goes missing and a report FIR is
So what does the law require if the FIR is not registered?
My lords, I have to approach the higher officials, which I have done. My lords, I filed an RPID. Officially, I've gone before them and I filed an RPD, my lords.
Huh?
I filed an RPD. My lords, page number 43, Annexure D.
Annexure D.
My lords, no action has been taken. Now, my lords.
Where is the letter, my lord? Letter is not produced.
My lords, even now, my lords, if I approach this magistrate in a PCR, my lords, the police might come. The police will only record because it's recorded on my complaint. It's not signed, my lords. I have no records, my lords. Now, the petitioner's husband, the complainant, is gone missing, my lords. There might not be any.
Who has gone missing?
The complainant, my lords. The complainant who filed this complaint has gone missing. The petitioner who is a
That your husband?
My husband.
Your husband?
Please, my lord, who is the
He is
complainant?
gone missing.
He's gone missing. Missing complaint was filed before police, Hindupur, second stage police station in Andhra Pradesh. And FIR has been registered. My lords, there is clear allegation of threat, my lords, by the respondents. My lords, there cannot be any answer given by, it's a cognizable offense, my lords.
Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned AGA. Stop, next para. Learned counsel for the petitioner submits that the petitioner's husband, Sri Bellam Naresh, lodged a written complaint, as found at Annexure B. Your husband knows Kannada?
No, he knows Kannada, man. He also there is a company which he runs in. He's a real estate business owner. He knows Kannada.
With the fourth respondent, station house officer, Gramantara police station, Chikbalapur Taluk. On
23/12/2024.
23/12/2024. Alleging that his own employees have stolen away movable properties from his office. And therefore requested action. Full stop. However, FIR has not been registered till date. Full stop. At Annexure D is the acknowledgement for having sent the complaint to the Superintendent of Police, Chikballapur district. Full stop. Learned counsel would further submit that the petitioner's husband has gone missing. And in that regard, a complaint, an FIR has been registered
On 10/1/2024.
with
Melod's Hindupur second town police station in Andhra Pradesh.
Barkondrama. Full stop. Next para. Learned AG is directed to secure instructions from the third respondent, Superintendent of Police, Chikballapur district, as to why action is not taken. Although a communication has been made to the Superintendent of Police
My lord, eventually superintendent of police will have to
on
direct.
9/1/2025. Full stop. The law requires the minimum of having the FIR registered in the police station, if an offense is made out on a complaint, written complaint given by the petitioner's husband. Full stop. Release this matter on 21st of January. Please ensure that an FIR is registered and take further action and make submission.
Admission. Number 18, Sampath Anand Shetty.
And for the petition, defendant's
Respond.
application seeking rejection of the plaint has been dismissed. Now, the facts which are not in dispute between the parties, that the plaintiff and defendant jointly purchased a vacant land measuring 19,874 square feet as back as on 16/11/2013. And it is further admitted that
Plaintiff and defendant.
together they jointly purchased
Ah,
a property measuring 19,874 square feet on 16/11/2013. Thereafterwards, on 13/2/2015, half share of the plaintiff came to be released in favor of the defendant, and the defendant became the absolute owner of the whole of the property. Now, after that, my lord, the property was developed into apartments. On 19/6/2015, the plaintiff, recognizing the title of the defendant, has entered into an agreement of sale in respect of one apartment. Out of the 29 apartments were developed, one apartment to be constructed, he had promising to pay about 50 lakhs. Now, while releasing on 13/2/2015, he had taken a consideration of 2 crores. The release deed was under consideration while relinquishing his half share. Thereafterwards, he has admitted my title. Then in 2023, after 8 years, I have filed first. He was trying to trouble me while my apartment was in the full-fledged construction. I filed a suit for permanent injunction. And that in that on 6/4/2023, a temporary injunction also came to be granted, restraining him from interfering with my peaceful possession. Thereafterwards, he sought, in the very same suit, he sought for modification of the said injunction on the ground that I have admitted that I have inducted him in one of the apartments out of the 29 apartments. That is his case. Now, the temporary injunction came to be modified, restricting that I should not interfere with him so far as
respect of that.
that apartment, and I have to file a suit for eviction. I have complied with that order and filed a suit for eviction, and I have obtained an injunction order restraining him from interfering with any of the apartments, not to interfere. Now, thereafter, the present suit came to be filed. This plaint, which I am seeking for rejection, that is OS number 25,762 of 2023. This is the plaint. Now, in this, what he seeks, kindly see the plaint copy of your plaint.
Filing it here.
No, we don't. No. Yes. Now, in this plot, kindly see the cause of action. Paragraph 18.
May I read, my lord? This suit. First, let me take your lordship to the cause of action of this suit. Plaint. Paragraph 18. The cause of action for this suit has accrued to the plaintiff on 6/4/2023 when OS number 25567 of 2023 was filed by the defendant asserting absolute title to the suit scheduled property on 17/4/2023. The henchman of the defendant forcibly entered the residence of the plaintiff in the suit shell property on 21/4/2023 when, notwithstanding the order in OS number 25567 2023 not to disturb plaintiff possession, high-handed actions were undertaken by the defendant on 26/4/2023 when the newspaper publication was given claiming plaintiff has no title to the suit shell property, and subsequently when steps are being taken even to this date by the defendant to create third-party rights and continues to accrue even on the stage within the jurisdiction of this court. Kindly turn to the prayer in the very same prayer. Wherefore, the plaintiff humbly prays that this honorable court be pleased to pass a judgment in decree to adjudge the release deed dated 13/2/2000 after 8 years, 13/2/2015, executed by the plaintiff via the defendant in respect of suit shell property in so and so as void. Now he takes 2 crores consideration after 8 years. After I filed a suit, by way of an afterthought, he seeks for nullification and it to be delivered by the defendant and cancelled. Consequently, send a copy of the decree to the sub-registrar for purpose of noting on the copy of the instrument contained. Next, this is very important. This is consequent. It is only after nullification this prayer would survive. Partition of half share of the plaintiff in the suit shell property by putting the plaintiff in possession thereof by meets and bounds and permanent injunction. Now, the reorder, now your lordship may kindly see.
You filed an application, order 7 rule 11.
Yes. Now that, so far as that is concerned, your lordship, the only portion of the order which has been considered is available at page 35.
Where is your application?
Application not filed. Application is not on record.
Not
My
filed a copy.
objections are not filed.
No, your lordship may kindly see.
You have not filed copy of the.
No, along with this, my lord, I have not filed. It is there.
My objections also, my lord, are not on record.
Now, the impugned order, if your lordship permits, notwithstanding.
No,
the
what are the
application.
grounds on which
Yes.
you
Yes.
filed the application?
Yes,
Yes.
there is no cause of action at all, because that's why I read the cause of action. Now, may I read?
That's all.
No.
Rule
because-
11A.
Pardon me? Yes.
Order 7 rule 11A.
Yeah, because,
Stay.
no, your lordship may kindly see. Here,
No, in terms of your application, sir.
yes, madam, that,
In terms of your application, what is the ground that you have raised?
no, the ground is, my lord, he has taken now the,
Please refer to the application and say what is the ground, sir. Where the suit appears from the statement in the plaint to be barred by any law.
No cause of action.
Please to reject the suit of the plaintiff where the suit appears from the statement in the plaint to be barred by law. Aste.
no, here, as far as this is nothing but a bogus litigation, because, no, your lordship may kindly.
Sir, you are aggrieved of the impugned order
Yes,
of rejection of your application.
yes.
So we are trying to find out what was your prayer, what are the grounds that you have raised,
That's what.
whether it has been considered or not. That
Yes,
is what.
that's
what
correct.
has-
First, my lord,
Yes.
from the statement, that's what I read. the
From
cause
your
of-
application, it appears that your only ground that it is barred by law.
Because there is no cause of action for the suit.
Sir, that is A.
Yes,
D is different. On a plain reading of your application, you are only contending that it is barred by law.
read by law, I don't think of that.
Huh? Then what?
No,
to do?
kindly see the consideration. I'm only on this, my lord. See at the page 35, consideration of that, whatever that application. kindly see page 35. Now, first, my lord, this on the trial court, in this suit, my lord, where I have made it clear.
Although you have made an amendment, you have written A and D.
Yes,
You
that's
have
what-
included
Yes.
in the application, but there is no grounds made out and no prayer.
No, I mean, that, be that as it may. Kindly see page 35, consideration of this. The effect of this, my lord, kindly see page
Yes.
35. In so far as page 35, running. through.
Yes,
Only this reasoning.
yes.
Insofar as IA number 2 for rejection of the plaintiff is concerned, no doubt the plaintiff has not pleaded force, fraud, or misrepresentation in the matter of execution of the release deed dated 13/2/2015. However, the plaintiff has specifically pleaded facts and circumstances in which said release was executed as a nominal document at paragraph 5 of the plaintiff, which is already discussed above. Therefore, it is a matter for trial to determine whether the plaintiff is able to prove on the said facts and circumstances the release deed is a nominal document. The law is settled that at the stage of order 7, rule 11 of the CPC, the court cannot enter into the realm of disputed facts. If the plaintiff arguments are taken at face value, as it has to be taken at stage 7, rule 11 of the CPC, the plaintiff contains sufficient arguments to the effect that the release deed is a nominal document which was never meant to be acted upon, and despite execution of the release deed, the parties always treated social property as their joint property. If these plaintiff arguments that the release deed 13/2 was a nominal is accepted at face value, and in view of the fact that suit shall property having been purchased jointly by the plaintiff and defendant, the plaintiff would be entitled to half share in the property. However, there is a heavy burden upon the plaintiff to prove in the trial that the release deed was a nominal document and never meant to be acted upon. Therefore, at this stage, it cannot be said that the plaintiff does not disclose cause of action or the plaintiff is barred by law because the plaintiff contains sufficient evidence that the release deed is a nominal document, and hence the matter requires to go to trial according to answer. Now I am, so far as the next order, IA number 39 order 24 is allowed and temporary injunction is granted, restraining the defendant from alienating or creating third party interest over the suit or property till the disposal of suit. Now,
This portion
admittedly,
of the order cannot be challenged in the CRP.
yes, madam, that I know. It has been affirmed.
CRP, we are only concerned of
Correct, madam.
order 7, rule 11.
Yes, madam. I'm
So if you have no grievance in respect of that portion of the
no,
order,
that has been confirmed also. I am not saying that.
It is confirmed.
What
with
I
this
have
court.
now
This
by
one
what
court confirmed that order
kindly,
in
no,
detail
I am
order.
not on that, madam.
yes,
Kindly see by what now the plaintiff now, I have filed an application seeking modification of this order because I am now restrained from alienating any of
we
the,
are not concerned of that
Yes, but
portion of
I-
the order in this CRP.
no,
In
no,
this
they-
CRP, we are
correct,
not
correct.
concerned of that portion of the order.
yes, madam.
We are only concerned of the application on order 7, rule 11. If you have to make any submission in that regard, you please make.
In page 38,
Yes,
I have filed by the.
your application is dismissed.
Dismissed,
Yes.
that's correct. Now,
What is wrong in the order?
no. That is, the 11 A and D both are there. That is there.
I
yes.
accepted.
Yes.
All right.
Yes. Now, your lordship may kindly see, in the instant case, this suit, when it is entertained, now, by virtue of that, my lord, admittedly, he is entire, except one apartment he has entered into an agreement. Now, after 8 long years, now,
All
all
that
that on merits.
requires to be considered after evidence is brought on
Yes,
record.
sir. Now, at the interlocutory stage, I
Chances
have
of
filed,
the chances of the plaintiff to succeed on these
are very bleak. that is-
governments
uh,
may be very less.
Yes. Now,
But
all that I request this honorable court is that
Huh.
I have filed this particular application before the pending suit. I have filed an application seeking modification of this order. That your lordship may kindly.
ಯಾವ
that-
order?
It is under order 39.
ಅದ್ ಬರೋದಿಲ್ಲ.
4A. In view of the subsequent events, there is a provision.
Sir, I can't consider that one in this CRP. The learned senior counsel is saying that in respect of that order,
It has been confirmed.
you are already before this court,
Yes.
and this submission should have been made in before
No,
that court.
even in the trial court, my lord, notwithstanding that, there is a provision, I have filed an application. That could be directed.
ಯಾವ
with the
application?
Application under the modification of that order.
Modification will be moved in the High Court now because
No, not.
the High Court has upheld that order
It is
fully.
pending. All that.
All
in
these
the-
contentions which my learned
the
friend
pending
urged
suit.
were
I am
examined
requesting-
specifically.
ಇಲ್ಲಿ ಆ MFA ಹಾಕಿದ್ರಲ್ಲ ನೀವು ಅದ್ರಲ್ಲಿ ಮಾಡ್ಬೇಕಾಗಿದೆ ಈ ಸಬ್ಮಿಷನ್.
ಅಲ್ಲಲ್ಲ, after that, even if it is considered, my application is pending, I will read the provision where I am entitled to do that, that application is pending. Now, otherwise, my lord, I am restrained from alienating any of the social property. My application is pending in the present suit. That at least your lordship, that or the suit itself, because I am restrained, half share I already demonstrated. I am restrained from alienating any of the properties, except he is hanging on one apartment, and for that also I filed a suit for eviction, accepting the order of the injunction. So now I am suffering without there being any deposit of 1 rupee. He is enjoying, I am restrained from, though I am the absolute owner of the property, I am restrained from.
What application have you filed now?
I have filed an application seeking modification of the order.
This order?
No,
Impugned order?
No, not this. It's a plain rejection. The injunction, by seeking that let him deposit or provide security. The application, David, to
You argued it, I'm told.
direct the trial court to consider that application. Or else the suit itself may be disposed of, because I am suffering, my lord.
Berkeley.
Suit may be directed to be disposed of. He is multiple suits have been filed and I am restrained. Though 29 apartments, I am not alienated. That to that extent I will protect it. Let him provide security.
Petitioner herein is defendant in OS number 25762 of 2023. Full stop. His application filed under order 7 rule 11 bracket A and B has been rejected by the trial court, and therefore this civil revision petition has been filed. Full stop. Next para. The impugned order contains order on an application filed by the plaintiff under order 39 rule 1 and 2, as well as consideration of the IA filed by the defendant under order 7 rule 11 of CPC. Full stop. Insofar as the order passed under order 39 rule 1 and 2 is concerned, learned senior counsel Shri Dhyan Chinnappa, appearing for the respondent, submits that the petitioner herein had filed MFA number 6736 of 2023 and 6738 of 2023, and the miscellaneous first appeals were dismissed by order dated 1/3/2024. Full stop. There is an injunction, temporary injunction operating against the petitioner herein, but defendant, that he shall not alienate or deal with any portion of the suit scheduled property during the pendency of the suit. Full stop. Learned counsel, next para, for the petitioner submits that subsequently the petitioner has filed one more interlocutory application before the trial court.
IA number 4.
In IA number 4, with a prayer
for modification, to provide security.
For issuing certain directions to the plaintiff to deposit certain amounts as security, since the defendant has been restricted from alienating the apartments which he has put up.
Yes.
Full stop. Learned counsel would therefore submit that the petition may be disposed of, directing the trial court to consider the said application.
As well.
Full stop. Next para. Accordingly, the civil division petition stands disposed of, upholding the impugned order passed in respect of
Rejection.
the IA filed under order 7 rule 11, while requesting the
Total 22, may on.
learned
13th edition.
13th additional city civil and session judge, May Hall unit, Bengaluru, to consider the said interlocutory application said to have been filed on behalf of the defendant, seeking certain directions in view of the restriction placed on the defendant not to alienate any portion of the suit schedule property during the pendency of the suit. Full stop. It is also requested that the trial court may consider, may endeavor disposal of the suit itself as expeditiously as possible.
This, your lordship, your lordship may kindly direct some time.
Huh?
Some time limit, because I am not even.
The interlocutory application filed by the defendant shall be considered as expeditiously as possible and at any rate within a period of 4 weeks from the date of receipt of a copy of this order.
All contentions may be left open, my lord, because
Now, I have not said anything.
19. Yes, Prakash.
I appear for the respondent. I appear for the respondent.
Matter is called out. There is no representation for the petitioner. List this matter after 2 weeks.
But may I request for a date?
20.
Interim.
There is an
order
interim order subsidiary against me, that's why.
Release this matter on 22nd of January. Please.
Number 20.
for the
Then Govindra.
petitioner, plaintiff's revision petition, challenge dismissal of the suit, small cause of suit. The plaintiff, my lord, is the owner of the suit schedule property, a residential property, my lord, which was let out to the defendant, who is the brother of the plaintiff. Suit for ejectment was filed before the small causes court. But 3 issues were framed: whether I established the dual relationship of landlord-tenant, and whether notice was issued under section 106 terminant tenancy, if not, what order to be passed. But trial court holds both those issues against me, that I have not established. But goes on to hold that I did not even have money to purchase the property, and the defendant is a co-sharer in the property. But these findings, my lord, in my suit for ejectment, my lord, I can very well understand on dismissal of my suit. But to pass findings against me, my lord, in the suit for ejectment, my lord, would in my humble submission not be the right course of action for the trial court to adopt. The partition suit is also pending. Now, defendant filed a partition suit against me. That suit is pending. So therefore, my lord, I'm aggrieved by the judgment insofar as record findings of title, my lord, against me and in favor of the defendant in my suit for ejectment.
Which portion?
My lord, paragraph in page 26, my lord, paragraph 14. The lordship will kindly see a Kannada portion, the observation. The lordship has a in page 26. On perusal of above statement in cross-examination, it shows that the plaintiff was not having any source of income, and hence she stated in the proceedings filed against her husband that she was depending on her income of her parents. It shows that she was not having any source of income to purchase the property. Even she has not produced any document to show her income to purchase the property. Lord, the next finding, my lord, para 18,
page 30. In page 30.
Hmm.
Moreover, PW1 in the cross-examination clearly admitted that she has no income to purchase property. PW1 in cross-examination dated 28/3/2023 has clearly admitted that there were some proceedings against her husband. In that proceeding, she has admitted that she has no income and depending on parents' income. This cross-examination shows that she was not having any income to purchase the property. Even the plaintiff has not produced any document to show her source of income. Admittedly, this is not a case of declaration of title of ownership of property. However, when the defendant took specific plea, disputing the exclusive ownership of the plaintiff over the property, heavy burden is cast on the plaintiff to prove her title over the property. But the last finding is that in page 32, about 6 lines from the bottom of, in page 32, you know,
32.
32.
Ah.
Only the court holds about 7 lines from the bottom of the page, foot of the page. Further, it shows that after the death of his father, defendant is residing in the suit premises as a co-sharer and not as a tenant under the tenancy of the plaintiff.
Hmm.
But in the light of the questions not the court frames for consideration, at page number 20, my lord, the points for consideration court has framed. Now, these findings are completely, my lord, contrary or inapposite, my lord, when compared to the
So
points.
what are you seeking only to expunge this?
Yes, these.
That's all. You work out your remedies in the partition suit.
In the partition suit, or I may be permitted to file, I can file another suit for ejectment against the defendant.
Huh?
I can, with liberty to initiate appropriate proceedings against the defendant, because in this suit, the court holds, I have not proved the jural relationship.
Yes.
Therefore, my lord, I can file, my lord, another suit for ejectment against the defendant.
How?
Not by placing appropriate material on record in accordance with law. Otherwise, my lord, my avenue to secure possession of the property is closed up. No, I can even file a suit for ejectment, not on the ground that he is a tenant. That is an unauthorized occupation. The permissive possession has come to an end. My right as an owner, my lord, cannot be restricted, my lord, is my humble submission.
See, you had filed a suit for eviction.
On the ground that he was a tenant.
Correct.
Yes.
Now the court has come to a conclusion.
Yes.
With the material evidence placed on record that you have failed to prove the jural relationship of landlord and tenant.
Correct.
So, would it be permissible for you to file one more suit on the same cause of action with the same prayer?
Not on that cause of action, my lord. I can
Same
say,
prayer.
I can now say that there is no relationship of landlord and tenant. As a brother, I've allowed him to stay in my premises. And now the permissive possession has come to an end. I do not want him to occupy my premises. If a trespasser enters my premises and establishes settled possession, then I can file a suit against him saying that I want to eject him from my premises. The question of landlord and tenant relationship, I may not be able to establish.
Then it will not be a matter that can be reconsidered by the small causes court.
Yes, it will have to be
a original suit.
Yes.
Yes, what do you say?
Admittedly, Your Honor, the
You
petitioner
heard
has
what the learned counsel is
Please,
trying
please.
to say.
way back in 1991,
You can uphold the orders passed by the small causes court.
please, And
Insofar as
in view
the
of,
rejection of the claim made by the petitioner, rejection of the petition
please,
for ejection of the defendant.
please,
To that extent, it may be upheld.
please.
But there are certain observations made regarding the ownership of the property.
Yeah, I will come to the ownership here.
Anyway, it could not have been made. So
It is-
what he is saying is,
Please.
please expunge those portions of the finding,
There is a
because
clear
it
find-
cannot be done in a suit for ejectment.
The trial court can lay its finding, Your Honor, at page number 17.
He has a right now to file a suit, not for ejection, for declaration. It is she, is it?
She.
She has a right to file a suit
Please.
seeking declaration that she is the owner of the property. Isn't it? If she files a suit, these findings will come in her way. That is the submission. In a suit for ejection, there was no need for the court to have made these observations.
No, it is a suit for eviction. Apparently, it is
Only a suit for eviction.
eviction.
So the suit for eviction is rightly dismissed.
Please,
All right.
please, madam.
But these observations regarding ownership should not come in the way of the petitioner if she files a suit for seeking declaration
Yeah.
that she is the owner of the property.
Please, madam.
To that extent, he is saying, you please expunge those remarks and permit me to file a suit seeking declaration.
Please. If I could take your lordship to para number 17 at page number 28. The trial court has given a clear finding that she was not the owner of the scheduled property.
That is what, madam, he is saying that cannot be done in this petition.
While answering a suit for.
All right.
While
So
answering.
Therefore, we will say all those remarks made by the court in respect of the ownership of the property in question is concerned,
Please.
will stand expunged while upholding the judgment, dismissing the petition. That would enable the petitioner to file a suit for declaration. And these observations will not come in the way of the petitioner in the subsequent suit.
And in view of the partition suit pending, Your Honor, the petitioner herein can urge all those in the suit for
It
partition.
is open for him to urge that in the suit filed by you,
Please.
or he is also having a right to seek a declaration. That you cannot foreclose.
Very well.
Barkale.
But there is a clear finding by the trial court with regards to
To-
the
For
ownership,
the purpose of dismissing the petition, it is all right.
and it has been a joint living, Your Honor.
That's
The,
what, madam.
respondent is none other than the brother of this petitioner.
For dismissing the petition, of course, some reasoning has to be given by the trial court,
Please,
and it
madam.
has given.
Please, madam.
But the request that is being made is, it should not come in the way of the petitioner if he files if she files a suit seeking declaration that there is already a finding given by the small causes court. Angagbardu.
Please, madam.
The petitioners small causes case seeking ejectment of the respondent herein and for delivery of vacant possession of the suit scheduled premises to the petitioner has been dismissed by the learned small causes judge and small causes judge in SC number 288 of 2022. Full stop. Learned counsel for the petitioner, however, submits that the petitioner has a right to seek a declaration that she is the lawful owner of the property in question. Full stop. However, in the impugned judgment, there are several findings given by the learned judge touching upon the title of the suit scheduled property. Full stop. Attention of this court is drawn to
Paragraph 14, page 26.
paragraph number 14, where it is held that on perusal, ಅದು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ಕೊಂಬಿಡಿ A to A ಅಂತ ಮಾರ್ಕ್ ಮಾಡಿರ್ತೀನಿ, ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ತೀನಿ.
Paragraph 14, 18 and 20, 3 paragraphs.
ಇದು ಪರವಾಗಿಲ್ಲ. 18 is all right because in the last portion it is clearly said
Dispute of fact.
admittedly this is not a case of declaring title ownership ಅಂತ ಬಂದಿದೆ ಇದರಲ್ಲಿ. So 18 may not be necessary.
Paragraph 20 ಅಲ್ಲಿ the difference declared as a co-sharer of the property. In page 32.
Again, in paragraph number 20, the following observations are made. ಇಲ್ಲಿ B to B ಅಂತ ಮಾರ್ಕ್ ಮಾಡುತ್ತೆ. Next para, learned counsel for the petitioner would therefore submit that the civil revision petition may be disposed of, upholding the judgment of the small causes judge insofar as the plea for ejectment made by the petitioner herein. Full stop. However, the said remarks which will come in the way of the petitioner who is entitled to seek a declaration of title may be expunged. Full stop. Next para, learned counsel for the respondent would however submit that the respondent has also filed a suit in OS number
7614 of 2023.
7614
of 2023.
seeking partition
Please,
and separate possession
please,
of the suit scheduled property
please. He along with the other siblings here.
along with the
Other
other
siblings.
siblings. The petitioner along with the other siblings. Full stop. The learned counsel would therefore submit that in a suit for ejectment, the court is required to consider the plea of the plaintiff who contends that she is the landlord, which would mean that she is the owner of the property. And therefore, the learned small causes judge has rightly made the findings in the impugned judgment, and no fault can be found in the impugned judgment. Full stop. Next para. Having heard the learned counsels and on perusing the petition papers, since the learned counsel for the petitioner has gracefully submitted that the impugned judgment can be upheld insofar as the rejection of the suit on the plea of ejection of the defendant is concerned.
Landlord tenant relationship, on that plea, my lord, it was rejected.
Having regard to the failure of the plaintiff to convince the court regarding the jural relationship of landlord and tenant between the parties herein. Full stop. However, the learned counsel is also right in his submission that the observations and findings in the impugned judgment touching upon the title of the property in question should not come in the way of the petitioner who is entitled to seek a declaration of title before the civil court. Full stop. Next para. Consequently, the petition is disposed of while upholding the impugned judgment. Full stop. However, the findings as extracted in this order, touching upon the title of the property in question, shall stand expunged to enable the petitioner to seek declaration of title in a manner known to law. Full stop. Ordered according.
Serial number 21.
Here for the petitioner. Defendant's revision, my lord, challenging or dismissal of their application and order 7 rule 11 A and D for the respondent is not. Lord, the petitioners are the mother and brother of the respondent.
He filed a suit.
He
filed a suit.
Yes, ma'am. The plaintiff filed a suit seeking a declaration that a power of attorney executed by her in favor of the second defendant is null and void, was a result of fraud played upon her by her mother and brother. Lord, an application was filed that the execution of the power of attorney is not denied by the plaintiff. The plaintiff says, I have executed. Lord, on the basis of the execution,
Plaintiff executed Power of
State will
attorney.
execute the power of attorney, my lord, in favor of second defendant. Does not deny the
Second
execution.
dependent on the sister.
Brother. Sorry, first defendant. Brother.
Brother. All right.
Thereafter, some 6 years later, she filed a suit before the court saying that this power of attorney is a result of fraud played upon me, and therefore the power of attorney is not binding on me, it should be declared as null and void. And all transactions made on the basis of the power of attorney should be cancelled. My first submission would be, my lord, if a person, my lord, who admits execution of a document, then comes before court and says, the fraud was played upon me at the time of execution, my lord, there will be no finality to any document, whether it's a sale deed or a power of attorney or any other transaction between any two
What
parties.
happened after, as a consequence of the power of attorney granted in your favor?
Yes.
What happened?
The property, my lord, belonging to our father, to the father, was transferred first to the mother, and mother thereafter executed a gift deed in favor of the son.
These are Christians.
They are propounding a will that P&SC is pending. In the will, they say the father has left a property in Kerala, bequeathed the property in Kerala in her favor. There are two properties, one in Bangalore and one in Kerala. She says the power of attorney which has been executed by her has been used now to transfer the Bangalore property first to the mother and then to the brother. And has sought cancellation of the power of attorney. But whether 6 years down the line, my lord, after executing a power of attorney, my lord, my humble submission is, it's not some person who is uneducated. She is employed in the US for the past 20 years, 25 years. But it is not open to her.
So you filed an application out of 7 Rule 11.
A and D, yes.
Huh?
Out of 7 Rule 11, A and D. Saying the suit lacks a cause of action and also is barred by limitation. But cause of action because...
Limitation. D is not for limitation.
But barred by law, barred by, under the limit, under law of limitation, section order 7 Rule 11D, if it's barred by law. Limitation Act says any suit for declaration must be filed within 3 years from the date of cause of action.
Yes.
Admittedly, she was aware that she executed a power of attorney, and now comes and says, I became aware of the contents of the power of attorney some 4 years after I executed the power of attorney. That contention in my humble submission cannot be raised, because then no document will have any finality. The trial court now holds she has taken the contention of
not a power of attorney
coupled with interest.
Coupled with interest.
It is coupled with interest.
It is coupled.
It is not
Let
coupled
me see
with
that.
interest. Yes. Page 40. But I will take your lordship to the relevant clause. She authorizes the brother to transfer the property to the mother. Lordship, can you see page 41? Clause 13. To sign on my behalf and transfer, convey, gift my share in immovable or movable properties to my mother.
Now, acting on this one,
7 months later, my lord, a gift deed or release deed was executed by the son and the daughter on behalf of her, my lord. Her brother also executed the release deed in favor of the mother. No,
all right.
The only contention that I'll have before your lordship is this, my lord, that a person who executes a document, when I can understand if she says fraud is played, it's a fabricated document, my signature has been forged. That is not the contention. She admits that she's executed the power of attorney. At that time, I was under distress. I did not see the contents. So whether such a contention could be countenanced, my lord. Para 23 of the plaint, my lord, at page number 88. About 8 lines, my lord, from the foot of the page. Page 88, my lord, paragraph 23 of the plaint. The plaintiff, who was in agony and had no reason to distrust the defendants, believing the defendants as she had faith and trust in her mother and brother, executed the document without properly reading and or understanding that the said document was a power of attorney, and without understanding the powers that she had conferred on her attorney. It is only now that the plaintiff has fully understood that she was made to sign a power of attorney in favor of second defendant, authorizing to do various acts, deeds, and things for and on behalf of the defendant.
Yes.
So the execution is not very plainly admitted. And in the cause of action, my lord, that's at page number
94 at para 38. It's a very, humble submission, it's a very vague cause of action that's pleaded. Para 38.
Yes.
The cause of action for the present suit arose first on 31/5/2012 upon the execution of the last will and testament of late Mr. Boniface William. Thereafter, on 11/1/2017, upon the death of late Mr. Boniface William, the cause of action for the present suit also arose on 18/1/2017 on the purported execution of the general power of attorney. And again, on 18/1/2017, on the execution and registration of the release deed by the second defendant in favor of the first defendant. That is an incorrect statement. That execution of the power of the release deed is on 31/8/2017. But this is the only ground on which I have filed this application in order 7 rule 11 before the trial court. And the only ground on which it's rejected is the contention taken as fraud. Therefore, it's a bundle of law and fact. The trial has to be conducted. In the face of a categorical admission that power of attorney has been executed, I'm sorry if I'm repeating myself. There would be no finality to any document. Even a registered sale deed, a person can come before court tomorrow and say, I was not aware of the contents. I was taken before the registrar. And
Yes. It is open for him to say.
The litigation,
I know I have executed, but for these reasons, it has to be set aside. Is it not permitted?
litigation, but frivolous
According to
litigation.
you,
Yes.
if once he admits, I have executed, that is the end of the matter. No, not so.
Similar contention was taken before the Honorable Supreme Court. In an identical matter, there it was a sale deed. The Honorable
Anyway,
Supreme
it's a
Court
matter of evidence, sir. It has to go through trial. At this stage,
may I make
the
this,
plaint cannot be rejected.
may I make this request?
Yes.
Preliminary issue regarding limitation if it is not framed.
Of course, you have to raise, you can raise.
I've raised the issue.
Yes, yes.
But just one judgment of the Honorable Supreme Court, just for your Lordship's kind consideration.
Yes.
Para 2, page number 2, just the facts in 2 paragraphs. The respondents here in original plaintiffs have filed the respective suits before the Learned Trial Court for cancellation of the sale deed executed by the plaintiffs in favor of the appellant, original defendant, as null and void, and also to declare that the plaintiffs are the absolute owners of the suit scheduled property and consequently restrain the defendant from in any manner alienating the suit scheduled property. Having been served with summons of the suit, the original defendant appellant herein filed applications before the Learned Trial Court to reject the respective claims in exercise of powers and order 7 rule 11D of the CPC, mainly on the ground that the respective suits were clearly barred by the law of limitation. The said applications were resisted by the plaintiffs by submitting that the sale deeds dated 12/9/2005, 19/9/2005, 22/9/2005, 29/9/2005, and 30/9/2005, for which the relief to cancel the same has been paid in the suit was obtained by fraudulent misrepresentation and was obtained by fraud. According to the plaintiff, by a fraudulent misrepresentation of the character of the document, that is, as if it is a joint development project, the defendant got the sale deeds and the plaintiff, without knowing the contents of the documents, have executed the said deeds. According to the plaintiffs, they came to know about the same only in April 2015, and immediately thereafter they had filed the present suits. The Learned Trial Court dismissed the applications on Order 7 Rule 11 CPC by observing that the issue of limitation is a mixed question of law and fact, and therefore the respective prayers are not required to be rejected at this stage in excess of powers and Order 7 Rule 11D of the CPC. Not para 13 then. It is submitted that there is a specific cause of action period in the respective claims, and there are allegations of fraud, and it is the case on behalf of the plaintiffs that the sale deeds documents are the result of fraud and sham, and from the date of knowledge in the year 2015 thereafter, immediately the respective suits were filed. It cannot be said that the respective suits are barred by limitation. Thereafter, para 24, at the outset, it's required to be noted that by filing the respective suits, the original plaintiffs have prayed to cancel the registered sale deeds which were executed by the original plaintiffs. The respective suits have been filed in the year 2015-16, that is a period after 10 years from the date of execution of such registered sale deeds. Therefore, the defendant filed the applications and prayed to reject the respective claims in exercise of powers under Order 7 Rule 11D of CPC on the ground that the suits are clearly barred by the law of limitation. On the other hand, it is the case of on behalf of the plaintiffs that as the sale deeds documents got executed by fraud and misrepresentation, and the plaintiffs signed the said documents, believing or treating it as joint venture agreement, and the plaintiffs did not go through the contents of the said documents, and as in the year 2015, the plaintiffs came to know about such fraud and obtaining the documents, sale deeds by misrepresentation, considering Section 17 of the Limitation Act, the said suits cannot be said to be barred by limitation. It is a case on behalf of the plaintiffs that in any case, the question of limitation being a mixed question of law and fact, and therefore in the facts and circumstances of the case, the plaintiffs may not be rejected in the exercise of powers under Order 7 Rule 11 DCPC. It is the case on behalf of the plaintiffs that while considering the application of Order 7 Rule 11, the allegations and averments in the plaintiffs are required to be considered. Thereafter, para 28, if you're asked to defend it. Therefore, even considering the averments and allegations in the plaint only, it can be seen that even according to the plaintiffs, the cause of action for the suit arose on 19/9/2005, the date on which the plaintiffs executed the sale deed in favor of the defendant. In paragraph 21, while considering the cause of action, it is further averred that the cause of action has arisen on 1983, 7/7/1989, 7/1/1994, 1/4/98, 1/4/98 when the High Court quashed the entire acquisition proceedings. From the aforesaid, it can be seen that most of the cause of action alleged are much prior to the execution of the registered sale deeds. Even the averments and allegations with respect to knowledge of the plaintiffs averred in para 19 can be said to be too vague. Nothing has been mentioned on which date and how the plaintiffs had the knowledge that the document was obtained by fraud and or misrepresentation. It is averred that the alleged fraudulent sale came to the knowledge of the plaintiffs only when the plaintiff visited the suit property. Nothing has been mentioned when the plaintiff visited the suit property. It is not understandable how on visiting the suit property, the plaintiffs could have known the contents of the sale deed and or knowledge about the alleged fraudulent sale. But even the averments and allegations in the plaint with respect to fraud are not supported by any further averments and allegations how the fraud has been committed or played. Mere stating in the plaint that a fraud has been played is not enough, and allegations of fraud must be specifically averred in the plaint. Otherwise, merely by using the word fraud, the plaintiffs would try to get the suits within limitation, which otherwise may be barred by limitation. So this is ultimately the applications were allowed. But about the same para 31, about 4 lines from the bottom of the paragraph, plaintiffs cannot be permitted to bring suits within the period of limitation by clever drafting, which otherwise is barred by limitation. At this stage, a recent decision of this court in the case of Raghavendra Sharan Singh is required to be referred to. In the case of Raghavendra Sharan Singh Supra, in the said decision, this court had occasion to consider all earlier decisions of excess of powers and Order 11 or 7 Rule 11 CPC, which are considered by this court in paragraph 6.4 to 6.9 as under. While considering the very same provision, Order 7 Rule 11 CPC and the decree of the trial court, in considering such application, this court in para 5 has observed and held as under. We have not the slightest hesitation in condemning the petitioner for the gross abuse of the process of the court repeatedly and independently resorted to. From the statement of facts found in the judgment of the High Court, it is perfectly plain that the suit now pending before the First Municip's Court, Bangalore, is a flagrant misuse of the mercies of the law and receiving plaints. The learned Municip must remember that if on a meaningful, not formal reading of the plaint, it is manifestly vexatious and meritless in the sense of not disclosing a clear right to sue, he should exercise his power under Order 7 Rule 11 CPC by taking care to see that the ground mentioned therein is fulfilled. And if clever drafting has created the illusion of a cause of action, nip it in the bud at the first hearing by examining the party searchingly under Order 10 CPC. An activist judge is the answer to irresponsible lawsuits. So thereafter, several other judgments of are referred to. And then para 32 is the conclusion at page 8. Para 32 para 6.9. In Ram Singh, this court has observed and held that when the suit is barred by any law, the plaintiff cannot be allowed to circumvent that provision by means of clever drafting so as to avoid mention of those circumstances by which the suit is barred by law of limitation. Applying the law laid down by this court in the aforesaid decisions on exercise of powers and Order 7 Rule 11 CPC to the facts of the case on hand and the averments in the plaint, we are of the opinion that both the courts below have materially erred in not rejecting the plaints in exercise of powers under Order 7 Rule 11 DCPC. Respective suits have been filed after a period of 10 years from the date of execution of the registered sale deeds. It is to be noted that one suit was filed by the minor, which was also filed in the year 2006, in which some of the plaintiffs herein were also party to the said suit, And in the said suit, there was a specific reference to the sale deed dated 19/9/2005. And the said suit came to be dismissed in the year 2014. Immediately thereafter, the present suits have been filed. Thus, from the averments in the plaint and bundle of facts stated in the plaint, we are of the opinion that by clever drafting, the plaintiffs have tried to bring the suits within the period of limitation, which otherwise are barred by limitation. Therefore, considering the decisions of this court in the case of T.R. Aribindan Dandam and other decisions of Raghavendra Sharan Singh, and as per the respective suits are barred by the law of limitation, respective claims are required to be rejected in excess of powers and order 7 to 11 CPs.
See, this is a case where sale deed or a registered document is not executed.
Yes.
It's a case where power of attorney is given.
True.
There is a lot of difference. Power of attorneys are given to the family members. We do not know for what intention. There can be cases where there is a clear intention of giving up the rights. In some cases, it is not a case of giving up rights. And by execution of a power of attorney, no person can be declared to have given up the rights. So here, it's not a registered document which is executed and registered by the plaintiff. It is only between the family members now. Unlike all the other cases where sale deeds are executed. Then after executing a sale deed, if we allow a person to come before the court and make all this contention, take up all these contentions, it is different. Here, a power of attorney is given to the brother.
Yes.
To do something in favor of the mother, not in favor of a third party. And let me see, you were saying it's a power of attorney coupled with interest. Let us see that.
It is not. Page number 40.
Yes. Where is it?
Para 13. To sign on my behalf and transfer.
What do you mean coupled with interest?
The right to alienate.
That is not coupled with interest. There are power of attorneys executed along with a
sale agreement of sale or any other document too.
And a receipt for having received money. So you cannot say it's a case where the power of attorney is coupled with interest.
No, there's also one other averment made in the plaint, just for the last submission. So far as the prayer in the plaint, prayer C, my lord, B and C, she's claiming, my lord, that release deeds executed and also the gift deed executed in respect of property in Bangalore should also be declared as null and void.
Huh?
Lord, B and C.
Page number?
Page number, my lord, 95.
Declaring that the release deed.
Yes, sir. Dated 31/8/27 registered
executed by the brother.
By the
in
brother
favor of the mother.
The mother
On behalf of
the strength
also.
on the strength of the power of attorney.
Yes.
She claims, my lord, in the suit that she has no claim over that property at all.
Huh?
In the suit, she states very clearly that I have no claim over that property in Bangalore because my father left a will leaving a property for me in Chennai. Over Bangalore property, I have no claim at all. Is the averment in the plaint. And yet, my lord, she seeks cancellation of deeds, my lord, so far as the Bangalore properties are concerned.
Cancellation, declaration.
Declaration?
They have on the basis of this.
Declaration that the release date.
Release deed is not binding. On my second on the strength of this release, on this strength of this power of attorney, my lord, this release deed and the gift deed were executed, purportedly claiming my share also has been transferred to the mother. So obviously, as a consequence of that power of attorney, if it is not, it's void. Obviously, these documents, I'm not saying cancellation because I cannot seek cancellation of the document. I'm saying it is not binding insofar as whatever purported share that they are claiming is concerned.
No, but if you are saying
my lord,
your father has left behind a will and under the will, You have been given only that property.
I have only been given that.
Then why are you
Because
agitating this?
what has happened is, my lord, if I leave these documents as this, then it is completely contradictory, because the power of attorney I'm saying is null and void. Now, on the strength of the same power of attorney, two other documents are executed. Obviously, I have to seek for those documents. I don't have because those are on the strength of an illegal and null and void power of attorney.
So your first prayer is concerning the power of attorney. Once there is a declaration that the power of attorney itself is
because the specific relief act mandates that if a
may
document,
in fact harm them.
Correct.
If it is left like that,
no, it harm.
the
Correct.
release deed
Correct.
Executed by your brother
Correct.
in favor of your mother.
Correct.
How far it will have the strength to convey the property and further that to be sold in favor of a third party. It is their headache.
Correct. That to that extent, yes, but
There was no need for you to have made this prayer.
if you look at it, my lord, strictly legally, it may not be a thing, because cancellation under the specific relief act, if a document is left in such a manner, because there's a registered instrument where they specifically state that the power of attorney has been executed by me.
So that
And nevertheless,
property
my lord,
at Chennai,
Kannur, my lord, that has been bequeathed to me, and there are TOS proceedings pending before this honorable court. And I've restricted my claim only to the Kannur property. In any event, I cannot claim the Bangalore property. The TOS proceedings are pending, they are representing.
therefore, this prayer at annexure B and C, insofar as Bangalore property is concerned.
It may be nugatory, but that may not result in rejection of the claim.
Let them make a submission, my lord, that they have no claim over that.
Well, I've made it on a pleading. I've
ಅಲ್ಲ,
stated
ಇದೆಯಾ
so.
ಇಲ್ಲ ಇದೆಯಲ್ಲ
But
Now,
TOS
now, in
restricted
terms of the bill,
Yes, and
only the property at Kannur is
Is what she's claiming.
I've sort of filed a TOS
Will
restricted.
not, she will not have any right in respect of this property at Bangalore. And your P&AC case is only in respect of
Only in respect to the Kannur
Kannur
property.
property.
They also are participating in those proceedings.
Very well.
ಬರ್ಕೊಳ್ಳಿ. The petitioners are defendants in OS number 881 of 2023. And they are aggrieved of the rejection of their application filed under order 7 rule 11 bracket A and D of CPC. Full stop. The respondent, plaintiff, is the son of petitioner number 1,
Daughter, my lord.
daughter of petitioner number 1 and a sister of petitioner number 2. Full stop. The parties shall be referred to in terms of their ranking before the trial court. Full stop. Next para. The respondent plaintiff filed the suit seeking a declaration that the general power of attorney dated 18/1/2017 executed by her in favor of
Second defendant.
the second defendant. ಅಲ್ಲಿ first defendant ಅಂತ ಬಂದಿದೆ prayer ಅಲ್ಲಿ.
Two.
In favor of the second defendant has been obtained by the defendants by fraud, misrepresentation and undue influence, and is therefore not binding on the plaintiff. Semicolon, for declaration that the release deed dated 31/8/2017, which was subsequently registered before the sub-registrar Gandhinagar, on the strength of the power of attorney said to have been executed by the plaintiff, is not binding on the plaintiff. Semicolon. Declare that the gift deed dated 31/8/2017, once again registered before the sub-registrar Gandhinagar is also not binding on the plaintiff. Full stop. It is the contention of the plaintiff that the second defendant brother got the power of attorney executed at the hands of the plaintiff by misrepresenting her that in her absence, the mother and brother may require her consent to do certain acts in respect of the property in question. And it was never told to her that she is giving up her rights in respect of the immovable properties.
Not in respect of the property.
Huh?
In respect of accounts. My contention was in respect of bank accounts of my father. I'll schedule illa GP nalli property ಬಗ್ಗೆ.
ಹೌದಾ?
Schedule illa. That is what if I'm allowed at
ಹೇಳ್ತಾರೆ plaintiff submits a difference that explicitly represented to her that the document will
property
require-
schedule illa.
Sir, 1 second. For purposes of accessing the accounts by their mother and for dividing and settling estate of father. Para 24, page 89.
Accessing accounts, I have specifically
And
stated.
dividing and settling.
For
Para
page,
24, page 89.
not page 40, power of attorney ನೋಡಿದ್ರೆ, there is no schedule for this property.
ಏನದು? And ಹೇಳಿ ಇನ್ನು immovable property. Full stop. On the other hand, what is stated in the power of attorney is only regarding the bank accounts.
Bank accounts.
And no description of the property is shown in the power of attorney. Full stop. Next para. The defendants filed an application under Order 7, Rule 11A and B, contending that the plaint should be rejected since there is no cause of action for filing the suit and that it is barred by limitation, since admittedly the power of attorney was executed on 18th of January 2017. The release deed and gift deeds were executed on
31/8/17.
31/8/2017, and the suit is filed on
2023.
My lord, the suit is filed on 24/3, sorry. 24/5/2023, my lord, sorry. 24/5/2023. 23.
Beyond the period of 3 years. Which is provided for seeking such a declaration in respect of a document. Full stop. Next one. We will continue at 2:30.
My colleague will be.
All right.
24th office obligation, complete here.
Not now.
ಸೀರಿಯಲ್ ನಂಬರ್ 40 ಆರ್ಡರ್ 14% ಡೇಟ್ ಕೊಟ್ಬಿಡಿ.
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. 20 ಆದ್ರೆ 12 ಟೈಮ್ ಇದೆ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್. ಕೇಳ್ಬೇಕು ಅದನ್ನ.
ಯಾರ್ಗೆ ಹೊಟ್ಟೆ
ಏನ್ ಮಾಡ್ತಾರೆ ಗೊತ್ತಿಲ್ಲ. ಇದು ಯಾವ್ದು ಇಲ್ಲ ಅದು ಅರ್ಜೆಂಟ್ ಆಗಿ
ಸರ್ ನನ್ನ ಟೈಮ್ ಕೊಡ ಡೇಟ್ ಕೊಡು.
ಡೇಟ್ ಕೊಡಕ್ ಬರಲ್ಲ. ಅದು ಸಾಹೇಬ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡೋಣ, ರೀಚ್ ಆಗುತ್ತೋ ಏನ್ ಮಾಡ್ತಾರೋ ಕೊಡ್ತಾರೆ, ಡೇಟ್ ಕೊಡ್ತಾರೆ.
ನಾನು ಇನ್ನೂ 1:15 ಆಗಿಲ್ಲ ಅಂತ ಮಲಗ್ಬಿಟ್ಟೆ.
ಯಾವ್ದು ಅರ್ಜೆಂಟ್ ಆಗಿಲ್ಲ.
ಹೌದು ಹೌದಾ ಅವ್ರು ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಚೆಕ್ ಮಾಡಿ. ಹೌದು ಮುಗಿದೆ ಸರ್.
ಬಂದಿದ್ದೀರಾ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಂದ್ರಲ್ಲ ಏನ್ ವೀಕ್ ಯಾಕಂದ್ರೆ ಹೇಳ್ತಾರೆ ಟೆಂಟೇಟಿವ್ ಅಂತ ಹೇಳಿದೀವಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರೆ ಹೇಳಕ್ಕಾಗಲ್ಲ ನೀವು ಮುಖ್ಯರು ಮೂವ್ ಮಾಡಬೇಕು ಅದೆಲ್ಲ ಪ್ರೊಸೀಜರ್ ಹೇಳಿದ್ಮೇಲೆ ಬರ್ತೀವಿ ನೀವು ಡೇಟ್ ಕೊಡಲ್ವಾ ನಾವು ಕೋರ್ಟ್ ಡೇಟ್ ಕೊಡಲ್ಲ ಹೌದಾ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಂದ್ರಲ್ಲ ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರೆ ಯಾವಾಗ ಬರ್ಬೋದು ಇಲ್ಲ ಮುಂದಕ್ಕೂ ಬರ್ಬೋದು ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಮೂವ್ ಮಾಡಬೇಕು
ಬಟ್ ಅಲ್ಲಿ ನಮ್ ಲಾಯರ್ ವಿಚಾರಿಸಿದ್ರೆ ಇನ್ನೂ ಅಲ್ಲೇ ಫೈಲ್ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು.
ಹಾಗಾಗಿ
Gone for long.
Tomorrow there's my interview, no?
ಏನ್ ಮುಗ್ಸಕ್ಕೆ?
ಹಾ,
ಡೇಟ್ ಕೊಡ್ತೀವಿ
ಯಾಕೆ?
ಸಾಯಂಕಾಲ ಆಗಿತ್ತು.
ಹಾ? ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಆಫ್ 12ನೇ
ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ, ಸಣ್ಣ ಪುಟ್ಟ ಇದೆ, ಅದನ್ನ ಅವ್ರು ಹೇಳ್ತಾ ಇಲ್ಲ.
ಹಾ.
ನೋಟಿಸ್ ಎಲ್ಲ ಕೈಗೆ ಕೊಟ್ಟಿದ್ರು, ಎಲ್ಲ ಇಶ್ಯೂ ಮಾಡಿದೆ.
ಹಾ.
ಅದೇ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ ಸ್ವಲ್ಪ ಇದೆ, ಸಣ್ಣ ಪುಟ್ಟದ್ದು. ಏನು ಅನ್ನೋದ ಹೇಳ್ತಿಲ್ಲ, ಇದೇನಿಲ್ಲ ಅಂದ್ಬಿಟ್ಟು ನೋಟಿಸ್ ಆಗಿದೆಲ್ಲ ಅಂತ ಇದು ಹೇಳ್ತಾರ. ನೋಟಿಸ್ ಆಗಿದೆಲ್ಲ ಅದೇನು ನಾನ್ ಕಂಪ್ಲೇಂಟ್ ಬೇಡ.
ಹಾ.
ದಯವಿಟ್ಟು ಅದನ್ನ ಇದು ಮಾಡಿ.
ಮತ್ತೆ ಈಗ ಯಾಕೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳ್ತಾ ಇದೀರಾ?
ಸ್ವಾಮಿ,
ಯಾಕೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳ್ತಾ ಇದೀರಾ ಈಗ?
ಅದೇ 3 ಜನಕ್ಕೆ ನೋಟಿಸ್ ಆಗೈತೆ.
ಹಾ?
ಕೈಲೇ ಒಂದ್ ಕೊಟ್ರು ಒಬ್ರಿಗೆ, ಅದನ್ನ ತಗೊಂಡು ಸರ್ವ್ ಮಾಡೋದು.
ಆಯ್ತ್ರಿ, ಇವತ್ತು ಬಂದಿರೋದು ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಆಫ್ ಜಸ್ಟಿಸ್ ಅಂತ. ಯಾಕೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳ್ತಾ ಇದೀರಾ ಈಗ?
ಅಲ್ಲ, ಕೇಳ್ತಾ ಇದ್ರು, ಅವ್ರು ಹೇಳ್ತಾ ಇಲ್ಲ. ನಾನು ಸುಮಾರು 3 ವರ್ಷದಿಂದ ಕೇಳ್ತೀನಿ, ಎಲ್ಲಾ ಮಾಡಿದೀನಿ.
ಹಾ, ಅದೇನು ಅಂತ ನೋಡೋಣ ಇರಿ. ನೀವ್ ಹಿಂಗೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳಿದ್ರೆ ಏನ್ ಮಾಡೋದು?
ಸಣ್ಣ ಪುಟ್ಟ ಇದೆ.
ನೋಡೋಣ, let us see. Yes.
Serial number 21, continuation.
Hmm? Huh? Huh. Forty-seven, 57, await service of notice of respond number 3, non-compliance of office objections. Huh. Huh. If it does not reach, then it will be listed next week. Anyhow, you need not be present. If that is the, we'll see. Yes.
Malad, may I make a mention, Malad?
For what?
Malad, serial number 46, Malad. Requesting Malad, withdrawal of writ petition. Memo has been already filed, Malad, as the matter settled out of court.
Huh?
Re-
Learned Counsel for petitioner has filed a memo dated 25/4/2020, 2023.
24, Malad. Memo filed on 24/5/2024. Withdrawal memo file date.
Memo for posting. Huh? Early the application. Sir, memo early. Memo for posting. You have not filed any other memo. Is it on
Malad,
10/1/2005?
Malad, I filed a memo on 25/4/2024, Malad. As the matter settled out of court, I have enclosed the loan closures letters also, Malad. (25/4/2024).
Counsel for petitioner has filed a memo on 10/1/2025 stating that the first respondent has settled the dues under one-time settlement scheme, and therefore the petitioner may be permitted to withdraw the writ petition. Full stop. Next para. The memo is taken on a court subject to all the exceptions. Accordingly, the writ petition stands dismissed as withdrawn.
Oblige, Malad. Oblige.
ಇಲ್ಲ ಇದು ಅವ್ರದ್ದು ಇದು.
Explanation, serial number 21. Application.
The trial court held that it is a well settled principle of law that while considering such an application filed under Order 7 Rule 11 of CPC, only the averments made in the plaint can be looked into. And since cause of action is a bundle of facts, and in order to ascertain the same, the plaint shall be read in whole, comma, the plaintiff and since the plaintiff has pleaded fraud, misrepresentation, comma, the time starts from the date of the knowledge as contemplated under Section 17 of the Limitation Act. Full stop. Further, it is held that in the present case on hand, the point of limitation is a mixed question of law and fact. The plaint cannot be rejected at the threshold. Full stop. Next, learned counsel for the petitioner seeks to place reliance on a decision of the Honorable Supreme Court in the case of C.S. Ramaswamy versus V.K. Senthil and others, 2022 SEC Online SC 1330. Where it was held that the suits were filed after a period of 10 years from the date of execution of the registered sale deeds. Full stop. Following the earlier decisions of the Honorable Supreme Court, it was held that if clever drafting of the plaint has created the illusion of a cause of action, the court will nip it in the bud at the earliest, so that bogus litigation will end at the earliest stage. Full stop. Learned counsel would therefore submit that since the plaintiff has admitted the execution of the power of attorney and the date of the power of attorney is
18/1/2017.
18/1/2017, the plaint is filed beyond the period of 3 years, and therefore, while applying the law of limitation, the plaint had to be rejected. Full stop. Next para. For contra, learned counsel for the respondent plaintiff submits that the power of attorney is not a registered document. Full stop. The power of attorney does not contain description of the suit schedule property, and a plain reading of the power of attorney shows that the plaintiff executed the same in favor of her brother, defendant number 2. When she was normally residing in United States of America, to take care of the bank accounts for payment of taxes to the concerned authority and for such other purposes. Full stop.
Para 13,
Huh?
para 13, page 41. To sign on my behalf and transfer convey gift my share in the immovable property.
Though at paragraph number 13, it is mentioned that power is given to the attorney to sign on behalf of the principal, on behalf of the plaintiff, and transfer bar convey bar gift her share in the immovable bar movable properties, in favor of her mother, nevertheless, it is an admitted fact that the power of attorney is not coupled with interest. Full stop. The plaintiff has not received any money from the defendants to give away her share in the immovable property. Full stop. Nevertheless, it is submitted that the trial court has rightly held that these are matters which are required to be considered after adducing evidence. And therefore, the trial court has rightly rejected the application. Full stop. The learned counsel would further submit that the plaintiff has also initiated proceedings seeking probate
grant of letters of administration.
for grant of letters of administration in respect of the will left behind by her father. Full stop. Next para. Having heard the learned counsels and on perusing the petition papers, this court is of the considered opinion that the decision cited by the learned counsel for petitioner in the case of
C.S. Ramaswamy.
E.S. Ramaswamy bracket Supra deals with cases where there are registered documents executed by the plaintiff. Full stop. The plaintiff therein had executed a sale deed in favor of the defendants. Full stop. However, in the present case, a general power of attorney was admittedly executed by the plaintiff in favor of her brother, defendant number 2. For performing various functions on behalf of the plaintiff. Full stop. Nothing specific is mentioned regarding the immovable property which forms the suit schedule property, and any specific reason as to why the plaintiff is giving up her rights in favor of her mother. Full stop. It is under these circumstances, the trial court has rightly held that the plaintiff has raised a ground of fraud and misrepresentation as against the defendants. Full stop. For the same reason, since the plaintiff had not executed the release deed and gift deed, she is permitted to contend that she was not aware of the registration of those documents. Full stop. She came to know about the said documents subsequently, and therefore the cause of action would arise from the date of knowledge to the plaintiff, which is permissible to be contended even in terms of section 17 of the Limitation Act. Full stop.
That's one submission that the date of knowledge has not been mentioned anywhere, my lords. The actual date has not been mentioned anywhere in the plaint.
She did not mention. She only says, I did not execute the release deed. I did not execute the gift deed. I came to know only subsequently.
The date of knowledge has not been mentioned anywhere. That is the reason, my lords, to calculate the limitation period of 3 years. I have mentioned the date of limitation.
Anyway, all these are matter of evidence.
Yes.
So therefore, at this juncture, the plaint cannot be rejected. Full stop. In the considered opinion of this court, no infirmity can be found in the impugned order. Full stop. The trial court has rightly come to conclusion that the averments made in the plaint are sufficient to hold that there is cause of action for institution of the suit, and the question of limitation, being a mixed question of law and fact, the matter can only be decided on merits after considering the evidence that could be brought on record by both the parties. Full stop. Next para. Accordingly, the civil division petition stands dismissed.
Well, it's the contention, the observations would not come in the way of final disposal of the suit.
Any observation during the course of this order shall not prejudice the case of either of the parties before the trial court.
And also I may be permitted to raise all these grounds before the trial court.
Already been raised.
You have already
We've
raised.
already raised all of
File
these.
my written statement yet before the trial.
Yes, yes,
Hey, no, your written statement is filed. Issues framed, evidence ಹೋಗಿದೆ.
all contentions are left open.
Great.
22. Jay Sanghavi.
Your lordship directed me to produce the citation regarding the whether the small causes court has jurisdiction. ತಗೊಳ್ಳಿ, ಕೊಡಿ. Title can't be adjudicated. Your lordship remembered that he filed 4 cases. 3 cases rightly came to be dismissed by the other court. I produced the copy saying that the plaintiff is not the owner. Even today, the khata stands in the name of case Sarvamangala, my lord. And they have not preferred any CRP against the 3 dismissal order. Here is the case. The Hemchandra, they filed a case. Hemchandra is not the owner. He produced the exhibit P2 khata certificate stand in the name of case Sarvamangala. And there is a family
For
dispute.
ejectment.
Yes, ejectment.
Ah,
3 suits came to be rejected on the ground that Hemchandra is not the owner, case Sarvamangala khata stands in the name. These are the 3 suits. But here in this case, the court has passed the decree without going through the objection evidence on record. The trial court has not gone through the khata certificate. The trial court has not gone into the evidence of the case. Your lordship may kindly call for the records, sir. I am producing the evidence, what they have led before the trial court. Your lordship will kindly see.
3 other
Euro totally he filed 4 cases.
for
Ejectment.
in respect of 4 different
Same, num shop. I myself is Nanu by
shops. Ah,
my husband, my wife. Continuously, there was one premises. Urian Madidru, it was bifurcated into the 4. Then they filed separate cases. So 3 cases came to be dismissed.
where
by
is
the
that?
trial court. Court copy. Tagoli. 1441, 4041, Kodi Savri. And they have not preferred any CRP. Tagoli, Kodi, copy. These 3 cases,
Hmm.
M. Chandra came to be rejected that he is not the owner. And they have not preferred CRP against this at all. Here also, they have not filed any caveat, and he has filed the execution case. The document.
There is a mention of those cases.
No, the
Huh?
judge says, other yaru yenadru order pass madli, I am not, this court, because different court. This was passed by court on number 15.
Where is that? In which paragraph?
SCCH 15, judgment copy.
Alla, which paragraph
Yavdu?
of this order have they mentioned about the previous
No,
cases?
no. In this case, they have not mentioned.
Saw it somewhere now.
Your lordship, yesterday, your lordship remembers I have argued the matter. Your lordship has gone through it, how the CRP is maintainable, and I have stated before your lordship. Your lordship has gone through this judgment.
That's all right.
Yes. Now the question is, your lordship will kindly see the written statement, what I have taken the objection. The trial court has not gone through the written statement. And the law says, the Supreme Court and High Court says that based upon the contention, what the defendant raised in his objections, and it has been proved by me. Exhibit P2, khata stands in the name of Sarvamangala. Your lordship will see the evidence of the PW1 cross-examination. I will give the copy. This is the 3rd round of litigation. They are filing cases after cases in order to blackmail the person. Your lordship will kindly see this.
27. Khata stands in the name of K. Salomangla. This is the document what they have produced. 27. Property stands in the name of K. Salomangla. And Hemchandra, how he has not proved before the trial court in what capacity he has filed the case. He has not proved that he is the owner or there was any partition deed. Nothing has been produced by the court. In evidence, he admits that he is not the owner. I will produce the evidence copy. This is my written statement, Your Lordship will get. Para 3, there is a serious dispute regarding ownership, that the plaintiff have not appeared before this honorable court with clean hands, that now they are the absolute owner in the scheduled property. Real and lawful owner in the respect of scheduled property was one K. Puttasamanna, son of Kadur Kalappa, K. Nanjundappa. The aforesaid K. Puttasamanna had no issues. That the K. Puttasamanna had 3 sisters, namely Sobhagyavati, Sarojamma, and Sardama. There was no partition between the family members, and all the aforesaid persons were the owner in respect of the scheduled property. Nobody, even I have taken the stand in para 4, that the khata stands in the name of K. Salomangla. The trial court, just 1 page, plaint has also not been reflected, 27. This is the written statement, para 3 and 4, Your Lordship may condemn. In other cases, suit has been dismissed, they have not preferred any CRP. So that is clear that they are not the owners, my lord.
Issue notice to the respondents. Next para.
Stay
Learned
mechanism.
counsel for the petitioner
Because they have filed it.
submits that 3 other small causes cases filed by the very same respondents in SC number 1440 of 2017, 1441 of 2017, and 1442 of 2017 were all dismissed
Yes.
by the learned 13th additional small causes and CJM, Bengaluru, practically SCCH 15, by judgments dated 23rd of July 2024. Full stop. However, this case in SC number 414 of 2018 has been allowed by the learned 14th additional small causes judge and ACJM, bracketly SCCH 10, by order dated 25th of July 2024. Full stop. This itself is sufficient to say, to contend that the impugned order requires reconsideration. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned judgment and decree dated 25/7/2024 in SC number 414 of 2018 on the file of so and so, till the next date of hearing.
Notice has to be issued. Summons.
Starting early then.
Earlier.
Number 23, B.K. Chandrasekhar.
23.
Judgment. My lord, in this matter, I undertake to file wakal for respondent
Learned counsel Sri
ಇಲ್ಲ ಅವರು ವಕಾಲತ್ ಹಾಕಿಲ್ಲ.
undertakes to, sir.
ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಬಟ್ ನಾಳೆ ಕೇಸ್ ಇದೆ, ಅಡ್ಜರ್ಮೆಂಟ್ ತಗೋಬಾರ್ದು.
Learned counsel Sri
G. Shankar.
G. Shankar.
Yes, I am appearing in the trial court, madam.
Undertakes to appear for
Respondent number 1, madam.
respondent number 1.
Yes, ma'am. They may be directed to serve copy.
Learned counsel for petitioner is directed to serve copy of a petition along with annexures on the learned counsel for respondent number 1.
Next week, any day.
Really, what is the,
Now, the application filed under order 7.
what about respondent number 2?
She has engaged a different
Mr.
lawyer. She engaged a different lawyer, madam.
Really, what is this matter about?
This matter is about rejection of my application filed under order 7, rule 11A and D.
Ah,
Now, the petitioner, who is the daughter of Shamanda,
all right, we will hear it next week. Issue notice to respondent number 2.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಹಿಂದೆ ಎಲ್ಲ ಡಿಗ್ರಿ ಆಗೋಗಿದೆ ಅವಾಗಲೇ.
Next para.
ತೋರಿಸ್ತೀನಿ ನಾನು.
At the request of learned counsel for respondent number 1,
Yes, madam.
release this matter on 22nd of January.
ನನಗೆ ಸ್ಟೇ ಕೇಳಿ.
Next
ಟೆಂಪರರಿ
week
ಪೀರಿಯಡ್
ಇದೆಯಲ್ಲ?
ಅಲ್ಲ, ಯಾಕೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅವ್ರು ನಾಳೆ
matter
ಹಾಕೊಂಡಿದ್ದಾರೆ, ಕ್ರಾಸ್ ಎಕ್ಸಾಮ್ ಹಾಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Yes,
number 4.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮ್ ಹಾಕಿದ್ದಾರೆ.
ಹೌದು.
ಆಮೇಲೆ ಅವ್ರು ಪ್ರೆಸಿಪಿಟೇಟ್ ಮಾಡದೆ ಹೋದ್ರೆ,
ಆಗ್ಲಿ ಒಂದ್ ವಾರಕ್ಕೆ ಏನು ಆಗೋದಿಲ್ಲ. Yes.
ಅಲ್ಲ ಅವ್ರು ನನ್ನನ್ನು ಮಾಡುವಂತ ಪ್ರೆಷರೈಸ್ ಮಾಡಿದಕ್ಕೆ ಇದು ಬೇಗ ಹಾಕಿರೋದು ನಾನು. ತಾವು
Cross examine
ಡೇಟ್
ಮಾಡಿ.
ನೋಡಿದ್ರೆ, ಅಲ್ಲ ಇದು ಡೇಟ್ ನೋಡಿದ್ರೆ
All right, all right.
2-3 ದಿವಸಕ್ಕೆ ಮೂವ್ ಮಾಡಿದೀನಿ.
We will see, yes.
ಸ್ಟೇಟಸ್ ಕೋ ಮೇಂಟೈನ್. ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ನಾನು ಆಲ್ರೆಡಿ ಐ ಹ್ಯಾವ್ ಗಾಟ್ ಎ ಡಿಗ್ರಿ ತೋರಿಸಿ ತಮಗೆ ಒಂದ್ ನಿಮಿಷ
Please
ನೋಡಿ.
come next week, sir.
ಒಂದೇ
We
ಒಂದ್
will
second.
see.
ಇಲ್ಲ ಅವ್ರು ಪ್ರೆಸಿಪಿಟೇಟ್ ಮಾಡದೆ ಹೋದ್ರೆ ನಾನೇನು ಇದು ಮಾಡೋದಿಲ್ಲ. ಲೆಟ್ ದೆಮ್ ನಾಟ್ ಪ್ರೆಸಿಪಿಟೇಟ್ ಅಷ್ಟೇ.
Yes.
ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಡೈರೆಕ್ಟ್ ದೆಮ್.
4.
2012 ಸ್ವಾಮಿ, ಒಂದು ಕ್ರಾಸ್ ಕಮೆಂಟ್ಸ್ ಮಾಡ್ಲಿ ಸ್ವಾಮಿ. 2012 ಇಂದ
ನೋಡಿ ಹೀಗೆ ಅಲ್ಲೂ ಅದು ಇದು ಸೇಮ್.
8
ಈಗ
years.
ಒಂದ್ ವಾರಕ್ಕವರೆಗೂ
ಏನ್
ಬಿಟ್ಬಿಡ್ರಿ.
ತೊಂದ್ರೆ ಇಲ್ಲ ಆಯ್ತು. I will not press
Learned counsel for respondent
ಒಂದು
number
ವಾರ
1
till next year.
gracefully submits that
I will not proceed.
ಯಾವ್ದು what is the date?
ನಾಳೆನೇ ಇದೆ, ನಾಳೆ.
The plaintiffs will not press for cross examination
Tomorrow.
of the plaintiff's witness tomorrow before the trial court.
Yes. I will.
Yes.
ಒಳ್ಳೆ
Passed over, serial number 4.
It's a matter pertaining to NCLT, Milords. The first petitioner is 99.99% shareholder of a company which is running a transport business called as SRS Transports. Lords, may kindly take the cost date, Milords. There is some significance to this. The petitioner number 1 and the first respondent are husband and wife. Now, Lords, may kindly take page number 22.
Petitioner number 1
And the first respondent are husband and wife. This company was belonging to
first
the
respondent is
Deepak.
Deepak.
Howdo.
First petitioner is
First petitioner is Mega.
Lords,
In the company, that's how, in the petition, that's how the name is reflected as reflected in the passport. This Mega and Deepak are husband and wife. This company was belonging to Rajshekar, SRS Travels. His name was Rajshekar. It was SRS Travels. Lords, when he constituted a company, what he did was, kindly have a look at page 22. Deepak Ramkrishna husband ge 10 share. 4,65,990 shares to the wife. That is the first petitioner. 99.996% or the 0.002% shareholding. Lords, husband started dwindling all the assets of this company. Secretly started selling all the buses. The wife was kept away. She was not aware as to what was happening because she completely relied upon the husband. Lords, the notices started coming under section 13(2) of the Surface Act saying that because most of the buses are financed. Lords, we went before the civil court at page number 32. Lords, at page number 40, an injunction order is granted against Deepak. Against the husband that he should not meddle with the accounts, he should not sell any of the assets. either by himself or through the officials of the company. That is injunction order is still operating.
Who are the others? Other defendants?
Lords, other defendants were the accountant. There was one chief accountant, there was one auditor, like this. These are all multiple persons who are the officials, my lords, who are working on the SRS. So this injunction order came to be granted. Lords, then we approached the DRT. Lords, if your lords were to see the application which is at page number 65. Lords, there is a financial debt which is due and payable by the company. Because there is one person who is holding 0.01% stakes. So he is not coming for any of the meetings. So we requested the court, either you appoint an ad hoc director because he is not cooperating, or you permit me to sell the buses so that the notices which are being issued under 13.2, I can address it. Lords, on this, the court passed an order, the NCLT passed an order at page number 85. Sorry, my lords, at page number 44. Page 44. At page 45. Petition and respondent number 2 are directed to maintain status quo in respect of assets of the company and not to sell the buses belonging to first respondent till next date. Respondent 2 is directed to attend the board meeting of the company, and petition is directed to send the notice. We have sent the notices, he has not attended. Then there is a company report which is called upon because we are requested for an ad hoc director. He said directed that second respondent himself has to come. We have issued the notices. He did not come and attend the board meeting. Now, the application was filed saying that there are notices which are issued. Kindly have a look at page 57 for a minute. Page 57. All the personal properties of the first petitioner are mortgaged for securing the loans of the buses. This is under section 13.2. Then again at page number 62, my lords, is a reply given. So we are getting notices, my lords, for this is in respect of almost about 25 crores. 25 crore rupees notice kalsidare. Now, we approached this honorable court earlier. Though we had filed a writ petition challenging the earlier order, we only said that let the NCLT consider the application for modification of the order, and the matter is slated on 16/12. And the matter came before this honorable court on 16/12. This honorable court passed an order which your lordships will find at page number 83, directing the NCLT to dispose of the application within a period of 1 week. Para 6 minutes at page 86. Lords, after this, we requested the NCLT to take up the matter. NCLT, my lords, obliged and posted the matter to 20th, 2012. 2012, my lords, when the matter was listed, the 1912, this Deepak goes and makes a mention before NCLT saying that I am not aware of the High Court's order, you adjourn the matter. The NCLT adjourns the matter to January 9th. We again go before the NCLT on 9th of January. There is no sitting. This is where I'm stuck, my lords. The NCLT, though we requested, again the matter is again listed on 20th of January. Lords, we are in a very dire straits. If I don't dispose of the, lords, may just pass on this memo, my lords, what happened before the NCLT and the manner in which the buses are lying. Because my husband entirely took control of the entire business. He swindled tons and tons of money. Let's kindly have a look at that memo. Lords, the photographs in particular, lords, I'll take your lordships to the other documents. Last page, lords, page nation, page number 9. All these buses are lying in the yard. We cannot operate. We have not paid the taxes. We are required to pay the taxes. We are required to disburse the entire loan amount. And I am the person who is holding 100% stakes less 0.002%. I have also produced, my lords, the proceedings of the NCLT. I produced a notification that there is no sitting. I have also produced a notification to show that NCLT sits only on Monday, Tuesday and Wednesday, only first half. Only second half, taking up the Bangalore matters. Now this is the difficulty with which we are placed.
What is
the
the praise
request?
now?
I'm only requesting, my lord, that we should be permitted to sell our own buses. That order could not have been passed. When I go before the court saying that you permit me to sell the bus, not participating. When the positive direction is given that yes, you are required to participate in the meetings, he doesn't come and participate in the meeting. My lords, I cannot be held left high and dry, my lords. I'm only requesting, I'll submit the accounts before this honorable court because everything, my lords, will have to take place in a transparent manner only. I'll submit all the accounts before this honorable court. Lordships may put me on terms.
Ella, ಈಗ next date of hearing is given
He's on 20th,
28th.
28th. ಹೌದು 60 ದಿನ ಮುಗ್ದೋಯ್ತು ಈಗ ಮತ್ತೆ 13 ಫಾರ್ ಅವ್ರು ಇನಿಷಿಯೇಟ್ ಮಾಡ್ಬಿಡ್ತಾರೆ. ನೋಟಿಸ್ ಇನಿಷಿಯೇಟ್ ಇಶ್ಯೂ ಮಾಡಿ.
This
25 ಕೋಟಿ ರೂಪಾಯಿ ಒಂದು ನೋಟಿಸ್ ಹಾಕಿದೀವಿ ಅದರಲ್ಲಿ
notification for 15th of January.
ಹೌದು.
Page number 9.
Yes, my lords.
It says on 15/1/2025.
Yes.
There will be no sitting.
Yes.
Of the NCLT Bengaluru bench. All cases will be re-notified for the next working day.
Yes.
Which is the next working day?
That is, my lords, this is only a notification to
Kelly, where do you get this?
My lords, previous page.
Date 28th.
My lords, it's on the website of the NCLT that the tentative date is 28th. Produce ಮಾಡಬೇಕು. It's only a tentative date given, my lords. It's not a confirmed date also. Lords, the previous page, 2nd January 25 is the notification which shows that it is sitting only between Monday to Wednesday, second half. We have brought it to the notice of the NCLT. This is the direction which has been given.
Monday to Wednesday.
Yes. Only second half.
Monday to Wednesday, second half.
So Monday to Wednesday, second half, ಅರ್ಧ ದಿನ ಕೂತ್ಕೋತಾರೆ ಆಮೇಲೆ ಮತ್ತೆ ಸಿಟ್ಟಿಂಗ್ ಇರೋದಿಲ್ಲ. ನಾವು ಅಡ್ವಾನ್ಸ್ ಮಾಡಿಸಿದ್ರು ಕೂಡ ತಗೊಳ್ಳೋದಿಲ್ಲ.
28th.
28th is what is reflected in the website, my lords, of the NCLT as a tentative date.
Next working day.
Pardon, my lords?
It says next working day.
Lords, this notification of 15/1/2025 is only to indicate, my lords, that there will be no sitting of the NCLT as member is on leave.
Correct.
All cases will be re-notified for the next working day and the same is directly to be uploaded on the website. Pursuant to this, now there are tentative dates mentioned saying that my matter is listed on 28/1. But where do you get this date 28?
Allah, it should be 20th or 21st or 22nd.
28th, my lords, it is listed.
28th, Allah, 20th it should be.
No, 28th is what is
20th is Monday. So it should be 20th. Not 28th.
Lords, it is 28th is what is told, my lords, in the NCLT.
Monday to Wednesday, they'll have to work.
Correct. 28th, my lords, is not
How
Monday.
can it be 28th?
Lords, 28th.
Next working day is 20th.
Lords, it is not listed on 20th. It's not listed. Now, the only thing is this, your lords may put me on any of the terms, my lords. I can even go to this extent, my lords, saying that the court can even appoint a person who can oversee the entire exercise. My lords, the company will dwindle down.
Issue emergent notice to the respondents.
The total loan is 350 crores.
Petitioners are also permitted to take out hand summons to respond number 1. Next para. Release this matter on 21st of January 2025. You please come.
Lordships.
Let us see if the matter is taken up on 20th.
Then I will have no grievance.
See what,
I go and argue the matter.
Yes.
Yes. Grateful.
Non-compliance of office objection for first time, serial number 24. You can't.
In this case,
24.
only 2 curable defects are there. He's running the workshop for eking out his livelihood. He borrowed some loan position has been taken over and action though is what
Then what the opposite?
office of represented by and the respondent
Representative of respondents to be stated.
responded ಅಷ್ಟೇ.
Prayer is
ಅದೊಂದು
restricted
ಆಮೇಲೆ
to
ಡೇಟ್ ಆಗ್ಬೇಕು ಇದಕ್ಕೆ
date.
ಪ್ರೇಯರ್ ಅಲ್ಲೂ ಡೇಟ್ ಆಗ್ಬೇಕು ಕ್ಯೂರೇಬಲ್ ಪ್ಲೀಸ್
Madi, we'll
That's
have it,
please.
we'll have it on 20th, if you comply with the office objections. Or 21st, list this matter on 21st of January. If the office objections are full stop. In the meanwhile, office objections will be complied with.
Please.
Yes.
25, J. Kumar T.
Back as issued a 7 days notice to vacate the position.
Office objections.
My lordship,
For office objections.
para number.
Same order, 21st.
My lordship, para number wrongly mentioned, my lordship, but that is the one.
Huh?
Para number wrongly mentioned, that is the only objection. my lordship.
Appear for responding, permit me to file.
I will deposit.
Learned Counsel Sri
Yes, Lakshmi Narayan.
S. Lakshmi Narayana, who is present before the court, undertakes to appear for the respondent. Really.
My lordship, the respondent bank has issued a notice to vacate the possession, physical possession, to take physical possession, my
Yes.
lordship.
Yes.
The scheduled property is house property, my lordship.
Huh.
I will deposit 20% of
Yesterday outstanding amount,
Out as on date, 66,73,000.
66 lakhs.
73,000
10
plus
lakhs,
interest.
10 lakhs.
ನಿಮ್ಮ
something
notice
is-
ಪ್ರಕಾರ
Notice, copy.
Notice, my lordship, annexure B, my lordship. They have not mentioned any figure of amount, my lordship.
Copy the report. Petition.
And in annexure B, my lordship, there is no mention the amount, my lordship.
Why have you not mentioned the amount, outstanding amount? Huh?
Lordship,
Lord, in physical possession annexure, page 18, my lord, B.
Huh.
It is
If
only
you
they
have a
made
copy of
notice.
the notice issued under 13-2, please
Please.
point out what is the amount
No, my lord,
outstanding.
I have not, I only have instructions to appear on behalf of Lord.
Hmm.
Take instructions and submit, but as on date, the outstanding is 66 lakhs.
orally submitted, my lordship. In fact, my lordship, 10 lakh something, 10 lakh around my lordship. Is due, my lordship.
ಹೆಂಗ್ ಹೇಳ್ತೀರಾ ನೀವು? How are you saying?
Lord, permit to statement. There are two loan accounts, my lord. One is top-up loan and principal loan, both sides. my lord. Pardon, my lord, I've taken two sides. Second page also, my lord, the outstanding.
ಅದೇ ಎರಡು ಸೇರಿಸಿ
ಹೌದು,
66, 73, 456.
please. As on date.
I will deposit 20%.
ಎಲ್ಲ ಹಿಂಗ್ ಹೇಳದೆ ಹಿಂಗೆ.
But can be disposed of with the 3 months time period, my lord, to close the entire loan. If he is filing in undertaking.
Already, they can at least pay the outstanding EMIs and get the account regularized.
As on date regularization, if they approach, my lord, they might get an opportunity. That, my lord, ಅದು already 14 section order pass agi, it has gone for possession. Only thing is left is, my lord, sale notice. to be- Or it may be disposed of, my lord, with the direction of 3 months, my lord, if they close the entire loan amount, 66 lakhs.
Why should they close the
Entire
entire
loan
loan
amount
amount?
is-
Let them pay the outstanding
But,
EMIs and get it regularized.
My lord, NPA might have been declared, my lord, in the year somewhere 21 or 22, my lord.
Huh?
ಇಲ್ಲಿಂದ non-performing assets ಆಗಿರುತ್ತೆ ಸ್ವಾಮಿ. Or else I might be, next week ತಗೊಂಡ್ರೆ, my lord, I'll give the, take instructions and furnish the.
Learned counsel for the petitioner submits that the residential premises
Please.
belonging to the petitioner has been mortgaged to the respondent bank. And if this court does not stay all further proceedings, the respondents will take possession of the property and the petitioner will be brought to the streets. Full stop. The learned counsel would further submit that the petitioner will make all efforts to pay the outstanding EMIs and get the loan account regularized
Please.
if reasonable opportunity is given to the petitioner. Full stop. Next para. Learned counsel for the respondent submits on instructions that the outstanding loan amount in the two accounts of the petitioner is rupees 66,73,456
As on date.
as on 14th of January 2025. Full stop. Next para. Consequently, the respondent is directed not to precipitate the matter any further till the next date of hearing, subject to the petitioner depositing 20% of rupees so and so,
Please.
with the respondent bank within a period of 4 weeks from today. Full stop. Next para, release this matter on 18th of February.
Please, my lord. Page 13 of the petition, my lord, NPA was declared in 2020 July.
Let us see. Yes.
Number 26, Sandeep Gowda, GB.
The only office objection is that, my lord, the deficit court fee that is paid, my lord, morning. Deficit court fee that is paid, my lord.
Learned counsel for the petitioner submits that the deficit court fee has been paid in the office on
Today, my lord, 15, today, my
this morning.
lord.
Stop. Office to verify.
My lord,
Yes.
my lord, this is pertains to, my lord, the now annexure E, the sale notice has been issued by the respondent bank. Outstanding due, my lord, 7,26,000. It is the husband of the first petitioner, my lord, has borrowed the loan for housing loan, 15 lakhs. He died, my lord, due to cardiac arrest on, my lord, on 8/10/2023. That loan is insured with, my lord, United Indian Insurance. Since the insurer, my lord, they failed to, my lord, the pay the outstanding dues, my lord, the proceedings has been initiated before the district forum, annexure A. And there is an order from the district forum, my lord, on 4/5/2024. The direction has been issued to the insurer to pay the outstanding dues of the housing loan for a sum of rupees, my lord, 6,79,559 along with interest, 6% interest.
I am really not able to understand what is this
My lord,
substance that is being made, that the insurance company will pay the EMI.
my lord, with the understanding with the bank, my lord, the same that the loan has been insured with the, my lord.
The property will
yes.
be insured.
My lord,
That is the requirement of the RBI. Repayment of the loan will not be insured, sir. Why would some insurance company come and take on this responsibility of paying the EMI?
in case
Your
of death.
property will be insured.
Yes, my lord, in case of death,
Yes.
my lord, the direction has been issued to the insurer to pay the outstanding dues.
No.
As against that, my lord, now the insurer has preferred an appeal and 75% of the, my lord, the
Same
claim
submission
amount.
was made in the
Yes,
morning in some
yes,
other
in
case.
serial number 3, my lord. same.
Cannot be, sir. ಅದೇ ತರದ ಒಂದು ಸಬ್ಮಿಷನ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದೀನಿ ನೋಡ್ರಿ.
Serial number 3.
ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಏನೋ ಬಂದಿದೆ ಅದರಲ್ಲಿ. ಇದ್ರಲ್ಲಿ ಯಾವುದು? ಇದು ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ.
ಇದರಲ್ಲೂ ಯುನೈಟೆಡ್.
Same. Before the district consumer redressal forum at Kodagu in CC number 1 of 2024. The amount repayable is rupees 7,83,556.
Final notice ಅಲ್ಲಿ 7,26,177. In page number 37. Sale notice ಅಲ್ಲಿ. In page number 37. Annexure E. Total liability as on 17/12 is 7,26,177. 37, my lord, page number.
7,26,177. Same order. 20% has to be deposited
Please.
within 4 weeks. Yes,
Subject stay, my lord.
yes.
Yes.
18-12. Number 27.
I appear for the petitioner, my lord. I will comply the office objections. Lord, in the meantime, my lord, in the earlier round, Mr. Madhukar Deshpande had appeared for the Union of India, my lord. Office has raised an objection saying that the Union of India address is shown as, respondent number 1 address is shown as New Delhi and other 2 respondents are in Chennai and Kerala.
There is no interim prayer.
No interim prayer. It's only a format.
Ian, what
Allah.
is the urgency? You comply with the office objections.
Yes, my lord. Could it be taken up on 21st, my lord? Because respondent Union of India is not taking the copies, my lord, despite they being the parties.
Allah, there are 9 office objections.
I will comply. No, partly if all have been complete, my lord, partly there is a few office objections. I will comply it.
If office objections are complied, release this matter. I'll list this matter for preliminary hearing on 22nd of January.
Please, my lord. Oblige.
28. Number 28.
Okay, I appear for the petitioner, my lords. There are 2 office objections. I'll comply it, my lords. Because I filed a writ of mandamus
Yes.
to direct the police to assist me in taking physical possession of the property. I'm a nationalized bank, my lords. I have to recover more than 375 crores.
Why you should file a writ petition for that?
My lords, because I have obtained an order from the learned magistrate. However,
Ah.
the police is not assisting me in taking possession of the property. My lords, the order is produced at Annexure D, page number 45. Because thereafter, I've given 2 representations as well, which is at Annexure E, my lords, on 25th September 2024 and 29th November 2024. Since I've not received any response, my lords, therefore I approached this court. Coordinate bench of this court has passed such orders, my lords.
Huh?
The coordinate bench of this court has passed similar orders directing the jurisdictional police to assist the.
Which is the order passed by the magistrate?
Was Annexure D, page number 45. Was passed on the 1st of February 2023. The operative part is not page number 52. 52 and 53.
The borrower entered appearance before the magistrate? No.
The borrower is usually not heard.
Huh?
The borrower is usually not heard in a section 14 application. It is the bank.
But for
They have
what
made a
purpose do
party.
you make them parties then?
My lords, because it is against them, we make them a
So
party.
therefore, that is the question
Please.
coming from the court. Did they appear or notice was not issued at all?
No,
Notice has to be issued.
But in a section 14, it's not,
Then for what purpose do you make them parties then?
my lords, to show that their property is being.
I don't think that would be with the position of law. So notice is not issued. Huh?
My lords, mine's, as far as I,
Because the order also doesn't say that notice was issued and they have remained absent. Nothing is there. Where is the representation given to the police?
it's at annexure each page number 55. I've given two letters, my lords. One is at page number 55. The second one is at page number 58. One is dated 25th September, the other is 29th November 24.
Yes, please take instructions.
I'll take notice, my lord. Correspondent number 1.
Learned AG takes notice for respondent number 1. Issue notice to response number 2 to 6. Emergent notice returnable by 29th of January. It will be listed on 29th. In the meanwhile, you, next para, learned AGA is directed to secure instructions. Having regard to the representations given by the petitioner as found at annexure E and F.
E, my lord.
Annexure E.
In the meanwhile, I'll comply the office.
Yes. Next para, in the meanwhile, office objection shall be complied.
Second time non-compliance.
Who's appearing on behalf of the respondent bank.
I
my
appear
lords.
for the petitioner in this case.
Yes.
It's a writ of mandamus, my lord. They had to file objections to
My lords,
the writ.
if I may submit, my lords, the loan is taken by the partnership firm. My lords, the firm is
Why
all.
have you not complied with the office objections?
My lords, it was listed before the vacation bench. After that, the file was not given to me because they had to file objections. Or kotrilla anta namgu file kotrilla avaru. I have paid the court fees, but I have paid the court fees.
No, there are 7 office objections.
No, I will comply it within a week, my lords.
My lords, if I may submit, my
Ah.
lords, it's a partnership firm, my lords, the borrower.
Hmm.
The borrower has already approached the DRT. The matter is listed on the 20th of January for hearing. The bank has already filed its objections. An interim order is also passed by the DRT. Hence, this writ petition will not survive when the partnership firm itself is before DRT.
And
The
who is
sale has
petition-
already taken place. 25% is paid by the auction purchaser. The DRT has stayed sale certificate, issuance of sale certificate. And matter is listed on the 20th, that is on Monday for hearing.
My lords,
As now they
If I may
say
be
that their
permitted.
representation to be considered where they want to pay the entire amount. However, sale has already taken place.
if I may be permitted, my lords, the NPA has been done in the year 2018. My lords, they have issued the sale notice in the year 2024. On 25/11, I have filed SA 265 of 2024, after which interim order has been granted. My lords, on 18/12/2024, respondent bank has filed objections in that said SA. After which I have come to know that the said mortgage property has been sold for so and so amount. 18th, I get a copy. 20th, I issue a representation saying that I'm ready to pay that so and so amount within the reasonable time. After which the bank officials, they call the petitioner and tell the petitioner that pays some amount
we'll do something. But until now, the petitioner has not paid 1 rupee after the sale confirmation has been issued against the auction, I mean, in favor of auction purchaser. Now, my lords, the second contention before DRT is that this mortgage property is agricultural property. Therefore, there is a contention from the petitioner before the DRT. So that is pending adjudication. Now I am before this court only seeking writ of mandamus to consider my representation, whether they reject it or to accept it.
You cannot do that. Once you have gone up before the DRT, whatever submission you want to make, you have to make before the DRT.
Yes, my lord, but
You cannot make use of this forum to again coax them to consider your representation. Angala madak barodilla.
yes, my lord, but
Learned counsel for the respondent submits that the petitioner has already approached the Debts Recovery Tribunal, Bengaluru, and interim orders have also been passed by the tribunal in favor of the petitioner.
The partnership firm.
Partnership firm, which is the borrower. Full stop. Moreover, the secured assets have already been put to auction and sold on
And it's 27th of November.
27th of November 2024. Andre Ali, they have stayed the
Sale certificate, issuance of sale certificate.
The tribunal has stayed the further process, including grant of sale certificate in favor of the auction purchase. Full stop. Next para. Learned counsel for the petitioner, however, submits that the prayer in this writ petition is to direct the respondent bank to consider the representation dated 20/12/2024 given by the petitioner. Full stop.
one submission.
If you are saying you are prepared to pay
Yes,
the entire amount that was bid for,
yes, ma'am.
it is open for you in accordance with law only.
My lords, but they have to accept my representation. Even if I pay, my lords, one submission.
If to show your bona fides,
Yes,
anyone can write a letter like this.
yes, my lords, but
To show your bona fides, you had to send a DD along with this one,
my lords,
saying, please take it, please consider, and in accordance with law, if a borrower has repaid the entire outstanding loan amount,
no, my lords.
then see, there is no right given to the auction purchaser that it has to be accepted.
Correct.
The first preference will always be given to the borrower, even in accordance with law.
Correct.
So if you pay the entire amount, they are bound to receive it. Only thing is they will have to pay interest to that person.
My lords,
My
at least,
That is all.
at least that direction may
My
be given.
lords,
My lords, my lords, even if the auction purchaser as per page number 61 R2, my lords, as per them,
Wherein the petitioner has clearly stated that he is ready and willing to deposit a sum of rupees 4 crores 3,13,000, which was the amount bid by the successful
Correct.
bidder and on such payment being made, the bank should release the title deeds in favor of the petitioner. Full stop. Next para. Since the petitioner is already before the debts recovery tribunal, comma, this prayer could also be made before the debts recovery tribunal. Full stop. Nevertheless, if the petitioner is ready and willing to deposit the entire amount as stated in the representation, comma, to prove the bona fides of the petitioner is required to tender a demand draft for the entire amount
My lords,
with the respondent bank. Full stop. If the entire amount is so deposited by way of a demand draft, comma, then the petitioner is entitled for such a relief even in accordance with law. Full stop. The borrower should be given such preference to save his secured assets. Full stop. The successful bidder will only be entitled for payment of interest,
my lords, if I may,
having regard to the law laid down by the Honorable Supreme Court.
my lords, if I may
Full
submit,
stop. Next para. Therefore, the writ petition stands disposed of,
my lords, if I may interrupt. my lords,
granting liberty to the petitioner to deposit the entire amount of rupees 4,03,13,000 as stated in the representation
Time frame may be.
by way of a demand draft. Full stop.
My lord, he loses his right to redemption once I publish the notice, my lords. Now the auction purchase has already entered appearance. He's paid 25%. Therefore, he cannot redeem the property now. It is for the,
55%, madam. He is
But-
prepared to pay the entire amount. That is
he's
why,
ready to pay the entire amount as well, my lords, only because of this, my lords. the-
even if he is ready to pay, it cannot be accepted if he tenders the demand draft.
Lords, in view of the Honorable Apex Court's decision in Seller LLP, he loses the right to redemption once I publish the notice. Hence, now he cannot come and redeem. It is DRT who has to decide if my procedures are wrong.
Those are all cases where nothing is done by the borrower.
My lords, the,
Here, that is why I am giving a direction that if he tenders that demand draft, you can as well accept it and direct him to pay the interest to
my
the
lords, when the case is before
uh,
DRT on the 20th,
bidder.
it will be decided on the 20th, my lords, then how does the question of considering his representation come? When I've already sold the property, after 1 month after I've sold the property, has given a representation.
Where is the question of selling, madam? You have not collected the entire amount.
That is
amount
because
is not
it's been granted by DRT, I could not
Therefore,
collect
you
it.
cannot contend
My
that it is sold.
This is not the first time that the petition has come before DRT, my lords.
Madam,
The
I
earlier essays were
understand.
dismissed.
Even with all this, he will not be able
Okay.
to tender a demand draft.
My lords, if this
That is
what-
observation is
but-
made, he will hold on to that, my lords, even
No
before
question.
DRT.
I will fix a time frame. If he does that, then
My lords, then,
he entitled
And they'll be,
then
they
interim
will have the
orders
liberty to proceed.
uh, be before the DRT as well and as well as before this court. I will not be able to proceed. The auction purchaser will withdraw. He will also not pay. Manoj, it's not the first time he has come before the bank several times. He's not paid.
the benefit given to the petitioner can be made use of by the petitioner only if a demand draft is accordingly deposited with the respondent bank within a period of 7 days from today.
Well, at
Full
least
stop.
that 25% within 7 days and remaining 75%.
Barada illa, not possible.
Malaj, at least 2 weeks, Malaj, because anyways, the next date in DRT is on 20th. Malaj, on that date,
Failing which,
the respondent bank has to,
failing which the petitioner may make any such prayer before the debts recovery tribunal. Yes.
grateful.
30, Yog Herali.
Here for the petitioner.
Matters infructuous.
The interim order, my lords. The event has been already taken place.
Huh?
Matters infructuous.
Actually, my lord, not a memo to that.
Learned counsel for the petitioner has filed a memo dated 15/1/2025.
5-1.
15/1/2025.
5-1/25.
ಏನ್ 5-1?
Today's date.
Sorry. Interim order dated 5.
Already you have filed a
Please,
memo.
please.
Stating that in view of the interim orders passed by this court on 5/1/2025, the event was held peacefully without any law and order issue. Full stop. It is therefore stated that the prayer made in the writ petition has become infructuous.
Please.
And therefore, the petitioner may be permitted to withdraw the writ petition. Full stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed as the prayer made in the writ petition has become infructuous.
On complaints for third time, serial number 31, V. Mohan.
Milord, I appear for the petitioner, Milord.
Yes.
The conditional order I already complied, Milord. That I'll file the affidavit in the next date of hearing, Milord. That petitioner is hospitalized. I'll file the affidavit within 2 weeks, Milord.
By order dated 20/11/2024, the petitioner was permitted to deposit 20% of the outstanding amount due as on the date of the order with the respondent bank, within a period of 2 weeks from the date of the order. Full stop. It was also made clear that if the orders are not complied with, the interim order granted stands automatically vacated and the respondent bank is at liberty to proceed in accordance with law. Full stop. Next para. Though learned counsel for the petitioner submits that the petitioner has deposited the said amount with the respondent bank,
On 2nd December.
no information is placed on record. Full stop. Next para. Release this matter on 21st of January.
The interim order will be extended.
No, sir.
32.
Yes.
Jairaj, DS.
I pray for a week's time to comply of his objections, my lord.
Huh?
I pray for a week's time to comply of his objections.
A week's time is granted at the request of learned counsel for petitioner for complaints of office objections. Interim orders have been passed?
No.
Yes.
33, Madhukar D. Deshpande.
Appearing for the petitioner, the office objection was with respect to production of legible copy of annexure D. First, we have produced the annexure D, my lord, so we have complied with the office objections.
May I make one submission, respondent number 2 in this matter, my lord. The writ petition is not survey for consideration. In pursuant to the interim order is granted by this court to participate the tender process. They have not participated the tender. Therefore, the writ petition become infructuous, my lord.
Lord, so I'll seek instructions.
Serial number 33, 67, 69, 86. These are 4 writ petition is become infructuous, my lord. In view of the division bench order, my lord.
Lord, I seek for short accommodation, my lord. The arguing counsel is not in town. Pray for short accommodation.
May I permit me to
What information?
coordinate bench of this honorable court. Division bench is held in.
ಅದಲ್ರಿ ಇದ್ರ ಬಗ್ಗೆ ಏನ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಇದೆ ರೀ ನಿಮ್ಗೆ?
Swami?
ಈ ಟೆಂಡರ್ ಬಗ್ಗೆ ಏನ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಇದೆ
E tenderly, there is not participated by the petitioner before this.
What information do you have? Who you are appearing for whom?
I am for the respondent tendering at the inviting authority, my lord.
ಏನ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಇದೆ ನಿಮ್ಮ ಹತ್ರ? ಕೊಡಿ. ಇದು ಯಾವ
Page number seven ನಲ್ಲಿ, page number second page seven, seal number 7 ನಲ್ಲಿ
ಚಾಮರಾಜನಗರ.
only Chamarajanagar they have,
ಚಾಮರಾಜನಗರ.
only Chamarajanagar they have applied. In serial number, only Chamarajanagar they have applied.
ಆಶ್ರಯ ಅಸೋಸಿಯೇಟ್.
Asraya Associates, it's showing in the name of the Vinay Vinkate Gowda,
ವೈಕುಂಠೇಗೌಡ.
Vaikunte Gowda, Shivay Gowda, represented by Asraya Associates.
ಹಾ
The only one district they have applied.
ಹಾ
Rest of the district they have not applied.
ಹಾ. What is the grievance?
They are challenging the notification, tender notification,
ಹಾ
for seeking for declaration of tender condition, serial number 2 and 3 of the eligibility criteria.
Bidder shall not be under a declaration of ineligibility for corrupt and fraudulent practice. ಅದ annexure A ನಾ?
Annexure A, tender notification, my lord.
Shall be the responsibility of the bidder to ensure credit of tender processing fee and EMD into the respective receiving bank accounts of e-procurement on or before the last date. So in respect of ಚಾಮರಾಜನಗರ,
Only they have Chamarajanagar.
3 ಜನ ಇದ್ದಾರೆ.
Howdu.
So you will consider the tender of all the 3.
Please, madam, you now,
Consider.
my lord, now there is an evaluation is completed and we have called for the document verification.
ಹಾ.
This the stage is before the tendering authority.
What was directed?
The directing the
Petitioner is permitted to participate in the tender process following the impugned tender document to date so and so, issued by respondent number 2. In the event petitioner quotes 10% below the estimated value of the tender document, the respondent number 2 shall not forfeit the EMD.
EMD.
ಅಷ್ಟೇ.
Please, my lord.
ಹಾ?
This is the interim order is granted by this court.
ಹಾ. Now
In pursuant to which
who is the lowest bidder?
my lord, still is the L1 is not qualified. As per the petition is concerned, they have applied only one district,
ಅದೇ.
Chamarajanagar.
ಹೌದು.
Rest of the district they have not applied. They are challenging the 4 districts. One Kodagu, Mandya, Hasan, Mysore.
Hmm.
They have filed the writ petition. All the Mandya, Chamarajanagar, Mandya, Hasan, Kodagu,
ಕೊಡಗು ಚಾಮರಾಜನಗರ.
Mysore, they have not participated in the tender in pursuant to the notification. Therefore, my humble submission before this court, my lord, there is a judgment of this division bench. I referred in para 11.1.
See, we have not stopped you from finalizing the tender process. We have only said it will be subject to the final outcome of the writ petition.
Please, my lord.
So have you proceeded?
No, my lord, we are not proceeded. Still, the document verification is process is now is going on. My submission before this court is, my lord, the other district, the petition is not applied. Therefore, the writ petition will become infructuous in view of the division bench order, my lord. Para 11.1.
ಅಲ್ಲ ರೀ, at least in respect of ಚಾಮರಾಜನಗರ.
Chamarajanagar, we are not disturbing.
So in respect of all the other district, the writ petition has become infructuous.
Please, my lord.
ಅಷ್ಟೇ ನಿಮ್
Aste
submission.
my submission.
So in respect of ಚಾಮರಾಜನಗರ,
ಚಾಮರಾಜನಗರ,
we will consider.
Please, my lord.
The writ petition will survive only in respect
Only
of
Chamarajanagar district. Writ petition number 3495590. Serial number
Lords, I may be permitted, my lords, one submission. I'll seek
68 and
instruction, my lords,
34.
whether we have applied for the tender for the other districts as well.
ಕೊಟ್ಟಿದಾರ್ರಿ ಇಲ್ಲಿ ಇನ್ಫಾರ್ಮೇಶನ್.
My lords, it may be passed over, my lords, we'll take
serial number
instructions.
68 and 34 is only
Seek for-
survive for consideration.
I'll seek for pass over, my lords, may be passed over.
ಯಾವ್ದು ರಿಟ್ ಪಿಟಿಷನ್ ಚಾಮರಾಜನಗರ ಯಾವ್ದ್ರಿ?
Chamarajanagar
Serial
serial
number
number
68, my
68.
lords.
68.
68.
In
So
Vigo.
other writ petitions can be disposed of.
Yes, my lord. And 34 also is survive for consideration.
68.
68. and 34.
34 ಏನು?
34 also similar order is passed by the different entity, my lord.
ಪದ್ಮಾವತಿ ಎಂಟರ್ಪ್ರೈಸಸ್.
Padmavati Enterprise.
ಅವರು
They have already applied and the still is documented,
participated
in the tender process.
ಯಾವುದು? ಯಾವ ಡಿಸ್ಟ್ರಿಕ್ಟ್?
Raichur, my lords, I am not.
We have not received the copy, my lord. I have filed the wakalat, but I am not getting the petition copy.
ಪದ್ಮಾವತಿ ಎಂಟರ್ಪ್ರೈಸಸ್.
Serial number 34.
ಕೊಡ್ರಿ ಅದು ಫೈಲ್ ಕೊಡ್ರಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 34.
Right.
ರಾಯಚೂರು.
ರಾಯಚೂರ್. ಅದರಲ್ಲಿ 4 ಜನ ಇದ್ದಾರೆ.
ರಾಯಚೂರ್ದು ಇಲ್ಲಂಗೂರಿಗೆ ಬರುತ್ತೆ. ಧಾರವಾಡ ಬೆಂಚ್ ಅಲ್ವಾ?
ಅಲ್ಲ, ಗುಲ್ಬರ್ಗ ಬರುತ್ತೆ.
ಗುಲ್ಬರ್ಗ, ಕಲಬುರ್ಗಿ. Why have you filed the writ petition here?
My lords, the tender was issued from. I'll seek instructions on this, my lords. Comply with the office objections.
ಟೆಂಡರ್ ಇನ್ವೈಟಿಂಗ್ ಅಥಾರಿಟೀಸ್ ಬ್ಯಾಂಗ್ಳೂರ್, my lord.
So,
ಅವ್ರು ಅದನ್ನ ಕಾಪಿನೂ ಕೂಡ ಥ್ರೂ ಮಾಡಿಲ್ಲ. ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಸರ್ವ್ಡ್ ದಿ ಕಾಪಿ.
ಇದರಲ್ಲಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡಿದೀರಾ ಇವ್ರದ್ದು ಬೇರೆ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಯಾವ್ದೋ ಹೆಸರು ಇದೆಯಾ?
ಇಲ್ಲ. ಓನ್ಲಿ ಒನ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ದೇವ.
ಓನ್ಲಿ ರಾಯಚೂರು.
ಓನ್ಲಿ ರಾಯಚೂರ್.
ರಾಯಚೂರಲ್ಲಿ ಇವ್ರ ಹೆಸರು ಇಲ್ವಲ್ರಿ?
ಅಲ್ಲ, ಅದು
ಪದ್ಮಾವತಿ.
ಫುಲ್ ನೇಮ್ ಹಾಕಿಲ್ಲ ಅವರು.
ಹಾ,
4th one is the ರಾಯಚೂರ್ ಪದ್ಮಾವತಿ.
ಹೌದಾ?
ಹೌದು.
Learned counsel for the second respondent, tender inviting authority submits that the petitioner Messrs. Ashraya Associates has submitted tender only in respect of Chamarajnagara district. Full stop. Similarly, petitioner in WP number 34687 of 2024 has has submitted the tender only for Raichur district.
ರಾಯಚೂರ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್.
Full stop. The learned counsel would therefore submit that the writ petitions may be disposed of in respect of all other districts, since the petitioners have not submitted their tender and no useful purpose would be served, keeping the writ petition pending for consideration in respect of the other districts. Full stop. Writ petitions number, serial number
33 67
35,
33 67 69 86
67,
69 86
69,
86.
86. Are accordingly disposed of. Stop. Next para. At the request of learned counsel for the petitioners, relist
Similar, one more matter is pending on
the other two writ petitions on 21st of January.
21st. ಅದು ಇನ್ನೊಂದು ಎರಡು ಮ್ಯಾಟ್ರು ಅವತ್ತೇ ಇದೆ ಸ್ವಾಮಿ.
ಯಾವ್ದು?
ಸಿಮಿಲರ್ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟ್ರ್.
ಇದು ಯಾವತ್ತೆ?
ಹೌದು 21st ಗೆ
ಡೇಟ್ ಕೊಟ್ಟಿದಾರ?
ಹೌದು.
ಸರಿ ಮತ್ತೆ. ಆಲ್ ರೈಟ್.
Number 35,
ಮಚ್ಚು.
Sandhya U. Prabhu.
Case, my lord, the office petition is with regard to.
Yes.
Office objection, my lord, outstanding possession notice is challenged. Kevet copies ಮಾಡ್ಬೇಕಂತಿತ್ತು ಬಂದಿದ್ದಾರೆ ಸ್ವಾಮಿ. And
Huh?
I think
Yes.
for the respondent, my lord.
possession notice is challenged. my lord. 10 crores is outstanding, my lord, and petitioner is ready to deposit 60 lakhs. my lord.
No, it cannot be your own, my lord.
Please go before the DRT.
My lord, who has offered mortgage, the property is preferred appeal before the NCLT at Chennai. Last, I think, he has filed on 1/2/2025. Sorry, 1/1/25.
Company Law Tribunal.
Please,
For what purpose?
insolvency petition filed by the guarantor, who has offered the property in favor of bank.
I have no instructions, my lord, on that.
We received notice from the NCLT at Chennai.
Learned counsel for the respondent, Srimati Saubhagya N.A. submits on instructions that the guarantor of the petitioner company has already approached the National Company Law Tribunal invoking insolvency proceedings. Full stop. The petitioner should be directed to approach the debts recovery tribunal for any relief, since the law declared by the Honorable Supreme Court is that the high courts should not interfere in the proceedings initiated by a secured creditor invoking the provisions of the SARFAESI Act. Full stop. Learned counsel would also submit that the outstanding loan amount is more than
10 crores, 18 lakhs, 39,000 as on 8/8/2024, my lord.
is more than 10 crores.
10 crores.
Full stop. Next para. Although learned counsel for the petitioner seeks to submit that the petitioner will deposit a sum of rupees 60 lakhs, this court is of the considered opinion that no relief can be given to the petitioner having regard to the law declared by the Honorable Supreme Court in the matters of procedures to be followed under the provisions of the SARFAESI Act. Full stop. Next para. The writ petition is accordingly dismissed.
Serial number 36, Naveen BH.
What's 36? I appear for the respondent bank.
For the petitioner, Malad.
Sorry.
My lord, on the last occasion also, this matter was supposed to be listed with the connected matter. However, today also it is not listed along with the main matter.
ಯಾಕ್ರಿ ಹಿಂಗ್ ಮಾಡ್ತಿದಾರೆ? ಎರಡನೇ ಸರಿ ಇದು ಆರ್ಡರ್ ಮಾಡಿರೋದು. Release this matter on so and so along with WP number so and so ಅಂತ ಬರ್ದಿದೀವಿ. ಎರಡನೇ ಸರಿ ಇದು ಆರ್ಡರ್ ಬರ್ದಿರೋದು. ಫೋನ್ ಮಾಡಿ ಕೇಳಿ ಅವ್ರಿಗೆ. ಕರೆಸ್ರಿ ಅವ್ರನ್ನ ಇವ್ರನ್ನ ಎಸ್ ಓ ಕರೆಸಿ ಅಥವಾ ಕನ್ಸರ್ನ್ ಕೇಸ್ ವರ್ಕರ್ ಕರೆಸ್ರಿ. ಎಸ್ ಪಾಸ್ ಓವರ್ ವಿಲ್ ಸಿ.
37.
37, I appear
And
the
for the
respondent
petitioner,
bank.
Manoj. Last time, I had submitted that 10% conditional deposit has been complied and memo has also been filed. And affidavit had to be filed before this court. I filed it on 13/1, day before yesterday. I've
In the affidavit, the petitioner states
The affidavit
has been filed.
has been filed on behalf of the petitioner.
Yes, on 13/1. 13/1, day before yesterday. Yes.
my lords, in the affidavit.
Copy has
he
been served.
He
Manoj, one
states that
one
the
second.
outstanding
Copy of the same is served on the learned counsel for the respondent.
Yes.
Yes.
One second. one
states
second.
that the outstanding is 31,95,000. My lords,
Yes.
the outstanding is around 55 lakhs.
Well,
Because
as
it is
per
60
the
lakhs
statement
when
of
the
account
interim order
which
was
we have,
passed. One,
as,
I'll complete.
one second. Nanda undertaking, sorry. Well, as per the statement of account which we have, the petitioners have, I have calculated and I have made a tabular column as well. It's not that blatantly I have written 31,95,909. I have made a tabular column at page number 3 of my undertaking affidavit. Malats, let them give a statement of account which they say that 55 lakhs is the outstanding. I will file a fresh undertaking affidavit. But as per my statement of account and as per my calculations, this is the outstanding balance as on today.
Because initially when the interim order was passed, 60 lakhs was the outstanding, out of which 10% he paid, which was 6 lakhs. Now he says the outstanding is only 31 lakhs. Because I'll
But
produce
as
the
per-
statement of
Learned
accounts.
counsel for the respondent, however, submits that
Let's page number 31 may be looked into for 1 second. It's page number 31 and 32. In 30 to page number 32, bank themselves,
by interim order dated 29/11/2024, this court had directed the petitioners to deposit 10% of the outstanding amount due as on the date of the order. And the petitioners have deposited rupees 6 lakhs,
10%.
comma, which is 10% of rupees 60 lakhs.
Approximately 60 lakhs.
Let's page number 32 may be looked into. The outstanding is 52 lakhs 50,000
The learned
as per
counsel,
their own notice.
Therefore submit,
In the year
learned counsel for the
2023.
respondent would therefore submit that the petitioner cannot now file an affidavit showing the balance outstanding as
31
rupees
lakhs.
31 lakhs,
95,000.
95,000. Full stop. Next para. Learned counsel for the respondent bank is requested to furnish
Statement.
Statement of account.
a statement of account or a communication from the manager of the respondent bank to show what is the outstanding amount payable by the petitioner. Full stop. Release this matter on 21st of January.
Grateful. Interim order may be extended. ma'am.
Interim order granted earlier stands extended till the next day.
Yeah, you Prabhu.
My lords, concurred.
In this case, the first case is by the guarantor challenging the order of the learner magistrate. The third case, my lord, is by the borrower, my lord. My lord, there was an order by this honorable court, my lord. Not to the property, my lord, was so undervalued and sold by the banker, my lord, for 1,58 lakhs, my lord. And this honorable court, my lord, because I had given a letter to the banker saying, I have identified a buyer who is ready to pay more than that, my lord. And this writ petition was filed, my lord, challenging the action of the banker. And this honorable court, my lord, directed me to make a deposit of 1,50,50,000, my lord, and later on, my lord, 2 crores within by end of this month, my lord. My lord, I have identified a buyer who has given me the check also, a copy of the check. I have given it to the banker informing that in the order, my lord, there is no clarity that if the buyer not deposits the amount, the property will be released. So if that word is included, my lord, I'm ready to give the this check, my lord, immediately to the banker, my lord. 2 crores check is there, my lord, ready. That will be given to the banker immediately. It will be cleared by the prospective buyer, my lord. Our 1,53,00,000 ಮಾರೋ ಬದಲಿಗೆ ಸ್ವಾಮಿ ನಂದು 2 ಕೋಟಿ buyer amount ready ಇದೆ. And the balance what I had undertaken that I will get a buyer for the higher amount ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಾನು previously undertake ಮಾಡಿದ್ನ ಅದ್ balance ಅನ್ನು ನಾನು ಕಟ್ತೇನೆ ಯಾಕಂದ್ರೆ second part of the order is for 2 crores.
You are now making submissions on behalf of the principal borrower.
Prospective buyer, my lord. Principal borrower.
Principal borrower.
ಹೌದು sir.
He had undertaken to pay rupees 1,53 lakhs.
Please, my lord.
That is not deposited.
ಅಲ್ಲ through the buyer ಅಂತ through the buyer ಅಂತಾನೆ ಹೇಳಿದ್ದೇವೆ ಸ್ವಾಮಿ.
Not
ಥ್ರೂ
deposit.
ದ ಬೈಯರ್ ಅಂತ ಅದ್ ಬೈಯರ್ ರೆಡಿ ಇದಾರೆ. ಡೆಪಾಸಿಟ್ ಅಂದ್ರೆ ಕ್ಲಾರಿಟಿ ಒಂದೇ ಒಂದ್ ಸ್ವಾಮಿ, ಅದನ್ನ ಪ್ರಾಪರ್ಟಿ ರಿಲೀಸ್ ಮಾಡ್ತಾರಂತ ಅದನ್ನ ಒಂದ್ ಬರ್ದ್ರೆ ಮಾತ್ರ.
My lords, if I
there
may,
are 4-5 ಪ್ರಾಪರ್ಟೀಸ್
ಹಂಗೆಲ್ಲ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ.
ಅಲ್ಲ
Possible.
ಅವ್ರು ದುಡ್ಡು ಕೊಟ್ಟಿರೋರ್ಗೆ.
There is a direction issued by this court.
ಪ್ಲೀಸ್ my lord.
Recording your submission
Please,
that
madam.
you will deposit rupees 1,53 lakhs.
ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಇದನ್ನು ಬರ್ತಿದ್ದಾರೆ ದಟ್ ಐ ಹ್ಯಾವ್ ಐಡೆಂಟಿಫೈಡ್ ಅ ಬೈಯರ್ ಅಂತ.
my lords, if I may submit, my lords, this is the 5th writ petition. There are 3 writ petitions now. Previously, 2 more writ petitions were filed. My lords, if my lords may take the third
ಕ್ಲಾಸ್
matter.
1 ಕಾಂಟ್ರಾಕ್ಟರ್ ಸ್ವಾಮಿ
That page
ಗವರ್ಮೆಂಟ್
number
ದುಡ್ಡು
42.
ಕೊಡ್ಲಿಕ್ಕೆ ನಂಗೆ 113ರಲ್ಲಿ ಸೀನಿಯಾರಿಟಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 13ರಲ್ಲಿ ಬಂದಿದ್ದೇನೆ ಸ್ವಾಮಿ. 2 ಕೋಟಿ ಗವರ್ಮೆಂಟ್ ಇಂದ ನಂಗೆ ಬರ್ಬೇಕು, ನಾನು ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿನೇ ಬರ್ಬೇಕು. ಬಟ್ 2 ಕೋಟಿ ಇನಿಷಿಯಲಿ ರಿಲೀಸ್ ಮಾಡ್ತೇನೆ ಅಂತ 113ರಲ್ಲಿ ಸೀನಿಯಾರಿಟಿ ಲಿಸ್ಟ್ ಐ ಪ್ರೊಡ್ಯೂಸ್ ಇಟ್ ಮೈ ಲಾರ್ಡ್. 113ರಲ್ಲಿ 13 ಬಂದಿರೋನ್ಗೆ ಅಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ಇಂದ ರಿಲೀಸ್ ಆಗ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ಎಲ್ಲ ಕಾಂಟ್ರಾಕ್ಟರ್ಸ್ ಗಳ ಲಿಸ್ಟ್ ಕೊಟ್ಟಿದ್ದೇವೆ. ಇದು ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ನಮ್ಗೆ ಅಮೌಂಟ್ ರಿಲೀಸ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ವಿ ಆಲ್ ವಿಲ್ ಕಮಿಟ್ ಸೂಸೈಡ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಚೀಫ್ ಮಿನಿಸ್ಟರ್ಗೆ ಬರ್ದಿದ್ದೇವೆ, ಪ್ರೈಮ್ ಮಿನಿಸ್ಟರ್ಗೂ ಬರ್ದಿದ್ದೇವೆ. ಇಷ್ಟೆಲ್ಲ ಆದ ನಂತರ ಗವರ್ಮೆಂಟ್ ನಾನು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿರೋದು ಇವ್ರ ಹತ್ರ ದುಡ್ಡು ತಗೊಂಡು ಗವರ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ಗವರ್ಮೆಂಟ್ ದುಡ್ಡು ಕೊಟ್ರೆ ಇವ್ರದ್ದು ಅಕೌಂಟ್ ರೆಗ್ಯುಲರೈಸ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ ಅಷ್ಟೇ. ಆದ್ರೆ ದೇ ಆರ್ ಬ್ಯಾಕ್ ಆಫ್ ಮೈ ಪ್ರಾಪರ್ಟಿ. ಆ ಪ್ರಾಪರ್ಟಿ ಅವ್ರು ಮಾರೋ ದುಡ್ಡಿಗಿಂತ ಜಾಸ್ತಿ ಬೈಯರ್ ಅಂತ ತಗೊಂಡ್ ಬಂದಿದ್ದೇನೆ ಸ್ವಾಮಿ. ಅವರು 2 ಕೋಟಿ ಇನ್ಸ್ಟೆಂಟ್ಲಿ ಕೊಡ್ಲಿಕ್ಕೆ ರೆಡಿ ಇದ್ದಾರೆ. ಬಟ್ ಓನ್ಲಿ ದ ಕಂಡೀಷನ್ ಇಸ್ ದರ್ ಆರ್ ಅದರ್ ಪ್ರಾಪರ್ಟೀಸ್ ಆಲ್ಸೋ. I'm not asking for release of that property. Let them retain the property, my lord. ಅವರು 153ಕ್ಕೆ ಯಾರಿಗೋ ಕೊಡೋ ಬದಲಿಗೆ
You are permitted to proceed.
My lords, now.
If they don't deposit it, you are permitted to proceed.
My lords, these writ petitions will not survive, my lords. I'll just point out the third petition. Previously, they had filed one more petition, 23125 of 2024, which is at page number 42 in writ petition number 29290. They filed an undertaking affidavit before this court that they'll close the loan, which they have not complied. Subsequently, they came up with these 3 writ petitions. My lords, in this also, none of the interim orders are complied. I've already sold the property. They've deposited 25%. Stay was granted, therefore they have not deposited the rest of the amount. I have to recover more than 12 crores. My lords, therefore, all the 3 writ petitions will not survive. They could have approached
25 for that 153 ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. ಆ 153 ಅವ್ರು ಮಾರಿರೋ ಒಂದು ಪ್ರಾಪರ್ಟಿಗೆ 3,25,00,000 ಕೊಡ್ತಾ
Very
ಇದ್ದಾರೆ.
same submission is made every time this
No, no,
matter
no,
is
this
listed.
can be the rigid proof, my lord. I'm lost my kind.
My lords, auction purchase
Court
has
of
already paid 25%. They've not showed them
There
both
is
sides.
non-compliance of the order.
My lord, non-compliance is just because of this, my lord. There requires a clarity, my lord, that
All-
in the event on payment of this amount, this is not my money, my lord. On payment of this amount, my lord, if the property is going to be released, my lord, my buyer is ready to pay. Property ಸಿಗುದಿಲ್ಲ ಅಂದ್ರೆ ದುಡ್ಡು ಹೇಗೆ ಕೊಡ್ಬೇಕಂತ ಅವ್ರು ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
On 18/12/2024, in writ petition number 33629 of 2024, the following order was passed. Extract ಮಾಡ್ಕೊಂಡು. Next para. Learned counsel for the respondent bank submits that the directions issued by this court have not been complied. Stop.
Second part ಇದೆ ಸ್ವಾಮಿ, ಇನ್ನೂ
Learned
ಇದೆ.
counsel would further submit that this is the third round of petitions that are filed at the hands of the borrowers bar guarantors. Full stop. Earlier too, such an undertaking was given before this court in WP number
23125 of 2024.
and on failure of compliance with the directions issued by this court, the said writ petition was dismissed. Full stop. Next
The
para.
said writ petition was disposed on the undertaking affidavit filed by them.
ಗವರ್ಮೆಂಟ್ ಇಂದ ದುಡ್ಡು
However,
ಬರುತ್ತೆ
that
ಅಂತ ಅಂಡರ್ಟೇಕ್
time
ಮಾಡಿದೆ
they have
ಸ್ವಾಮಿ.
not paid, therefore the interim order was vacated. Therefore, I proceeded with the sale notice.
Government was supposed to give my money, my lord. ಅವ್ರು ಕೊಟ್ಟಿಲ್ಲ.
Hello, and the writ petition was disposed of, permitting the petitioner to comply with the undertaking given before this court and make necessary payments with the respondent bank. Full stop. However, on failure on the part of the petitioner, the respondent bank has proceeded to auction the property, secured assets. Full stop. The successful bidder has deposited a sum of 25% of the bid amount. And since there were orders of stay passed by this court, the bidder is not permitted to deposit the balance amount. Full stop. Next para. Learned counsel for the
make
petitioners,
one submission.
however, seeks to submit that there was some clarification required to the order dated 18/12/2024 that on deposit of the amount of rupees 1.5 crores,
$1.5 ಅಲ್ಲ ಸುಮ್ನೆ 3.25 ನಾನು ಪ್ರಪೋಸ್ ಮಾಡಿದ್ದೆ
3.25 crores,
ಇಟ್ಸ್ ಡಬಲ್ ದೇರ್ ಅಮೌಂಟ್
the at the hands of a buyer who would be identified by the petitioner, the title deeds should be released to the petitioner. Full stop. It is further submitted that the petitioner is due to receive more than 2 crores from the state government for the works he has already executed. Full stop. Next para. Having regard to the fact that earlier too such a petition was filed by the petitioner and the undertaking given before this court has not been complied, and the fact that the respondent bank has proceeded to auction the property, secured assets, no indulgence can be shown by this court. Full stop.
ಐ ಮೇ ಬಿ ಡೈರೆಕ್ಟೆಡ್ ಟು DRT at least ಚಾಲೆಂಜ್ ಮಾಡ್ತೇನೆ ಅಲ್ಲಿ at least.
The petitioner, of course, may approach the debts recovery tribunal for redressal of their grievance. Full stop. Next para. Consequently, all the 3 writ petitions stand dismissed.
Wait.
Yes.
In the first petition, guarantor, separate magistrate order. So even she may be given with the liberty, my lord.
I have said petitioners are at liberty.
Please, my lord.
Number 39.
Office objection has raised, my lord. I will comply with respect to my lord out of 4, 3, my lord. And today morning, my learned friend has served the my lord statement of objection to me, my lord. I will file the counter on this, my lord. Counter affidavit.
Yes.
Short question that's involved in this case is transfer of shifting of sawmill from one place to another place. Present sawmill is in Banarghatta Road, Bengaluru. They want the sawmill to be shifted to a village called Marur. Here, Arehalli Hobli, Belur Taluk. But here, section 162 subclass 2A says that there should be a minimum of distance between the forest boundary and the sawmill of 10 kilometers at least. That is the aerial distance as the crow flies. So that should be there. Here, not the distance where they are seeking to shift the sawmill is 2.90 km from Chikmagalur district, Banavara village, that forest. And the other one, other village forest is situated 9.90 km. That's the aerial distance. Malad, may kindly come to.
Why is that a different opinion was given by the Tahsildar?
No, this is the aerial report. It is a survey conducted.
Annexure, your lordship may kindly peruse the annexure, my lord.
But given
G.
that opinion,
Yes, my lord, annexure G.
page number,
Page number, my lord, operative 35, bottom, my lord. ಸದರಿ sawmill ಸ್ಥಾಪನೆ ಮಾಡಲು ಉದ್ದೇಶಿಸಿರುವ ಭೂ ಪರಿವರ್ತನೆ ಬೇಲೂರು ತಾಲೂಕು ಅರೇಹಳ್ಳಿ ಹೋಬಳಿ ಮರೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೊ ಅಂಡ್ ಸೋ 30 ಗುಂಟೆ ಪ್ರದೇಶದಿಂದ ತಗರೆ ರಕ್ಷಿತ ಅರಣ್ಯದಿಂದ 10.19 ಕಿಲೋಮೀಟರ್ ಹಾಗೂ ಕಲ್ಲಹಳ್ಳಿ ರಕ್ಷಿತ ಅರಣ್ಯ ಪ್ರದೇಶದಿಂದ 15 ಕಿಲೋಮೀಟರ್, ಮಲಸವಾರ ಕಿರು ಅರಣ್ಯ ಪ್ರದೇಶದಿಂದ 14.30 ಕಿಲೋಮೀಟರ್, ಚಿಕ್ಕಮಗಳೂರು ವಿಭಾಗ ಮತ್ತವರ ಅರಣ್ಯ ಪ್ರದೇಶ 10.35 ಕಿಲೋಮೀಟರ್ ಹಾಗೂ ಮುಗವಳ್ಳಿ ಅರಣ್ಯ ಪ್ರದೇಶದಿಂದ 11 ಕಿಲೋಮೀಟರ್ ವಾಯು ದೂರ ಇರುತ್ತದೆ. sawmill ಸ್ಥಳಾಂತರ ಮಾಡಲು ಉದ್ದೇಶಿಸಿರುವ ಪ್ರದೇಶವು ಗ್ರಾಮ ಪಂಚಾಯತ್ ವ್ಯಾಪ್ತಿಗೆ ಬರುವುದರಿಂದ sawmill ಸ್ಥಳಾಂತರಕ್ಕೆ ಅರ್ಹ ಪ್ರದೇಶವಾಗಿರುತ್ತದೆ ಎಂಬ ಅಭಿಪ್ರಾಯದೊಂದಿಗೆ ಉಲ್ಲೇಖ 3 ಮತ್ತು 4 ಪತ್ರದಲ್ಲಿ ವರದಿ ಮಾಡಿರುತ್ತಾರೆ.
ಯಾರು?
This is by my lord respond number 3. Respond number 3, Deputy Conservative of Forest, Hassan Subdivision, Hassan, my lord.
Allala, this opinion
Yes, my lord.
was given by whom?
That is my lord, Deputy Conservative of Forest, Hassan Subdivision, Hassan.
No. This communication is made by the Deputy Conservator of Forest.
To the Chief Conservative of Forest.
This opinion,
Yes,
ಇವಾಗ ನೀವು ಓದಿದ್ರಲ್ಲ,
Yes, my lord.
that opinion was given by whom?
As per the reference number 3 and 4, my lord, it was conducted.
ಯಾರು?
That is my lord, Valaya Aranyadhikari, Beluru. Then my lord, Sahayaka Aranya Rakshanadhikari, Samrakshanadhikari.
Yes.
Then my lord, your lordship may kindly peruse running page number, my lord. 53 annexure P, my lord. Last, my lord. 53 ಸ್ವಾಮಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾ, my lord. ಮುಂದುವರಿದು ಶ್ರೀ ರಂಜಿತ್ MT ಬಿನ್ ತಿಮ್ಮೇಗೌಡ ಮತ್ತವರ ಗ್ರಾಮ ಚಿಕ್ಕಮಗಳೂರು ಇವರ ಮಾಲೀಕತ್ವದ ಮೆಜರ್ಸ್ ಕೈಲಾಶ್ ವುಡ್ ಇಂಡಸ್ಟ್ರಿ ನಂಬರ್ 21/5 ಗೊಟ್ಟೆಗೆರೆ ಬನ್ನೇರಘಟ್ಟ ರಸ್ತೆ ಬೆಂಗಳೂರು ಇಲ್ಲಿಂದ ಬೇಲೂರು ತಾಲೂಕು ಅರೇಹಳ್ಳಿ ಹೋಬಳಿ ಮರೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 28/1 30 ಗುಂಟೆ ಕೈಗಾರಿಕಾ ಉದ್ದೇಶಕ್ಕಾಗಿ ಇನ್ ಬ್ರಾಕೆಟ್ sawmill ಬ್ರಾಕೆಟ್ ಕ್ಲೋಸ್ ಭೂ ಪರಿವರ್ತನೆಯಾದ ಪ್ರದೇಶಕ್ಕೆ ಸ್ಥಳಾಂತರಿಸಲು ಸದರಿ ಪ್ರದೇಶದಿಂದ ಪ್ರಸಾದಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 40 ಪ್ರದೇಶವು ಪರಿಭಾವಿತ ಅರಣ್ಯ ಪ್ರದೇಶಕ್ಕೆ ಸೇರಿದ್ದು ಸದರಿ ಪ್ರದೇಶವು 9.90 ಕಿಲೋಮೀಟರ್ ಅಂತರದಲ್ಲಿ ಬರುತ್ತದೆ ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 38 and 39 ಬಾಣವರ ಗ್ರಾಮ ಚಿಕ್ಕಮಗಳೂರು ಪರಿಭಾವಿತ ಅರಣ್ಯ ಪ್ರದೇಶವು 2.90 ಕಿಲೋಮೀಟರ್ ಬರುತ್ತದೆ. ಇವೆರಡನ್ನು ಹೊರತುಪಡಿಸಿ ಬೇರೆ ಯಾವುದೇ ರಕ್ಷಿತ ಅರಣ್ಯ, ಮೀಸಲು ಅರಣ್ಯ, ಜಿಲ್ಲಾ ಅರಣ್ಯ ಪ್ರದೇಶಗಳು ಇಲ್ಲದೇ ಇರುವುದರಿಂದ sawmill ಸ್ಥಳಾಂತರಿಸಲು ಉಪ ಅರಣ್ಯ ಸಂರಕ್ಷಣಾಧಿಕಾರಿ ಪ್ರಾದೇಶಿಕ ವಿಭಾಗ ಹಾಸನ ಇವರು ಶಿಫಾರಸು ಮಾಡಿರುತ್ತಾರೆ. ಸದರಿ ವರದಿಯನ್ನು ಈ ಕಚೇರಿಯಿಂದ ಅನುಮೋದಿಸಿ sawmill ಸ್ಥಳಾಂತರಿಸಲು ಅನುಮತಿ ನೀಡುವ ಬಗ್ಗೆ ಪೂರ್ಣ ಕಡತ ಮತ್ತು ಲಕ್ತುಗಳನ್ನು ಈ ಪತ್ರಕ್ಕೆ ಲಗತ್ತಿಸಿ ತಮ್ಮ ಆಹ್ವಾನಕ್ಕೆ ಸಲ್ಲಿಸಿದೆ.
ಇದ್ರ 2.90 ಕಿಲೋಮೀಟರ್ಸ್ ಅಂತ ಅವರೇ ಹೇಳ್ತಾರಲ್ಲ ಇದ್ರಲ್ಲಿ.
That is my lord deemed forest ಪರಿಭಾವಿತ. That is my lord deemed forest ಅಂತ ವಿಲೇಜ್ ಅಲ್ಲಿ ಬರ್ತದ ಅಂತ ಹೇಳ್ತಾರೆ. ನಂದು ಕನ್ವರ್ಷನ್ ಆಗಿದ್ದು ಸ್ವಾಮಿ ಸಾಯಿಂಗ್ ಮಿಲ್ಲಿಂಗ್ ಮಾತ್ರ. sawmill purpose only, my lord. Provided that, my lord, section as per the section, my lord, I may permit to read, my lord. 163 subclause 2A, my lord. Provided further that the above. Sorry.
ಯಾವ್ದು ಇದು?
The Karnataka 1969. The Karnataka Forest Rules, my lord, 1969. My lord. 163.
Subclause 2A.
Subclause 2A.
Rules ಅಲ್ಲಿ ನೋಡಿ.
Two A, 163, 2A.
Karnataka Forest Rules.
Rules 1969, my lord.
69.
ಅದರಲ್ಲಿ 2A ಅಲ್ಲಿ provided other 2A ಅಲ್ಲಿ
ಯಾವ್ದು rule?
Rule 163. Subclause 2A. In that the proviso, my lord.
Proviso.
No person shall establish a sawmill or any other sawing contrivance other than those specified in Rule 2B, 6C and 163(1)
for
cutting or contravening
timber,
converting timber anywhere in the state without obtaining a license from the concerned license issuing authority, provided that no new sawmills or any other sawing contrivances shall be established within the limits of or within an aerial distance of 10 kilometers from the limits of any reserved forest, protected forest or district forest. This is what you are saying.
Yes.
There is no deemed forest, man.
There is no deemed forest.
But
Then, my lord,
the.
then, my lord, provided further.
Second proviso may also be
One-
read, my lord.
once
Ah.
Further
Second
that
proviso also says.
the provided
Provided further that the above restriction of the first proviso, aerial distance of 10 km shall not be applicable for establishing any
and-
running new sawmill within notified limits of any municipal or
area
and industrial
and
area.
industrial area. Now it is, my lord, converted for sawing mill purpose only, my lord, as per the conversion order.
Converted ಬೇರೆ, conversion ಬೇರೆ.
Conversion for the sawing mill only. ಯಾಕಂದ್ರೆ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಏರಿಯಾ ಇರ್ಲಿಲ್ಲ ನಮ್ಮ ಊರಲ್ಲಿ.
Provision says
ಇಡೀ
it
ತಾಲೂಕು
will not be applicable if it is within the municipal area
Municipal
and
area.
industrial.
and industrial area.
Area.
ಅದಕ್ಕೂ conversion ಗೂ ಸಂಬಂಧ ಇಲ್ಲ.
Please. ಇಲ್ಲಿ ಕನ್ವರ್ಷನ್ ಮಾಡುವಾಗ ಸಾಯಿಂಗ್ ಮಿಲ್ಲಿಂಗ್ ಅಂತಾನೆ ಕನ್ವರ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದಲ್ಲ.
Please, my lord.
The provision says
Please, my lord.
if it falls within the municipal area, this provision will not apply.
Right.
If it falls within industrial area, it will not apply.
Yes, my lord. Second,
So you cannot read in something which is not provided here.
yes,
Conversion ಆಗಿದೆ ಆದ್ರಿಂದ it falls under municipal area ಅಂತ ಹೇಳಕ್ ಬರಲ್ಲ.
ಇಲ್ಲ ಅನ್ನ
ಹಾ.
ಹೇಳ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. Then, my lord, this property is concerned, my lord.
ಹಾ.
Reserve forest ಅಲ್ಲೂ ಬಂದಿಲ್ಲ,
ಹಾ.
protect forest ಅಲ್ಲೂ ಬಂದಿಲ್ಲ,
ಹಾ.
district forest ಅಲ್ಲೂ ಬಂದಿಲ್ಲ.
This is what we will consider now.
Yes. No,
The
deemed
proviso
forest-
says
Yes.
if it falls within the prohibited distance of 10 kilometers
Yes.
from a reserved forest, protected
Yes.
forest
Yes.
or district forest.
Yes.
ಇದು ಮೂರು ತೋರಿಸಿದ್ದಾರೆ ಇಲ್ಲಿ.
Yes.
ಇವಾಗ ಅವರು
Once, my lord, once, my lord, forest is deemed to be a forest, deemed forest, my lord. It is a forest. It is protected forest.
then we'll have to go to,
Godavarman judgment is that, my lord, we cannot, once forest is a forest, my lord, that status cannot change. Deemed forest is also a protected forest. So it's covered by the judgment.
let us see.
And my lord may come,
My
kindly come to the
my
Google map,
ಅಲ್ಲ.
aerial, which has been taken, which clearly says that it is 9.9 kilometers and 2.19 kilometers.
9.9.
90.
That is okay. That is very, very marginal.
No,
ಈಗ
2.98.
2.9 ಇದೆಯಲ್ಲ
2.9.
ಅದನ್ನ let us see that. That is let us see that one. ಯಾವ್ದದು 2.9 kilometers.
2.9, Lord, may kindly see my annexures that I have produced, my lord, in my statement of
That is, my
objection.
lord,
The last
deemed
second-
forest, my lord.
ಹಾ?
Deemed forest 2.90. Paribhavita, running page number 53, my lord. 53.
No, that's not it, my lord. Here, my lord, the
Is there-
map, I have produced a map. Towards the end of the
Ah.
page number 22.
Ah.
ಆ map ಅಲ್ಲಿ, see, my lord, the orange line which goes on top, that is 2.9 kilometers
Paribhavita.
from the center.
ಅವರೇ ಹೇಳಿದ್ದಾರೆ
Towards the right, the blue line shows 9.9 km. That's one forest. Other forests are all at a distance. This particular forest is only is at a distance of 2.9 kilometers.
But that is deemed
The
forest.
orange,
ಅದು deemed forest, sir. ಅದು not a
deemed
protected
forest is a forest. It is it comes under protection.
No, no.
It is a protected forest.
And let us see what is this deemed forest. What is this deemed forest, sir?
My lord, may kindly
Because
come
that is
to
not
page
mentioned
number
in the,
9.
that is not mentioned in the provision.
No, deemed forest, no, that
What
is
is
a
mentioned
subsequent
is-
development.
Reserved forest,
Yes.
a district forest,
Protected forest.
protected forest. Deemed forest ಅಂತ mention ಆಗಿಲ್ಲ provision ಅಲ್ಲಿ.
My lord, may kindly come to page number 11, 9 in the statement of objections. That
Huh?
is the Karnataka Sarkaರದ ನಡುವಳಿಗಳು.
Page,
Page number 9 of my objection statement.
ಹಾ,
And my lord, can you take my lord to page 11? From page number 10, we can start off. Where it says the Honorable Supreme Court further ordered that each state shall constitute within 1 month an expert committee and so on. Now, my lord, the next page, second paragraph, my lord, can you see? The committee will verify, public review, the areas included as deemed forest in the report of revised expert committee 1. The total extent of deemed forest should be categorized into a statutory forests, into a statutory forest, recorded as forest in government records. Areas which are forests as per dictionary definition, based on field verification, as per the criteria and methodology approved at para 11 of the preamble. The committee also consider those areas not included in the revised expert committee report as deemed forest, but eligible for inclusion based on government records or approved field criteria. ಎಂದು ಆದೇಶಿಸಿರುತ್ತದೆ. So my lord, here the committee has included these. And the land which has been now shown, my lord, here. Anyway, there is no dispute. No, page number 17, my lord, of our. Page number 17. The list, my lord, which are included as as decided deemed forest, which have been brought under the committee report. Serial number 3637 and 3638, my lord. Okay, 1.9.
ಯಾವ ಯಾವ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಇದು?
ಇದು ಬೇಲೂರು.
Chikmagalur.
ಬೇಲೂರು ಸ್ವಾಮಿ. ಬೇಲೂರು, ಹಾಸನ್ ಬೇಲೂರು.
It's in between Chikmagalur and Hassan. We have also, my lord, produced a statement showing the details of deemed forests, my lord, which have been included in the committee.
ಅಲ್ಲ, see, the government order that you just read out now.
Yes.
Is a government order.
Yes.
Made for placing before the Honorable Supreme Court. Please see.
Well, it says ಆದೇಶಿಸಿರುತ್ತದೆ.
Please see the government order at page number 13. The operative portion. ಓದಿ. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದ
ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ
ನಿರ್ದಿಷ್ಟಪಡಿಸಿದ ಕ್ಷೇತ್ರೀಯ ಮಾನದಂಡಗಳನ್ವಯ ಜಿಲ್ಲಾ ಮಟ್ಟದ ಸಮಿತಿಗಳು ಗುರುತಿಸಿ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಲಾಗಿರುವ ಈ ಆದೇಶಕ್ಕೆ ಲಗತ್ತಿಸಿರುವ ಅನುಬಂಧದಲ್ಲಿನ 3,30,186.93 ಹೆಕ್ಟೇರ್ ಪ್ರದೇಶಗಳನ್ನು ಸಂರಕ್ಷಿಸಿ ಅಭಿವೃದ್ಧಿಗೊಳಿಸುವ ದೃಷ್ಟಿಯಿಂದ ಪರಿಭಾವಿತ ಅರಣ್ಯ ಪ್ರದೇಶಗಳು ಡೀಮ್ಡ್ ಫಾರೆಸ್ಟ್ ಎಂದು ಅಧಿಸೂಚಿಸಿ ಆದೇಶಿಸಿದೆ. ಇದರಲ್ಲಿ ಹಾಸನದಲ್ಲಿ ಯಾವ್ದು ಐಡೆಂಟಿಫೈ ಮಾಡಿದ್ರು ಡೀಮ್ಡ್ ಫಾರೆಸ್ಟ್ ಅಂದ್ಬಿಟ್ಟು, ಪ್ಲೀಸ್ ಗಿವ್ ದಿ ಇನ್ಫಾರ್ಮೇಶನ್.
The statement, my lord, is at page number 15.
No, along with this one.
Along with this one, that I will place it on record.
This is what was placed before the Honorable Supreme Court.
Yes.
I would like to see
Yes, I will
what
place
is it that was placed before the Honorable Supreme Court,
Yes,
saying this is the deemed forest in Hassan district.
yes,
ಅದನ್ನ ತಂದ್ಕೊಡಿ.
yes, my lord.
It should contain all the information. ಇವಾಗ ನೀವು ಇದ್ರಲ್ಲಿ ತೋರಿಸ್ತಾ ಇದ್ದೀರಲ್ಲ ಈ ಗೂಗಲ್ ಮ್ಯಾಪ್,
Yes, my lord.
we can't go by this one.
That is
We'll
because
have
of the
to-
aerial distance, my lord, calculate.
ಅಲ್ಲಲ್ಲ, ನೀವು ಇಲ್ಲಿ ಈ ಬಾರ್ಡರ್ ಅಲ್ಲಿ ಗ್ರೀನ್ ಮಾರ್ಕ್ ತೋರಿಸ್ತಾ ಇದೀರಲ್ಲ,
Yes,
that saying that is the deemed forest.
yes. This distance between the dim.
ಹಾ,
Yes,
ಇಲ್ಲಿ ನೀವೇನ್ ತೋರಿಸ್ತಾ ಇದೀರಾ ಮೇಲ್ಗಡೆ ಡೀಮ್ಡ್ ಫಾರೆಸ್ಟ್ ಅಂದ್ಬಿಟ್ಟು,
yes,
whether that is what was placed before the Honorable Supreme Court or not is what I want to
I will
verify.
place it on record.
So in terms of this government order, what was placed before the Honorable Supreme Court in respect of Hassan district,
Yes,
that information you will have to bring
Yes,
before
yes.
the court.
yes, my lord.
ಬರ್ಕೊಳ್ಳಿ. ಗೊತ್ತಾಯ್ತಲ್ಲ ಮಿಸ್ಟರ್ ಪವನ್ ಕುಮಾರ್, if they have placed the information before the Honorable Supreme Court that this is the deemed forest identified in Hassan district, then all of us are bound by it. Because they have already filed a submitted an affidavit before the Honorable Supreme Court.
Please.
And they will also be bound by it. So I want to see that information. In terms of the government order dated 5/5/2022 at annexure R1 filed along with the statement of objections, this court would like to verify as to what is the deemed forest in Hassan district, which was identified and placed before the Honorable Supreme Court. Full stop. A clear map in terms of the said government order dated so and so 5/5/2022 shall be placed before this court.
Yes.
Full stop. Release this matter on 21st of January.
Lord, I would like that. These 2 weeks
Pass
time,
it.
my lord, 27th or 28th. my lord.
Allala, this is already placed.
Lord, for me to.
It should be readily available with you.
Yes, my lord.
Tomorrow also you should get it.
Yes.
I don't think you should need 2 weeks for that. This is placed before the Honorable Supreme
Yeah,
Court in the year
I agree.
2022.
I agree. my lord.
That information I want to see.
Public.
Yes.
Last your matter, serial number 36, Naveen BM.
ಯಾಕಮ್ಮ ಎರಡೆರಡು ಸರಿ ಆರ್ಡರ್ ಮಾಡಿದೀವಿ, ಪ್ಲೇಸ್ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಅಲಾಂಗ್ ವಿತ್ ದಿಸ್ ಅಂದ್ಬಿಟ್ಟು, ವೈ ಆರ್ ಯು ನಾಟ್ ಪ್ಲೇಸಿಂಗ್ ಇಟ್? ಸೊ ಒಂದು ನೋಟ್ ಪುಟ್ ಅಪ್ ಮಾಡಬೇಕು ಕೆಳಗಡೆ ಫಾರ್ ಇಲ್ಲಿ ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಅಥವಾ ಇಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಒಂದು ನೋಟ್ ಹಾಕ್ಬೇಕು ನೀವು. ಫಾರ್ ದಿಸ್ ರೀಸನ್ ವಿ ಆರ್ ನಾಟ್ ಏಬಲ್ ಟು ಪ್ಲೇಸ್ ದಿ ಫೈಲ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಅಂತ ಹೇಳ್ಬೇಕಲ್ಲ, ನಮ್ಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತಿಲ್ಲ ಅಂದ್ರೆ. ನೋಡಿ ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದು ಎರಡನೇ ಸರಿ ರಿಪೀಟ್ ಮಾಡಿರೋದು ನಾವು. Release this matter on 15/1/2024 along with WP number 33927 of 2024. Ivaga, if you are not able to find this file because it is with another learned judge, you should put up a note. ಹಿಂಗಾಗಿದೆ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಫೈಲ್ ಅವ್ರ ಮುಂದೆ ಇದೆ, ಆದ್ರಿಂದ we are not able to put up ಅಂತ ನೀವು ಬರೀಬೇಕು. ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತಿಲ್ಲ ಅಂದ್ರೆ ನಮ್ಗೆ? Release this matter on 28th of January. ಇದೊಂದು ಕರ್ಬಿಡ್ರಿ, ಇದು ಇವ್ರದ್ದು ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ serial number 40.
14%, M. Ramaya.
ಯಾವ್ದಪ್ಪ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಾನ್ ಕಂಪ್ಲೈಂಟ್ ಯಾವ್ದು ನಾನ್ ಕಂಪ್ಲೈಂಟ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಯಾವುದು? ಹ್ಮ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಾಟ್ ಕಂಪ್ಲೈಂಟ್ ಅಂತ ಬರ್ತಾ ಇದೆಯಲ್ಲ, ಇಷ್ಟುನಾ 9? ಏನ್ರಿ 9 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ, ಹೋಗಿ ಕಂಪ್ಲೈಂಟ್ ಮಾಡ್ರಿ. ಮಾಡಿದೀನಿ ಅಂತ ಹೇಳ್ತೀರಾ, 9 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ನೋಡಿ. ಎಷ್ಟು ಸರಿ ಟೈಮ್ 12ನೇ ಸರಿ ಬರ್ತಾ ಇರೋದು ಮ್ಯಾಟ್ರ್. Finally, a week's time is granted at the request of the petitioner party in person for complaints of office objections. Release this matter on 22nd of January. Yes. Correct.
41, CM Nagabhushana.
My lords, I may be permitted to withdraw, my lords. I filed a memo for withdrawal.
Learned counsel, the petitioners and learned counsel for petitioners have filed a memo dated 8/1/2025 stating that the parties have amicably settled the matter out of court and the petitioners do not wish to prosecute the writ petition. Full stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition CRP stands dismissed as withdrawn. Yes.
The interim order will be continued, my lord. If I call tomorrow,
All matters which are not reached, there is no need to extend the interim orders.
please.
Yes.
And one more submission, my lord.
Courtmaster, what was the last matter that was heard?
Sir, next week, all matters.
79. Interim order.
Sir, ಎಲ್ಲ interim orders extend ಆಗಿರುತ್ತೆ.
Courtmaster, what's the next date
No
for
dates
item
will be given
51?
next week.
Sir, 77.
Next week. All matters.
Date make.
Huh?
Date fix ಮಾಡ್ಬಿಡಿ. ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಬಿಡಿ ಹೇಳಿ ಸರ್.
ನೋಡೋಣ. ಸರ್, ಯಾವ ಮ್ಯಾಟ್ರಿಗೂ ಡೇಟ್ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ ಸರ್. ಏನು ಮಾಡಕ್ಕಲ್ಲ, ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ಸ್ ತಗೊಬೇಕು ನೀವು ಯಾವಾಗ ಎಲ್ಲಿಂದ ಬರ್ಬೇಕಂದ್ರೆ ಹೇಳ್ಬೇಕು.
Courtmaster, what date for item 51?
ಯಾವಾಗ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ ಸರ್ ಎಲ್ಲ ಕಳ್ಸಿದೀವಿ ಸರ್.
ಸರ್
ಡೇಟ್ ಕೊಡಲ್ಲ ಸರ್, ಯಾವ್ದಕ್ಕೂ ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ ಮೇಡಮ್. ಯಾವ್ದೋ ಇನ್ಫ್ರಾಕ್ಚರ್ಸ್ ಆಗೋದಿಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ. ಇಂಟ್ರಿ ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಆಯ್ತು ಆಯ್ತು ಸರ್, ಆಯ್ತು, ಏನು ಚೇಂಜಸ್ ಆಗಿದೆ
ಸರ್.
ಹೋಗೋದು ನಾವು ಕಂಪ್ಲೇಂಟ್ಸ್ ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಾ, ಹೋಗುತ್ತೆ ಮಾಡ್ಬಿಡಿ
ಸರ್.
ಸರ್, ಯಾವ್ದಕ್ಕೂ ಡೇಟ್ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ ಹೇಳೋದಲ್ಲ. ಡೇಟ್ ಕೊಡ್ಬೇಕಂದ್ರೆ ಮ್ಯಾಟರ್
Courtmaster, what date for item 51?
City 5 and tender matter.
ಹೇಳಿದಾನೆ ಸರ್, ಅದನ್ನೇ ಮಾತಾಡಕ್.
ಸರ್
Item 51,
Once
what
again, I
is the
can't
next
repeat,
date?
dates cannot be given. Please
Okay.
don't ask the dates once again.
one request for CL number 60. Next week, any date, no problem. But like one submission on Wednesday, I may not be able to come because criminal matter is there for Wednesday, except Wednesday, any day. Sorry?
You just speak,
No, party in person. I'm party in person. Yes. No, like next week, any day, no problem.
you have to move the memo.
No. Next week it will be posted, na?
Next week tentatively it will be posted. We can't assure.
So like the matter is on